Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today as we are setting our sights on a new trial out of New Jersey. So this one is Paul Caneiro. This case is about brothers. Let me just make sure. Welcome to Trial TV Live. All right, audio is good. This one is a very, very interesting case. It's been going on since 2018. And jury selection is set to begin today. We're not sure how long jury selection will be, but for today, we are going to be doing a deep dive into this trial. So, Squid Kid, Sparkling Princess, good morning to you. Pammy, Sassy, good to see you guys. Hellrider, you're back in Florida. Awesome. Sounds good. Will Johnson, Iowa, good to see you. Can't wait for the background story. It's an interesting one, you guys. Very interesting. Lily Wayne, yep, just read the description. Lots happening, and an incredible tragedy for sure. Red Snap, good to see you. Fire Girl, Handmade by Wendy, thank you for joining us. Let's see, Crazy Mary Joe, I know you were, oh, no, Sharon, you were first in chat. Good to see you. Thank you for joining us. Mike, Christine, good to see you. Teresa, hello, hello. Amy Lee, good morning to you. Mama Nine, Brenda, Tammy, Selena, good morning, welcome in. Brett, Allie B, good to see you guys. Allison, Debbie, Shirley, finally, after 24 hours, no internet service because a truck drove into a pole. Wow. You know, I had a family member that a snowplow ran into their pole. They were without internet service as well. Green-eyed Cat, good morning to you. Deviant, good to see you. All right, Mary, thank you for joining us. All righty, Jenny Lynn, good morning to you. Let's see. All right. Crystal, good to see you. Melissa and Seagate, good morning, good morning. All right, you guys, let's get to it. This one is very messed up. Very, very messed up because it's brother and brother. All right. So the incident takes place November 20th of 2018. Paul Caneiro is the defendant, and it's alleged that he took out his brother Keith, Keith's wife Jennifer, and their two children, Jesse and Sophia, ages 11 and 8. Now, there were three 911 calls on November 20th. The first one was around 3 to 3:15, and it was a neighbor calling 911 to say, "Hey, are you allowed to hunt at 3 o'clock in the morning? I just heard 5 shots, pop, 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 and then another pop." And the 911 operator said, "No, you're not allowed to hunt anywhere at night." So officers were dispatched, and nothing was found. Then around 5:30 or 6, 911 got a call from Paul saying his house was on fire. So first responders show up, fire department shows up, everybody's fine. Although I've heard that a turtle did pass away. Unfortunately, their pet turtle died. But the fire was put out. Then about 5 or 6 hours later, around 12:30, there's another call to 911, and it's Keith and Jennifer's house that's on fire. And that was called in from the yard worker. And he says there's a dead body in the backyard. So first responders show up, and it's Keith. Keith has been shot 4 times in the back of the head and then once in the back. And then they go in and they find Jennifer, Jesse, and Sophia. Now they had been stabbed, and unfortunately, the autopsy showed that they had also succumbed to smoke inhalation. So they were still alive while the house was just smoldering and smoldering and smoldering. So Paul is being charged with first degree on all 4 counts, aggravated arson because he theoretically set 2 fires, unlawful possession of a firearm because Keith was shot 5 times, unlawful possession of a knife because Jennifer, Jesse, and Sophia were stabbed, and then insurance fraud. So this is all based, and this goes back to Keith is the middle child, right? So there's 3 brothers. So Paul's the oldest, Keith is the middle one, then there's a younger brother, Corey. Now they were born in Brooklyn, but I believe they were raised in Staten Island. And then Keith was really into computers. So he took a job at a computer store for free, and then he eventually created his own company called Square One, and then this was in Brooklyn. And then he got so busy that he had to have his brother Paul come in as a partner, and it wasn't a 50-50, but it was I don't know what the split was, but Keith was the majority owner. Then they got a bid, or they won a bid from Citibank, right? So they were making like millions and millions of dollars. So then Keith and Paul decided to form a pest company, and that one was called Eco. I can't remember the name right now. Anyway, so they formed a pet service company, and they were 50-50. So Keith had set up a trust account for his kids, Jesse and Sophia, and Paul was running the books, basically. And Keith and Jennifer they figured out that there was money that was missing. And it was also around this time that Paul got in a car accident, so he has a limp. So when you see him come into court, you'll see him with a limp. And so he was collecting disability, but he was also making like $225,000 a year. So his wife continued to make that money while he was collecting disability. So right there, he's frauding disability. So he was in charge of the books and he was stealing money. And Keith and Jennifer finally kind of caught on, and they're like, "Hey, wait a minute, we're gonna just pause everything while we figure out what the heck is going on." And unfortunately, while they were paused and they were figuring out what the heck was going on, they were deleted along with their kids. So right now, law enforcement is alleging that it was Paul that did this. So we'll have to wait and see how it all plays out. So on November 20th, 2018, 4 members of the Caneiro family were found deleted inside their Colts Neck, New Jersey home, which was intentionally set on fire. The victims were Keith, 50, his wife Jennifer, 45, and their 2 children, Jesse, 11, and Sophia, 8. Earlier that same morning, a separate fire was set by Paul Caneiro's own residence. Detailed prosecutors allege was a deliberate diversion meant to mislead investigators. Now, he's not out on bail. He's still in jail. He's been in jail since 2018. And a lot of that reason, there's a couple reasons. Actually, there's 3. He's changed from a private lawyer, private lawyer to public. So that's one reason. Then we had COVID happen. So that's another reason. And then there's DNA testing. Technology has changed, and the prosecution is using this new technology. And Paul's defense needed time to figure out and find experts of their own. So there's 3 reasons why it's been delayed since 2018. Now, if he is convicted, Paul faces life in prison without the possibility of parole, with additional sentencing related to the arson, weapons, and fraud. So if he is convicted, he's going to go away for a very long time. Now, here's another thing I want to show. Let's see here. All right, so here is, let me take myself off camera here. All right, so it's Square One and EcoStar. So Square One is the, thank you, Aaron. So Square One is his, the technology company, computer-based company that he formed, that Keith formed, and then he brought Paul on as a limited partner, and then they both formed EcoStar. All right, so here is the map. All right, so Keith's house, 15 Willowbrook Road. This is in Monmouth, New Jersey, and then Paul's house. So it's only about 20 minutes, 12 miles, 12, 13 miles, and it's only about 20 minutes. Now, I also want to come over here and show you, let's get over here. Let's get over here. All right, so for those that are not familiar with the area, this is where we're talking about. So this is New Jersey. All right, so here's New York City up here. We all pretty much know where New York City is. There's New Jersey, and this is on the east coast of the United States. So just to kind of get your bearings, there's the east coast of the United States, and there's New York, and then here's Long Beach. I have personally been to Long Beach. It's a very well-to-do section of the beach along New Jersey. And this area is exceptionally well-to-do. So let's see. So this is where, let's see. All right, so that's Tilton. All right, so that is that's where Keith. I'm sorry, that's where Paul lives, and then Keith was about 15 minutes away, 20 minutes away. So anyway, so that kind of gives you the idea of where we're going to be spending in the foreseeable future. So, hey, Dream Horse, good morning to you. Let's see, Allison, good morning. Melissa, yes, yeah, and here's the thing, that was their uncle that did this allegedly, right? So this is his niece and his nephew, right? And you know, I don't know how you guys are with your family, but you know, family is obviously very important to a lot of people, and they weren't just stabbed once or twice; they were stabbed repeatedly, and then of course the brother is shot like 4 times in the back of the head, and then once in the back. So, Lori, good morning to you. Hector's mom, unlawful possession of a knife. Well, because they were stabbed. It was used as a weapon. So we have seen that before. Hey, Edward, good morning to you. Jennifer King, good to see you. Lacey, happy New Year to you. Brett, I know siblings don't always get along, but the allegations take sibling rivalry to new extremes. That is absolutely true. All right, Richard, good morning to you. Nana, Angel, good morning. All right. Yes, upcoming live trial. Iowa Backyard says we are doing background while jury is being selected. Miss Lola, this rocked the community. A loving family who did not deserve this. Totally agree with you. Are you in the area? Let me know if you guys are in the area. Anybody that's in the area, let me know. Sweet Vampy, you would never harm your family ever. Willow Johnson, some angry issues for sure. Yeah, let me know if you guys are in this area. Having spent time in New York City, and I'm more familiar with central and northern New Jersey. South Jersey, I'm not so familiar with. Like I said, I did go to Long Beach. There's Long Beach right there. So there's Long Beach right there, and then this happened pretty close, right? So it's pretty close to Long Beach Island. So, all right. Green-eyed cat, this is your last Monday at your job. I'm really sad it's coming to an end. Oh, I'm sorry. Sorry, green-eyed cat. Miss Lola, you're only 20 minutes away. Okay. Very affluent community. Absolutely. Yeah, that's by all accounts, that's what I'm hearing too. And remembering. Terry, good morning to you. Sweet Vampy, even mentally or emotionally, I love my family way too much. Sounds like sibling unalivery. Exactly. All right, so let's get to it. We have a long day. We have about 11 hours ahead of us. So we're going to play news clips first. You guys know the deal. We do our news clips first, and then we're going to, we have a couple hearings. We have press conference of arrests and all that good stuff. So let's get to it. Let me just switch this out. So appreciate you guys joining. And for those that were...
The eve of the quintessential...
For those that were tuning in to watch the Sarah Grace Patrick trial, we are still interested in that, but that may get... there was a neuropsychologist that was supposed to provide a report right after Christmas. So it was supposed to be trial selection, jury selection today. The jury selection was to be today, but it's still kind of up in the air whether that's going to start today. So we saw that this was jury selection is going to start for this today. So we're hoping that a jury will be seated within the next day or two, so we can pick up on this. All right, so we're going to get to the news first.
Family holiday, a family murder mystery and tragedy unfolding in New Jersey tonight. That huge arson fire at a mansion in Monmouth County yesterday. Turns out the man found outside was shot and killed, and his wife and 2 young children found inside were stabbed before that fire started. No charges have been filed in those killings, but the man's brother, who was also his business partner, is now arrested for setting his own house on fire a few miles away with his family inside. The question tonight, are these 2 crimes linked, and how and why? New Jersey reporter Tony Yates is live in the town of Colts Neck with the very latest on the investigation. Tony.
Yes, Liz, and where a vigil just wrapped up, and surely during grace over Thanksgiving, many families here in Colts Neck will remember the Caneiros and their 2 young children who were friends and classmates with many of the kids who came out to this vigil tonight. The last minutes in the lives of 45-year-old Jennifer Caneiro and her children, 11-year-old Jesse and 8-year-old Sophia, were horrific.
And to date, our investigation has revealed that, unfortunately, sadly, each of these individuals were the victims of homicidal violence at some point prior to when the fire was set.
Keith Caneiro was shot several times outside his home, and entire family wiped out. Their mansion in affluent Colts Neck set on fire.
Our Father, who art in heaven, hallowed be thy name.
Hundreds of their friends and neighbors came together to remember the family. The Caneiro children's sports coach.
Something like this, it doesn't affect one family here. This affects everybody, from the kids that go to school or parents that knew him.
So many questions remain, with one person behind bars and police looking for no one else. Paul Caneiro was Keith's brother and business partner. He's under arrest only for the arson at his Ocean Township home that happened hours before the Caneiro's mansion went up in flames.
We announced that our office charged Paul J. Caneiro, 52-year-old of Ocean Township, with aggravated arson in the early morning hours of today.
The mansion was burned so badly, engineers must make sure investigators can go in to do their work to determine who killed the family and why. The prosecutor stopped short of calling Paul a suspect so far.
I can't confirm or deny whether he's a suspect. The only thing I can tell you is we are exploring the possibility that these 2 incidents are linked, like we mentioned yesterday.
And again, Paul Caneiro will make his first court appearance on November 28th. He is right now only charged with the aggravated arson at his own home, and the Monmouth County Prosecutor's Office told us today that his investigators will be working through this holiday to come up with more evidence.
All right, so just a few more facts. So this area, Bruce Springsteen lives there, Jon Stewart, and Queen Latifah. So that just kind of gives you the level of, it's only about, a half hour, maybe an hour outside of New York City. So again, Bruce Springsteen, Queen Latifah, and Jon Stewart all live in this area. So very well-to-do. Things like this don't happen here, so it's one of those situations of like quiet neighborhood, what the heck's going on, So again, so Keith's house is 15 Willowbrook Road, and then Paul's house is 27 Tilton Drive. So that's just and there's Colts Neck there. You can see that just sort of gives you an idea of where this is, and a lot of horses. Obviously, Jersey is known for their horses and their gardens. It is the Garden State after all, their flowers. But this particular area houses a lot of people that are horse owners and or have stake in horses. So let us continue on. That is the initial news, and then we're going to hear. Let's see here. We'll continue on with some more news.
In the aftermath of a mysterious...
Okay. I'm going to get to the press conference. I'm going to get to the press conference instead. All right, so I have two press conferences.
All right, so
All right.
Good morning or good afternoon, ladies and gentlemen. Before I begin, I want to say thank you to the gentlemen that have joined me up here today. I'm joined by Sheriff Sean Golden of Monmouth County Sheriff's Office, by my Chief of Detectives John McCabe of the Prosecutor's Office. Behind me is Acting Chief Frank Lassess from the Colts Neck Police Department. We have my Deputy Chief of Detectives Doug Johnson, the Chief of the Ocean Township Police Department Steve Peters, and my Director of the Major Crimes Bureau Chris Decker. So we wanted to give you an update on where things stand on the two arson investigations that are occurring here in Monmouth County. Before I do that, I want to give a great shout out, great credit and gratitude to the fire departments in Ocean Township and Colts Neck and the 20-plus departments that played a role in extinguishing these fires, particularly the one in Colts Neck, which, as you know from yesterday's press conference that we held, was burning well into the evening hours. I'm happy to say that that fire has been extinguished at 15 Willowbrook, and I just want to say on behalf of the entire law enforcement community that we are grateful for all of the fire department's assistance in investigating this matter, but most importantly, getting those fires put out so we can take a deep dive into this investigation. Regretfully, today, I can identify 2 of the 4 bodies that were recovered from the Colts Neck residence, and those are Keith and Jennifer Caneiro, both of which owned and resided that home at 15 Willowbrook in Colts Neck. And today we can tentatively identify the other 2 remains as those of the Caneiro children. The reason why I can't conclusively identify them at this point is because the medical examiner's office continues to do their forensic examination, and because of the condition that 3 of the 4 bodies that were recovered from that home were in because of the fire, that is complicating matters. We expect that that information will be confirmed by the medical examiner's office at some point before the end of the day today. The Monmouth County Prosecutor's Office, the Colts Neck Police Department are investigating the Colts Neck matter as a multiple homicide and arson case. Yesterday we specified just arson. The case has transcended into a multiple homicide investigation in addition to the arson matter. And to date, our investigation has revealed that, unfortunately, sadly, each of these individuals were the victims of homicidal violence at some point prior to when the fire was set at 15 Willowbrook. As I mentioned yesterday, 3 of the 4 remains were severely burned, and I told you that's complicated matters, but that is not going to prevent us from doing our jobs, because those 2 crime scenes have and will continue to remain secured until the completion of our investigation. I know there's been a lot of speculation about gunshot wounds with some or all of those victims in that home. I can confirm that Keith Caneiro, whose remains were found in front of the home, was shot, but I can't go any further than that at this point in time. Remember, the cause and manner of death are going to be the part and parcel of the findings that come from the medical examiner's office, and it would be premature to even discuss or speculate that until that investigation is complete. As I stand here today, we continue to work with county engineers on making sure that we can safely access the residents in Colts Neck so we can continue our forensic examination. But again, that scene remains secured with law enforcement ensuring that there's no issues with the integrity of that crime scene, so that will likely go on over the next several days. We have enlisted the support of a number of law enforcement agencies, some of which I've mentioned here, but I'd like to add a few others to that list. That includes the New Jersey State Police, the Federal Bureau of Investigation, the Bureau of Alcohol, Tobacco, and Firearms, the New Jersey Regional Computer Forensics Laboratory, and a host of other municipal police departments that work shoulder to shoulder with these chiefs in the county that are willing to share their efforts and assistance in this investigation. Now I want to change gears and I want to talk about the arson that occurred in Ocean Township on 27 Tilton Drive. We announced that our office charged Paul J. Caneiro, 52-year-old of Ocean Township, with aggravated arson in the early morning hours of today. That defendant's first court appearance will be held on Wednesday, November 28th, 2018. Time and courtroom will follow, but on that date he'll have not only his initial appearance, but a detention review hearing before the court. Now, as many of you might be familiar with, aggravated arson is a second-degree crime. It carries 5 to 10 years imprisonment, and the allegations by the state with this particular aggravated arson are captured in the affidavit that accompanies the criminal complaint that was filed earlier today, which all of you should have access to. A couple additional points before I try to answer any questions you might have. I really want to convey my thanks and gratitude to my staff that's working on this investigation, as well as all of the members of the law enforcement community that continue to work on these investigations as I speak with you here today. They're going to keep working tirelessly on this case to deliver justice to these 4 victims, and many of them will not be able to celebrate the holidays, the Thanksgiving holidays, with their families. But I have to say I'm quite honored and privileged to work with all of them, these people that take their oaths and their dedication to their job so seriously. So I'd like to commend all of them that are working on this. And thank you, gentlemen, for your team's roles in working this case. Finally, the last thing I'd like to say is to the members of the Colts Neck community. We in law enforcement know Colts Neck to be a quiet, safe, and close, tight-knit community. I am sure that you're feeling the reverberations and the traumatic and emotional effects of the loss of the Caneiro family, and our hearts in law enforcement go out to you. In that same vein, if anyone has any information about that arson and homicide investigation or the one in Ocean Township, I really encourage you to call us in Monmouth County Law Enforcement. With respect to the one in Colts Neck, you can call Detective Pat Petrozello at 800-733-7443. He's a detective with the prosecutor's office. Or Colts Neck Police Detective Zarullo, which a number I will provide. For the Ocean arson investigation, please call Detective Brian Weisbrot of the Monmouth County Prosecutor's Office at the same number I've just given, 800-733-7443, or Ocean Township Detective Chris Brady at 732-531-1800. So with that, I'll try to answer any questions you might have. Just bear with us because this is an ever-evolving investigation. Yes, sir.
Ron,
how are you?
The question is why? Why would this suspect allegedly kill his members of his family?
We're working on that. This happened less than 24 hours ago. Well, we discovered this around 12:30, so it's a little bit over 24 hours. That is something that, of course, we want to answer in any of our investigations. What you're getting at is motive. But I would just caution you to let's crawl before we walk. We have a great team assigned to this. If there is information to release to the public as to motive, I would encourage you to come to the detention review hearing, and if there is information at that point to disclose from the state, it'll be done at that point.
You know, there's been any threats against the family?
None that I'm aware of. None that I'm aware of. Yes,
Is
sir.
Paul Caneiro a suspect in these murders?
I can't confirm or deny that at this point in time. I can only focus on Paul Caneiro as a defendant in the Ocean Township aggravated arson that's charged. I mentioned yesterday that one of several avenues that we're considering is whether these 2 arsons, and by virtue of the investigation how it's involved, whether the arson and the homicide is linked. But I cannot commit to that. I can't confirm or deny it.
It'd be a heck of a coincidence, would it not, sir?
I can't comment on it. I'm sorry.
Where in the house were the bodies actually discovered? Either way, bedrooms, living room, basement?
I'm not going to get into that. I'll only say that Mr. Caneiro was found outside the front of the home, and the other 3 remains, the wife and the 2 children, were found inside the home.
Were the
Yes, ma'am.
Where was Paul Caneiro picked up, arrested?
I'm not going to comment on that either. I'm so sorry. Yes, ma'am.
You mentioned yesterday that the surrounding communities did not need to be on alert or high alert. Why did you say that?
Because we believe that in some form or fashion that this family was targeted. If there was an open threat to the community, if this was random violence where we felt like there was a gunman or somebody who could present a risk to the community, the first thing we would do is put that information out to the public at large. And the second thing we would do is ensure a heavy police presence in areas where we thought there was a concern. But I'm here to tell you at this point in time, I have no reason to believe that's the case. I do believe that this was a targeted situation with the Caneiro family. We're still developing that. I can't go any further. But if there's changes to that, we'll certainly let you know.
Chris.
Yes, ma'am.
Without stepping on the
toes of the medical examiner's investigation. What can you give us in terms of details about the homicidal violence that you said? Were the children and Jennifer Caneiro stabbed? Were they beaten? Was there any blunt force trauma?
The only thing I can give you is what I've just disclosed earlier, and we are confirming that there were gunshot wounds that were sustained by Keith Caneiro. Yes, ma'am.
Of the time the homicides occurred.
No, I can't comment on that, Kathy. I'm sorry, I can't even come close to getting to that. Yes, sir.
Is Keith considered a murder victim, or is there any possibility he may have had a self-inflicted gunshot wound?
Our investigation, we're operating on the presumption that these were all victims of homicide. We have no reason to believe at this point that there was a suicide angle. I know that was some of the earlier reports that came out. At this point in time, we don't believe that's the case.
Prosecutor, can you give us a timeline starting from, I believe, the fire at Paul Caneiro's home? Is that the first alarm? Give us a timeline, please.
We received the call at the Ocean Township residence for a call of a fire of roughly 8 a.m. in the morning. I say we're talking about dispatch received the call. With respect to the fire in Colts Neck, there was a call made to county dispatch at the sheriff's office around 12:38. It was a local person, a landscaper or otherwise, that made the call, and as a result there was a response there. As far as timeline goes, that's the best I can do for you at this point in time.
Chris. Are there any indications there were financial problems in the Caneiro family?
Still exploring that among several other aspects and avenues, but I couldn't get into it because it would be potentially evidentiary. And I don't mean to be obstructionist with you all. You have to understand that there's going to be a possible prosecution that ensues here, so every time I go too far, I run the risk of tainting a possible jury pool. So
Were they business partners? Without saying, do you think you have a good idea of why this happened?
I don't get in my business. I said yesterday, it's a bad practice to speculate. I'm going to let the experts that stand behind me and the investigators out there as we speak do their thing before I get too far. Yes, sir.
Were the two brothers business partners?
I'm sorry?
Were the two brothers business partners?
It's my understanding. Yes, I believe they were. And there was a business out of Asbury Park that they ran. It had something to do with technology and possibly pest control.
How did the fire stop at Paul's house, at the Ocean Township house?
Stop?
Yes.
That was extinguished by local fire departments that responded.
Do you know you said that he set the fire. Paul set the fire. His wife and children were inside the house when the fire was set? Is that correct?
Just a point of clarification. I said that the state has alleged that he has started the fire at his home. That's why he's charged with aggravated arson. I mean, it's obviously a determination a jury would have to make one day. But our allegations are everything we're going to mention with respect to that are captured in the complaint and affidavit, and by virtue of the fact that he's charged with second degree, we allege that there was a possible risk to family members as a result of his possibly starting that fire.
Do you know when
Yes,
the
Brian.
Caneiro family was murdered?
One, a neighbor said that the children did not go to school in the morning. Do we know what time they were killed?
No.
The murders happened in this house.
Not at this point. We're still exploring that. Remember, I mentioned earlier, Brian, that the scene hasn't been rendered safe for forensic investigators to go really in there and take the deep dive that we normally would. Once county engineers release that scene, we'll be able to go in there. We'll be able to do a more thorough arson investigation. And once we do that, questions like when we allege that the accelerant was poured, if there was one, when the fire might have started, will hopefully come into clearer picture. But at this point, we have the scene detained and secured. We're just waiting for the okay, so it's safe for investigators to be able to go in and explore that further.
Okay, the other question, Chris, I had, under what conditions, what time, was there resistance that Mr. Caneiro, Paul Caneiro, was arrested or detained yesterday or overnight, or can you say where this happened?
I'm not going to say where, but I have no reason to believe that there was any resistance to the arrest at this point.
Can you clarify the time frame on the fire? Because it was originally reported that it was at 5:30 in the morning that Paul's house.
In Ocean Township?
Yes.
Okay. Chief Peters is confirming that's right. He would know better than me, so let's correct the record and make it 5:30 instead of 8.
5:01 a.m.
Yeah.
5:00. Okay, so not 8 o'clock.
Yes, I was wrong. My apologies.
You
Yeah.
call 911. There's any mob involvement in this, and why? What leads you to say that the family was targeted?
I'm not going to comment any further on what I have. I just know it's an active and ongoing investigation. Yes, sir.
Why is the FBI working on this case?
Because, you know, we work all in a team atmosphere, and this is obviously a big deal, a quadruple homicide. Don't read anything unnecessary into that. Like Monmouth, I will pride this county. We pride ourselves on working well in a team environment, and that just doesn't include local and county or state investigators, but it also includes our federal law enforcement partners.
So why did the fire take so long to actually put out? Was it a typical fire for that, or were you guys trying to preserve the scene for forensics?
Now, that's a tough question. I'd probably reserve that for the fire professionals, but you know, I realize out there that it was a pretty substantial fire. I saw it myself. There was some stories about the possibility of water shortage. Let me rule that out. The departments did a fabulous job by virtue of the fact that they extinguished it. But hey, I'm not an expert on fires. Sometimes they get put out quickly, sometimes they take a little while. Those guys did a great job.
Do you yet know how it started?
No, like I was saying, we're still trying to get inside there.
Do you know
Yes.
if Keith ran the tech company and Paul ran the pest control company?
The names and ages is 11-year-old Jesse and 8-year-old Sophia. Jesse, and Sophia is common spelling, Sophia. 8.
Jesse is one?
Yes.
Were there conversations between law enforcement and Paul Caneiro, maybe even at the scene of the Ocean Township fire, and then later on in these cases?
Look, it's a fair question, but you know I couldn't touch that with a 10-foot pole. That would go to possible evidentiary matters. I'm not confirming or denying it. It's just something I can't disclose to the public.
Okay,
Yes, sir.
I'm a little confused, but I'm not that bright. But so
that makes two of us.
Paul's been arrested on an arson charge. You say the family was targeted. So are you actively seeking the suspects who killed his family? And I guess it gets back to the same question: is Paul a suspect in these murders?
Look, again, I'm not trying to pull punches or dance around you. It's just a question that I can't answer at this point in time. I can't confirm or deny whether he's a suspect. The only thing I can tell you is we are exploring the possibility that these two incidents are linked, like we mentioned yesterday.
Is Paul in jail? Has bail been set? Is Paul in jail?
Paul is detained pending his initial appearance at the Monmouth County Correctional Institute. So on Wednesday the 28th, he'll have an initial appearance and a detention review hearing where a judge will determine whether that detention will carry over. In other words, whether he'll be remanded or released on some type of conditions.
No bail set?
Not at this point. That's something that possibly would happen on Wednesday the 28th of November. Depends on what the defense attorney wants to do.
So should the public worry that there's a quadruple killer out there right now?
No. If that was the case, then you'd hear it from all of us up here, that we would be sharing our concerns with the public. But I have no reason to believe that's the case, and I really hope that none of you get carried away in that regard, because I don't want to create a public scare when it's not necessary.
What's the hold-up on charging him with the homicides and more, other than the aggravated arson at his house?
Because, we can't charge people unless we have evidence. I told you that the scene is secured, but we can't even send largely our investigators and forensic examiners in there to look at the scene because we're waiting for county engineers to release it, to be able to tell us it's safe, the roof's not going to cave in on you, the floor's not going to cave into the basement. Bear in mind, it was a pretty substantial fire, and we do have to ensure that there's safety to the investigators.
Timeline here. At 5:01, the Ocean fire was called in. Is that correct?
Yes, that's right.
And it was called in by Paul?
I can't confirm that right now, but it would be on record.
And then 12:38, a fire is called in by the landscaper.
By somebody who was working in the community. As I understand it, it was a landscaper, and then there was a big response from there.
And Paul's family, wife and 2 grown children, were able to escape the first fire. Is that correct?
Yes.
And are they in custody? Are they witnesses? What is their status?
I'm not going to comment on their status. The only status that I'm able ethically and legally to comment on would be the defendant who's charged with aggravated arson.
When do you think you'll get into the house?
Sorry?
Do you have any suspect in the quadruple homicide?
Again, I'm not suspect, person of interest. We are looking at all angles, but I'm not in a position to be able to make those disclosures at this point in time. It would be irresponsible of me to do so.
Well, how can you assure the public there isn't someone out there who's a quadruple killer?
Because I did 3 questions ago.
When will you be able to get into the house? When will engineers clear the house? Do you anticipate getting in there?
I'm hopeful that that'll come in the coming hours, and then investigative teams will be working on that place over the next 48, 72 hours or whatever it takes.
So will Paul be charged? If you find evidence, could he be charged?
You couldn't conclusively identify the children, but you gave their names and ages, so Are you identifying the two
No.
children dead as?
We are tentatively identifying them based on our investigation to date. But when it comes to positive identification and confirmation, that usually that will most often follow with a medical examination's completion of their report. The reality is, I understand the circumstances as we sit here today, and it's I'm trying to share as much as I can with you, but also reserve the fact that conclusive or positive identification is reserved for the medical examiners. So it's a tentative ID at this point in time. We have no reason to believe it's anyone other than those two children.
What was the condition of the mother and the two children's bodies, and how long will it take the ME to determine the exact cause of death?
Well, like I mentioned yesterday, because they were exposed to a fire, their remains were severely burned. The question about how long it'll take the medical examiner's office, I don't know, but I know that the Middlesex County Medical Examiner's Office has deployed multiple people to work on this, and I obviously can understand that it's a priority for them just like it is for us.
Can you talk a little bit more about the evidence that you had to charge this morning about the video?
I'll defer to things that you've seen in the criminal complaint and the affidavit. That's as far as I can go, which is what's in the current public record, but anything beyond that, I'm not allowed to publicly disclose. Art?
Yeah, Kristen, can you rule out, or are you investigating the possibility that the Colts Neck murders occurred before the Ocean Township fire?
That's a possibility. We're not ruling out any possibilities. It could be that's the case, it could be not. That's something that we're going to be working on. But remember, and nobody wants to get in there and solve this and investigate this more than me and the people up here in our teams. But we have to make sure that Colts Neck scene is clear before we can conduct a much more thorough investigation that we've done. And remember, sorry, go ahead. Yes, ma'am.
Do you have any information on the type of weapon that was used to kill Keith Caneiro?
No, not at this point in time that I can publicly disclose.
Was there a pet in the house in Colts Neck?
Not that I know of.
Was there a housekeeper also? I understand that there was somebody living in that house, a fifth person.
There were concerns that there might have been a housekeeper in there, but we have since established that she is alive and well, so no issues there.
Can she provide information? Was she there at the time? Is she helping you in the investigation?
I can only tell you that if we were going to swear you in.
Did you
Sorry.
find any guns at Paul's house? Are they legal? Were they purchased legally?
I have no comment on that. You know, we're undertaking a number of investigative techniques in addition to some of the general ones I've outlined. The only thing I can encourage you to do is just stay tuned. We will continue to share information transparently like we've done here. I'll take two more and then we have to get back to it.
This is a prolific scene. Can you describe where the bodies were found in the house?
Well, I think a lady over here asked that earlier. The only thing I can comment on is that the two children and the wife were found inside the home, and the husband, Keith, was found outside the front of the home. That's the furthest I can go.
Other cases you've had to deal with.
There were reports that a homicidal incident, the children and the wife were stabbed. Can you confirm that?
No, I can't confirm or deny or even comment on anything further. The only thing I've disclosed earlier is that we are putting out that at this point in time our investigation has revealed that all four of them were the victim of homicidal violence prior to when the fire was set at that home. Kathy,
Would Paul be considered a person of interest given that his family still survived and there were other people who came from the home, and I'm guessing maybe some ballistics are on the way. You can't call him a person of interest at this point?
No, I can't. It's not prudent of me to declare suspects persons of interest. The only time we get into that business is really in two reasons. If there's somebody who's a defendant, like we've discussed with respect to the Ocean Township arson, or if we're seeking the public's assistance on somebody that requires, that might need notification in the public's eye. I really can't go any further. Kathy, last question. What'd you have?
How does this find compared to some of the other two officers had to deal with?
This is I can speak for these gentlemen up here in the entire Monmouth community that this is one of the most heinous cases that I think they have ever investigated, that we have ever seen, and you know, there's no shortage of that, unfortunately, in our history here. But I'm encouraged at the same time that we really do have dedicated, outstanding detectives and investigators that in their hearts they'll solve this. I mentioned earlier they want to give justice to the Caneiro family. That sometimes that term is thrown around pretty commonly in trite fashion, but we really mean it. And we really hope that we can solve this. So to that end, anybody that can help in any regard, any leads, even if it's an indirect something or other, please contact us in law enforcement. Any little piece of the puzzle might make a difference. If you're not comfortable communicating with law enforcement, the Monmouth County Crime Stoppers is a 501c3 charity that takes information, tips or otherwise, in completely anonymous fashion, in some cases for reward. And we don't work with them, they don't share identity or anything, but they will share tips with us. And I'm sure they're going to be plugged in on trying to help us with this one. So with that, ladies and gentlemen, I appreciate your patience with us. Just stay tuned. If there are further updates, we'll either put them out by social media or through our public affairs offices. Follow us on Twitter and Facebook. Thank you all for your
Is there a
patience.
mugshot, sir? There's one in Asbury Park Press. Was that from today's arrest?
It's on their Twitter feed.
Yes.
Oh, it's on.
Yes.
Do you know what the relationship was between the families at the time?
This is a mugshot. Let me just clarify.
Yes.
We don't release mugshots. When we release a picture of somebody who's in arrest, it's usually a driver's license picture. So that's probably a driver's license picture.
And just a clarification, before you said that Keith Caneiro suffered a gunshot wound, plural, I want to make sure I heard you correctly.
Yes, that's right. Thank you all for your time. I hope you all have a good Thanksgiving. Appreciate seeing you today. Yeah, no kidding.
All right, so we heard a lot there. We heard about the family that was found, Keith with the gunshots to his back. The kids were all the kids and the wife, mother, Jennifer. They were all found in the home, and further investigation. Well, they died before the fire, and then further investigation is going to show that autopsy is that they also died not only of their stab wounds but also of smoke inhalation. So they were all alive as this was happening, as the fire was happening, which is a shame. All right, so now now we're going to get to another press conference. And this one is going to be more about, well, we'll see. I won't give away anything. Let's just watch together.
What's his demeanor?
Let's just get back here. All right. What are you guys talking about? I-9, yeah, it is absolutely horrible. Lily Wayne, that was a good press conference. We did learn a lot. He is not out on bail, Willow. He is not out on bail. And he's been in jail because of COVID. So this happened 2018. So first of all, you had COVID hit. Then you had him changing from a private to a public defender. Then you had the prosecution uncovering new DNA technology advanced. And then the defense needed time to examine that and to see if they had any experts. So there was 3 reasons why this has been delayed. So 3 reasons why this has been delayed. Or if not really delayed, but has taken so long to actually come to trial.
That have worked tirelessly on these investigations over the past week, and I will give particular shout outs to many of them as we go through this press conference. But we called this press conference for the purpose of announcing that additional charges have been filed against Paul Caneiro this morning, and he's been served with those charges while he's detained at the Monmouth County Correctional Institute here in Freehold. We have charged defendant Caneiro with 4 counts of murder, 1 count of aggravated arson, 1 count of possession of a firearm for an unlawful purpose, and 1 count of possession of a knife for an unlawful purpose. These charges that were filed this morning are in addition to the charge that was filed last week out of Ocean Township for the alleged aggravated arson of the defendant's own home. And by filing these charges, the state alleges that the defendant murdered his brother Keith Caneiro and Keith's entire family, his 2 children, Sophia and Jesse, and his wife Jennifer, during the early morning hours of Tuesday, November 20th. Specifically, we allege that the defendant repeatedly shot and killed his brother while he was outside of the side of his home, and then moved to murder the rest of the family inside the home. We allege that Jennifer was shot and stabbed, and the 2 Caneiro children were repeatedly stabbed by knife. We also allege that after murdering the Caneiro family, the defendant then set fire to the house at 15 Willowbrook in Colts Neck in an effort to conceal and disguise his earlier committed crimes. Now, as I mentioned, the defendant was served with these charges this morning, and he will have an initial appearance and detention hearing for these charges, as well as the charges that were filed last week on the aggravated arson out of Ocean Township. That hearing will be held before the Honorable James McGann at the Monmouth County Superior Court tomorrow at 9 a.m. As for the status of the medical examiner's investigation, Keith Caneiro's cause and manner of death was ruled to be multiple gunshot wounds by homicide. Jennifer, Jesse, and Sophia's cause and manner of death remain open, pending toxicology reports. But as I mentioned last week when we spoke about this case, it is the state's position and allegations that they were the victims of homicidal violence, as indicated by the charges that were filed today. The cause of the two fires at the Ocean Township home and the Colts Neck home has been determined to be arson by the Bureau of Alcohol, Tobacco, and Firearms. And ATF has further determined that the origin of the Colts Neck fire was in the basement, and the origin of the Ocean Township fire was two exterior locations at each end of the house in Ocean Township. Now, there's been extensive speculation about a timeline or order of events as it pertained to the fires in these two towns. We allege that the Colts Neck incident happened in the early morning hours of last Tuesday, November 20th. We also allege that the defendant returned to his house in Ocean Township with certain items of evidence that he retained from the Colts Neck crime scene. And I can't provide any further description as to that type of evidence because of the ethical and legal rules that constrain us. From there, we allege the defendant intentionally set fire in his home at or about 5 a.m. for the purpose of both destroying evidence of his earlier crimes in Colts Neck and to also create the illusion that the overall Caneiro family was somehow victimized or targeted. We allege that it was a ruse. Now, understandably, many have questioned and wondered about a motive to these alleged crimes. Based on our investigation to date, we believe that the defendant's motive was financial in nature, stemming from his and the victim's joint business ventures that they owned and operated out of Asbury Park. As a result, we have also launched a financial investigation into the business and financial dealings of the defendant. Now, with these types of investigations, they take time. So I won't be able to provide any further information as to motive at this point in time. But I would encourage you to continue to follow this case as it proceeds through the criminal justice system. As court appearances occur, there will likely be information that's presented on the record by the state in this case. Bringing together a case like this takes a true team effort. And I'm honored to be joined by some of the agency heads, detectives, and prosecutors, all of whom played a vital role in bringing this case to a head with these charges today. The investigation necessarily required the support of a number of law enforcement partners who stand with me here today, and I would like to personally commend them and give them our thanks. The Colts Neck Police Department, represented by Acting Chief Frank Lissess. The Ocean Township Police Department, represented by Chief Steve Peters. The Monmouth County Sheriff's Office, represented by Sheriff Sean Golden. The New Jersey State Police, represented today by Lieutenant Colonel Scott Ebner and Major Mike Kane. The New Jersey Regional Computer Forensics Laboratory, represented by Deputy Director Lieutenant Cy Blystein. The Bureau of Alcohol, Tobacco, and Firearms, represented today by Special Agent in Charge John DeVito. The Federal Bureau of Investigation, represented by Special Agent in Charge Greg Erie. The Monmouth County Fire Marshals, who represent the entire fire community, who's here today represented by Kevin Stout. And then finally, so many members of my investigative and legal staff at the Monmouth County Prosecutor's Office, some of whom join me up here today. These individuals and so many others spent countless hours and continue to spend countless hours working on these investigations. I want to convey my sincere thanks and gratitude to those involved in this case who worked tirelessly, particularly through the Thanksgiving holiday, to solve this case and bring these charges to fruition today. These were your finest days, ladies and gentlemen, and this is your finest hour. And it is my greatest honor to work with you in the law enforcement community as we stand here today. I'm humbled by your partnership, and I look forward to that continuing on through this case and any other case that comes through Monmouth County. As to our cases, they remain active and ongoing. And to that end, anyone in the public with information on these matters or any others that might relate to the Colts Neck or arson incidents, I would encourage you to contact law enforcement. If it involves the Colts Neck incident, please call Monmouth County Detective Pat Petrozello at 800-733-7443 or Colts Neck Detective Richard Zarillo at 732-780-7323. If it involves the Ocean Township case, please contact Monmouth County Detective Brian Weisbrot at 800-733-7443 or Ocean Township Detective Chris Brady at 732-531-1800. And as to those 4 detectives that are running the point on these 2 investigations that stand up here behind me today, I want to commend you on your outstanding work and thank you on behalf of a grateful county and a grateful law enforcement community. Finally, to the victim family members and the friends of the Caneiro family and to the entire Colts Neck community, it's not lost upon us how troubling and confusing this incident has been to you and how unusual these circumstances are as alleged. Our collective hearts in the law enforcement community go out to you for the loss of Keith, Jennifer, Jesse, and Sophia. In this case, we started strong thanks to this team effort, and I want those victims and those community members and friends to know that we're going to finish this case strong too. We won't stop until we bring justice in the name of Keith Caneiro and his entire lovely family. For further updates on these charges as they proceed through the criminal justice process, please continue to follow us on Facebook, on Twitter, at our webpage. Our Twitter handle is @MoncoProsecutor. And as of Monday, anybody in the community or the public is able to download a free app under the Monmouth County Prosecutor's name that will share with you all things relating to Monmouth County law and public safety, to include this case. And with that, I'll take questions, do the best I can to answer them under these limited circumstances. Brian.
Can you at all make sense out of why someone would go, if it's a financial issue between 2 brothers, why would he kill the mother and 2 children, the wife and his father?
Look, Brian, I get questions like that all the time. I have 2 answers for you. The first is I have to defer to the evidence that's going to be presented at trial if this case gets indicted by a grand jury. The second is I can't read what's in a person's, or in this case, a defendant's head. Motive is not an element of these crimes, but it is something that we will be presenting to a jury one day if this case is returned as a true bill. That's the best I can offer you right now. Yes, sir.
Chris, could you, you mentioned you cannot really go into the motive. You said it was financial, but can you talk at all about what led you guys to kind of look in that direction, even generally speaking?
Well, you recall last week there was a great effort that was undertaken by the fire community here in Monmouth County. It took nearly a day for that scene to be secured at Colts Neck. And after it was rendered sound by county engineers, I have fabulous investigators that have worked with us on this case and at the Ocean Township case. The only thing I can say is that we recovered a great deal of evidence, and that evidence is being analyzed as we speak here today by many of the agencies that are represented by these partners behind me. I can't comment substantively on the quality or quantum of our proofs. The only thing I can say is that at this point in the stage, we are confident in our proofs, or else we wouldn't have charged this case the way we did. And the only thing I can tell you is just to continue to follow this case. As there are future court appearances, then information will be presented during those appearances as part of the public record. Yes, ma'am.
In terms of a financial motive, now that Paul Caneiro has been charged with the murders and the arson of the Colts Neck house, do you believe your investigation will stem outward further into financial crimes and organized crime in terms of, establishing more of a reason that there was a financial motive?
No, that's a fair question. At this point in time, remember, we are just assessing motive and we're conducting a financial investigation. I don't have any reason to believe that there's I can't tell you if charges are or are not coming. As to the angle that you mentioned about organized crime, we have no reason to believe that there's any aspect of organized crime involved in these 2 investigations. And that's in partnership with not just county and state law enforcement agencies, but in our partnership with federal law enforcement agencies. But I qualify that by saying this case, as is every other case, they are fluid. So this is an active and ongoing investigation. Yes, sir.
Has the suspect been cooperating with you? What's his demeanor like? How difficult has it been to build the case against him?
Well, the suspect has been in jail since we charged him last week, so by virtue of that, because he's incarcerated pending trial, he has to be cooperative. As far as the service of charges go, they occurred this morning without incident. Yes, ma'am.
Did he target his family? Did he try to kill his wife and his kids? And after these charges, are they still standing behind them?
I couldn't speak to what the family is or is not doing on behalf of the defendant, but as I mentioned, we charged the defendant with aggravated arson of his own home last week. So we allege that because it's a second-degree crime, we allege that his family was put in danger by virtue of that. That said, today I've shared that it is our theory and belief that that fire was effectively a ruse designed to make it appear as if the overall Caneiro family was somehow targeted. Yes, sir, in the back.
Chris, so on the timeline, so he kills Keith and his family, that's overnight, and then he goes back to his house and sets a fire to hide the evidence. When does he start the fire back in Colts Neck, though? Does he do that early and then you don't see it till 12:38, or?
Now, that's a fair question. We allege he started the fire in the early morning hours of Tuesday, November 20th, after he allegedly murdered Keith Caneiro and his family. Now, it's a fair point about the fire not being reported at 12:38. Based on what we know from cause of origin of that fire, it was started in the basement. It continued to smolder until when there was entry made into the home. A great deal of oxygen coming into the home effectively fed that fire. So it wasn't reported until 12:38, and what we believe caused the fire to catch on from there is likely the feeding of oxygen as the house was entered into.
So he had started the fire after he killed him early in the morning before coming back home to start the second fire.
That is the state's allegations and position at this time. Yes, sir.
Sir?
Yes, sir.
The evidence that he took with him after the murders, I know you can't provide many details about it, but is it possible that perhaps this was stolen property, something that he took with him that when the first time he went to the home, he didn't bring with him?
We have no reason to believe that it was stolen property at this time. Yes, sir.
However, was the weapon, or was it registered?
I can't comment on that at this point in time. I'm sorry. Alex, you had a question?
Yeah, what kind of punishment is Paul?
Well, the first-degree murder charges, each of them carry 30 years to life. So the maximum penalty is life imprisonment. Yes, ma'am.
Can you say anything about how long he may have planned this, how premeditated? Was it 24 hours? Was it a month? Any?
It's a good question. I wish I could answer it. I can't. I would just encourage you to follow this case as it proceeds through the criminal justice system. Yes, sir. Hey, Alex.
Can you specify where in the house the three victims were found and how Paul Caneiro had control of all three of them at once?
I missed the second part of your question. I'm sorry.
How Mr. Caneiro may have controlled his three alleged victims at the same time.
I can't comment on the placement in terms of where they were found inside the home. That would be evidentiary. And the other part of your question, I'm sorry, I still didn't catch it. What is it again?
It would seem that he was able to keep control over all three of them at once, since they were all found in the house. I was wondering how he might have, maintained control and kept them within the house before he was able to.
Or were they asleep?
The only thing I can comment on at this point in time is what I mentioned earlier, which is we allege that he shot and killed his brother when the brother came outside the home, and then he returned inside the home where he allegedly murdered the other three family members.
So are you saying that this was planned over a period of time? Was it a spontaneous?
I can't comment on that at all. I'm so sorry. Yes, ma'am.
What type of business, joint business did they have in Asbury Park?
They ran a technology company based out of Asbury Park, but it also was a pest control company, so it basically served two purposes. Yes, sir.
Can you talk a little bit more about the financial investigation? Are you just looking into Paul's finances or also into the company's finances?
I can't go any further at this point in time because it's in infancy stages, but stay tuned.
Is that launched by the prosecutor's office?
Yes, it's by our financial crimes and public corruption section that we have here in the office. Yes, ma'am.
What about any security video, neighbors, or what happened with the family's security system?
Look, I can't comment on that at this point in time, but as I mentioned earlier, we thankfully collected a great deal of evidence that is being forensically examined as we speak now, but I can't confirm or deny that type of evidence was collected. Yes, sir.
You're the prosecutor.
Yes.
You deal with heavy-duty stuff all the time, I'm sure. This is particularly heinous and horrible, it would seem. As a person, when you have to deal with something like this, the murders of a wife and kids, the guy shot in the head, can you talk a little bit about how that affects you and your team?
Yeah, I can. If these allegations are proven true, regardless of whether or not the defendant did it, because he is entitled to his constitutional protections, this, you know, we work for the state and for the government without passion or prejudice, but this one is the most brutal case that I've seen in my experience here. And I know that the entire team of investigators and people involved in working on this case, the fire officials, that they've struggled with this too. But I guess if there is a silver lining at all, even though they struggled with it, as I mentioned earlier, they did an absolutely outstanding job in it. And for that reason, it's one of my proudest moments that I've had in my life.
Was the
Yes, sir.
suspect in some way ill or out of work or not able to work leading up to this? Is that part of what?
I couldn't comment on that. I couldn't confirm or deny it. I'm sorry. Yes, sir, in the back.
Now, Paul goes back to his house and sets it on fire with his own family in there. Is he going to be charged with attempting to kill his own family too? Did he try to kill them also in that fire?
I couldn't comment on charges, what might or might not come from this point in time. It really depends on how our investigation unfolds. Yes, ma'am.
Is that part of it though? Is that a part of it?
Again, I couldn't even begin to speculate it, and I have to let my team do their thing, do their forensic and examination and analysis, undertake the financial investigation before I could even get there.
His wife and kids were in the house when the fire started.
Yes, yes, sir. That's what we allege. Yes, ma'am.
Has Paul expressed any interest in attending the family funerals?
Not-
For any be able to attend it out of jail or anything?
You know, that's a question I would probably direct to his legal counsel. I don't know the answer to that. I'm sorry. Yes, sir.
Was there any kind of toxicology done on Paul, and if so, can you share what the results were?
There was no toxicology done because his remains were recovered outside the home and they weren't burned. So part of the reason the medical examiner has to conduct a toxicology is because of the condition of the 3 remaining bodies inside. Oh, you said Paul. I'm so sorry.
Yeah, that's okay.
No, I couldn't even begin to comment on that. I apologize. Yes, ma'am.
Are you absolutely certain that he acted alone? Did anyone possibly plan this, or was just jump into this for a moment?
Based on the evidence and the investigation we've conducted to date, we are confident that it was just the defendant acting alone as alleged by the charges filed today. Brian.
2 questions. One, can you say where the knife came from?
No, I couldn't.
Did you bring it into the house, or did you get it at the house? Can you say?
I couldn't do that, and it's not that I'm trying to be obstructionist. I want to ensure the integrity of this criminal justice process. This is obviously a huge case with every case we bring, but I am not going to run the risk of doing anything to taint this case as it proceeds forward. Yes, ma'am.
Can I follow
Oh, sure.
Different question.
You got it.
Can you say anything about the suspect once he got to his own house? Did he raise are you aware if he raised any alarm with his family? Can you say anything about how or where you found him later in the day so that you could charge him with attempted aggravated arson?
My only response to that is, in terms of that aggravated arson that was filed last week, we allege that there were family members inside, or else we wouldn't have charged it as an aggravated arson. But in terms of the question about whether he had intended or attempted to murder his own family, I don't believe at this point in time there's any evidence to indicate that. Our theory and belief that he was going to get his family out all the time, and as I mentioned, that the fire at his home served 2 purposes. One was to destroy evidence that he retained and brought back from the Colts Neck crime scene, and the other was to create some type of a ruse or an appearance that his larger or overall family was somehow targeted. Yes, sir, in the back.
Is there any evidence that Paul and Keith had any kind of physical altercation, obviously beyond the shots that were fired outside the home? Was there any fight between the two? Any evidence, obviously, on the surviving member there?
I couldn't comment on that. I'm sorry. I couldn't confirm or deny it. Alex.
Outside looking in, it appears that these 2 were successful. Can you speak more about the financials of the business? Were the businesses doing well? Did they fall on hard times?
We're still working on that. I can't comment on it at this time. But if further announcements are necessary, whether it's by way of charges or through appearances in court on the public record, making statements thereto, you'll be able to glean the state's theory and how we're going to proceed on that motive therefrom. Yes, ma'am.
Can you talk about the circumstances through which Mr. Caneiro was arrested? Was he with his family? Was he trying to run away? Can you talk a little bit about how was he arrested?
The only thing I can comment on is that he was arrested without incident. Yes, ma'am.
Is there any past known violence between these two brothers, whether at their homes or at their business?
Again, I couldn't even begin to get into past conduct, so I can't confirm or deny that. I'm not allowed to comment on that. Yes, ma'am.
Has the defendant shown any remorse for allegedly killing his own family members?
He's represented by counsel. Our communications are not capable as a result. I would direct that question to his legal counsel. Yes, sir.
Have you been able to trace the gun directly to him? And what evidence was there that really connected him to this crime? Was there something really specific?
Listen, I understand the question. I'm sure I understand the appetite for that information in the public and the media. I just can't comment on the quantum of proof and the evidence that we have. That's something that's going to have to save for a later day. The only thing I can say is we are quite confident in our proofs, or else we wouldn't have charged this case. Art.
Mr. Prosecutor, is the vehicle that the defendant used to travel to and from the two homes in evidence, and is there blood in it?
I can't confirm or deny that, Art, for the reason I just gave this gentleman. Yes, sir.
Can you talk at all about how he got the brother outside? Because that's where he allegedly shot and killed him. I mean, did he yell? Did he knock on the door? Is there any sense about how that played out?
None that I can comment on today. Yes, sir. Alex.
New Jersey's not a death penalty state, but do you feel he deserves a death penalty? The allegations are proven true if he's convicted of these allegations?
So here's what I think about that. Obviously, I only enforce the law. I don't make it. But if that was a possible sentence in the state of New Jersey, the only thing I can say is that I would have certified this case as a capital case. But again, that is not my job here.
Can you tell us, sir, when the business was started at least, how long they were together in this partnership?
No, I don't even know the answer to that as I stand here today, but I couldn't comment on it if I did. Just two more, please. Yes, ma'am.
So Paul Caneiro shows up at Keith Caneiro's house. Do you know if he knocked on the door, was there an argument inside, and then the brothers went outside and it continued and just spilled over? Or do you think he went there with the sole purpose of killing his brother?
Listen, I wish I could comment on that. It's a fair question. And like I said, I understand the appetite and interest for something like that in the public. I can't go there at this point in time. We have theories and answers and thoughts on this entire investigation, and much deeper dive that I wasn't able to share with you today. I just can't go so far as to share it with the public extrajudicially like this. It has to be for the courtroom. Yes, ma'am.
Given the nature of the crime, are you expecting to be held without bail tomorrow?
Well, let's put it this way. The state will definitely be seeking detention, which means we want him remanded pending trial until these charges are resolved.
Last question.
Yes. Brian.
Can you please describe any injuries found, any burn marks, whatever, found on Mr. Paul Caneiro?
No, I couldn't comment on that.
Any particular reason? I mean, did you find him in an injured state?
Listen, all of those types of questions, that all ties in to the evidence that we might or might not present at a future criminal prosecution. And again, the goal here is not for me to be obstructionist. I understand the public's interest in this. I'm doing the best that I can.
You can't say why he did it, but do you think you have an idea of why he did this?
Yes, as I mentioned, our theory and our belief is that the motive was financial in nature. That's the best that I can do at this point in time.
Do you really think you've been able to, again, you've amassed all this evidence, you have all this.
Yes.
You think you have a really good idea specifically why he did it?
We do, but again, I'm not going to jump to conclusions because it's going to require a thorough investigation. The last thing I'll say to you is I had a chance to meet with the extended members of the Caneiro family, and naturally you can imagine the turmoil and the confusion and the pain and struggle that they're going through. I would just ask members of the media and public on that family's behalf to please give them their privacy. And with that, again, just follow us on our social media and news platforms. We'll do our best to try to update you. Next appearance is tomorrow at 9 a.m. in this particular case, and I wish you all happy holidays.
Thank you, everyone.
Thank you. Let's go back to the room. Good.
All right, so in that press conference, Paul was arrested, and he was charged with the 4 counts of taking out his brother, his sister-in-law, and his nephew and his niece. So I know some of you have been chatting a little bit. So Sarah Grace Patrick, it looks like it's been pushed to August, so we don't have to worry about that. I didn't watch it. I just I didn't hear it, I should say. I was just watching it and reading chat on another channel, a couple other channels. And it seems like it's being pushed to August. And it probably has to do, again, I don't know for sure, but it probably has to do with the neuropsychologist that was supposed to have a report to the defense after Christmas. And then the state was going to have a chance to review that report and then possibly come up with their own rebuttal experts. Don't know. But that's what I've been kind of gleaning. So for now, Sarah Grace Patrick is put on hold, at least in my mind, at least for now, until we hear more information. But as far as I'm concerned, we're gonna go full on with Paul Caneiro and this trial. So jury selection is going on today. Not sure how long it's going to take. I've heard some people say it could take up to a week, but you just don't know. Just don't know. They could get a jury by tomorrow. It could take them all week to get a jury. We're not sure. We will be ready to go tomorrow, and if it's not, then we'll do something else. But for now, jury selection is going on right now, and hopefully it won't take too long, but we just don't know. So, hey, Sherry, good morning to you. Yeah, hey, Jane. Yeah, the judge wanted it done. Because Sarah's been in jail. He's been in jail, and he wants her to get go to trial. And I think it was because of that neuropsychologist. I think, not 100% sure, but Crystal, thank you for that memory or reminder. Don't forget to hit the like button, you guys. Appreciate that. All right, let's continue on. I've got a few more news clips, and then we're going to go into some hearings. So first up, I've got two more news clips, and then I have his first appearance. So let's, and then I have a memorial. We'll watch that too, because we never ever forget about the victims here at Trial TV Live. Never.
Fire ripping through a dream house.
So we never forget about the victims here. So some more backstory.
Fire ripping through a dream house in Colts Neck, New Jersey, but prosecutors believe it was set to cover up a vicious quadruple murder.
We allege that the defendant repeatedly shot and killed his brother while he was outside of the side of his home, and then moved to murder the rest of the family inside the home.
That defendant, Paul Caneiro, is in court today for charges already filed against him after prosecutors say the same day he set fire to his own home in Ocean Township with his wife and 2 daughters inside.
We allege that it was a ruse.
Prosecutors say Caneiro wanted to make the family appear targeted and destroy evidence of the murders in Colts Neck. Investigators say Caneiro and his younger brother Keith owned tech and pest control businesses in Asbury Park.
The defendant's motive was financial in nature, stemming from his and the victim's joint business ventures that they owned and operated out of Asbury Park. As a result, we have also launched a financial investigation.
But Caneiro says police have it all wrong. His attorney released a statement saying, in part, Paul's family means more to him than anything else in the world. He had absolutely nothing to do with these crimes. It's a bit of a legal nuance, but this morning's court appearance is not expected to address any of the murder allegations that have come out over the past couple of days for Caneiro's younger brother and younger brother's family. Only expected this morning to hear from the judge about the allegations that Caneiro set fire to his own home. Live in Freehold, New Jersey, I'm Clark Foraker, CBS 2 News.
Clark, thank you.
Yes, Shirley. Yes, he and his family, so Paul and his family, he's got 2 adult daughters and then his wife. So he had called 911 around 5:30, 6 o'clock, saying there was a fire. And when the first responders got there, they were sitting inside their Porsche. So they had an SUV Porsche. They were found inside that SUV. So 2 adult daughters and his wife, and he were okay. However, there was a red gas can that was found next to the SUV, and then there was 3 more gas cans that were found inside of his garage. So they were okay, but they found a gas can, a red gas can by the SUV, and then 3 more, I believe. 3 more were inside of his inside of his garage. All right. All right. So we are now going to get to his first court appearance. Let's get to his first court appearance. This is from November 30th of 2018.
Session, the Honorable James B. McGann presiding.
All right, please be seated.
Good morning, Your Honor.
Good morning. All right, this is the case of the State of New Jersey versus Paul Caneiro, dockets W2018-581304 and W2018-790-1337. All right, your appearances, please.
Good morning, Your Honor. Chris Decker, Assistant Monmouth County Prosecutor for the State.
Good morning, Your Honor. Mitchell Ansell, Grimm & Aaron, Paul Caneiro.
Good morning, Your Honor. Robert A. Honecker, Jr. from the firm Ansell, Grimm & Aaron on behalf of Paul Caneiro.
Thank you.
All right, thank you. Very good. We will begin with a reading of the defendant's rights. Mr. Caneiro, you are here today because you have been charged with an indictable or disorderly persons offense. This opening statement is designed to inform you of your rights and the procedures for today. Please listen carefully. I will begin with the reading of your rights. You have the right to remain silent. Any statement you may make may be used against you. You are being represented by a private attorney today. If that should change and you ever want to make application for a public defender, you have the right to do so. If you are not a United States citizen and if you plead guilty to or are convicted of certain offenses, including some motor vehicle offenses, it may result in your being deported from the United States, or it may prevent you from being readmitted into the United States if you leave voluntarily, or it may prevent you from ever becoming a naturalized citizen. You also have the right to seek advice from an attorney about the effect a guilty plea will have on your immigration status. You also have the right to pretrial release. You may be released today with conditions unless the prosecutor has filed a pretrial detention motion or if you have outstanding detainers that cannot be resolved today. If the state has filed a motion for pretrial detention, then and they have, then your case will be heard. It's going to be consolidated and heard today to determine whether you may be safely released or must be detained pending trial. At that hearing, the state must establish probable cause that you committed the alleged offense. You will have the right to an attorney, and you do have an attorney representing you here today. You will have the right to testify, to present witnesses, to cross-examine witnesses who may appear at the hearing, and to present information by proffer or otherwise. Testimony given during the hearing shall not be admissible against you on the issue of whether you are guilty, but your testimony may be admissible in proceedings related to pretrial release, violations of the conditions of release, perjury, or for the purposes of impeachment. Under the court rules, the state can request a 3-day postponement of the detention hearing. You may request a 5-day postponement of the detention hearing. While awaiting the hearing, your commitment to the county jail will be continued. If the state withdraws its motion before the hearing, you will be brought back to court and released on your own recognizance or with the conditions of release. However, if the prosecutor has not filed a motion for pretrial detention and you do not have any outstanding detainers, you would be released on your own recognizance or with conditions of release. As a condition of release, you must provide a valid mailing address at which you receive and regularly check mail. You must notify the court handling your case of any change of address. If you fail to notify the court of any change of address and miss a court appearance as a result, a bench warrant may issue for your arrest. Please provide court staff with your mailing address, cell phone number, home phone number, email address, and the best way to reach you in the event that the court staff must notify you of a change to your scheduled event. In addition, the court may assign other conditions of release. You must strictly adhere to these conditions. Failure to do so may result in a bench warrant being issued for your arrest or the revocation of your release. If you are charged with an indictable offense, you have the right to have a hearing as to probable cause and the right to indictment by the grand jury and trial by jury. You may also choose to waive an indictment or a trial by jury. If you choose to waive a trial by jury, you will be tried by the court. In that instance, a judge will determine whether you are guilty or not guilty. You may be eligible for the pretrial intervention program. You may also be eligible for the drug court program. In order to be considered by these programs, you must submit an application. Staff in the courtroom will direct you to relevant materials for making these applications. A special note for military veterans, a program called the Veterans Assistant Project exists to provide veterans with referrals to community-based resources for services related to housing, mental health counseling, substance abuse treatment, financial aid, legal services, education, and veterans benefits, including possible monitoring by another veteran. Our court staff can provide you with a brochure describing the program and an application. Staff can also help you with completing the application. All right. That concludes the statement. I would ask that the prosecutor read the charges.
Thank you, Your Honor. Mr. Caneiro, first and foremost, warrant 2018-000790137 alleges that on or about November 20th, 2018, you did commit the crime of aggravated arson, specifically by purposely or knowingly placing another person in danger of death or bodily injury, and or with the purpose of destroying the building or structure of another. To wit, you did set fire to your residence by using gasoline and igniting the gasoline, causing the residence to catch fire while your wife and 2 daughters were inside. That is in violation of NJSA 2C 17-1A1 and or A2. Here is a copy of your complaint.
Record will reflect the defendant has been served with a copy of the complaint.
Thank you, Judge. And Mr. Caneiro, W 2018-000058-1304 alleges that also on or about November 20th, 2008, within the jurisdiction of this court, you did purposely or knowingly cause the death of Keith Caneiro or serious bodily injury resulting in the death of Keith Caneiro. That's a first-degree crime, contrary to NJSA 2C 11-3A1 or 2. It also alleges that within the jurisdiction of this court, you did purposely or knowingly cause the death of Jennifer Caneiro or serious bodily injury resulting in the death of Ms. Caneiro, a first-degree crime contrary to the same statute. The third charge is that you did purposely or knowingly cause the death of J.C., a juvenile, or serious bodily injury resulting in the death of J.C., also a first-degree crime. The final murder charge alleges that you did purposely or knowingly cause the death of S.C., a juvenile, or serious bodily injury resulting in the death of S.C., crime of the first degree. You also are charged with purposely starting a fire on the property of another, to wit, 15 Willowbrook Road in Colts Neck, New Jersey, owned by Keith Caneiro and or Jennifer Caneiro, thereby purposely or knowingly placing another person in danger of death or serious bodily injury, or with the purpose of destroying a structure of another. This is a second-degree crime contrary to NJSA 2C 17-1A1 and or 2. You also are charged with a second-degree crime of possession of a firearm for an unlawful purpose, by purposely or knowingly possessing a firearm with the purpose to use it unlawfully against the persons of Keith Caneiro, Jennifer Caneiro, Sophia Caneiro, or Jesse Caneiro. Finally, you are charged with unlawful possession of a knife for an unlawful purpose, a third-degree crime for using it unlawfully against the person of the aforementioned victims. Judge, that culminates the reading of the complaints. I will provide this last warrant to Mr. Caneiro.
All right, record will reflect that the defendant has been served with a copy of that complaint as well. Defense want to add anything at this point?
Judge, at this point, we acknowledge that my client has been served in regards to these particular complaints and ask that a not guilty plea be entered in regards to all of these complaints.
All right, so noted. All right, we are joining today the first appearance along with the probable cause and the detention. How will the state be proceeding as the probable cause?
Judge, our intention was to proceed by way of proffer with respect to both detention motions. However, I've had conversations with Mr. Ansell and Mr. Honaker with respect to this. And it's my understanding that based upon the discovery they've received and the knowledge they have of the case, they are going to be stipulating that probable cause does exist based upon the discovery as of now, and it's for purposes of this motion or this detention motion or both detention motions at this time. That being said, it's also my understanding that once that probable cause determination is stipulated there too, they will be consenting to Mr. Caneiro's detention, continued detention through the culmination of these matters. That is my understanding. Mr. Ansell and Mr. Honaker, I believe, would agree with those representations.
Mr. Honaker, Mr. Ansell, is that your understanding?
That's correct, Your Honor.
It is, Your Honor.
In regards to this particular matter, we will not contest probable cause at this juncture. We stipulate the probable cause at this juncture, but reserve the right to challenge probable cause should there be any additional motions, such as motions to suppress evidence or motions to dismiss the indictment.
All right, very good. Probable cause, as we know, is a well-grounded suspicion that an offense has been committed and that the defendant committed it, and that's State v. Sullivan, 169, New Jersey 204. I will accept the stipulation of probable cause, and we will move on to the detention phase of the proceedings. It is my understanding that detention is being consented to. That is correct?
That's correct, Your Honor. We've had an opportunity to fully advise our client as to the nature of the detention hearing. Our client has indicated that he wishes to consent and waive his opportunity to have a detention hearing, and we've advised the prosecutor's office of our decision in that matter.
Is that true, Judge?
All right. Well, at this point, I'm going to place him on the record and read to him his rights that he would have had the detention hearing proceeded, so that the record will reflect that there is a knowing and voluntary waiver of the rights. Please stand, sir.
Place your left hand on the Bible. Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
State your name for the record and spell your last name.
Paul Caneiro, C-A-N-E-I-R-O.
All right. Mr. Caneiro, you have the right to be present at this hearing, which you obviously are. You have the right to have counsel, which you do. And at a detention hearing, you also have the right to be provided with all statements or reports in the prosecutor's possession relating to the facts on which the state bases its pretrial detention application. Mr. Decker, have you provided all this information to the defense?
Judge, I have. We've provided on several occasions over the course of the last, I think, 10 days. And it's my understanding that anything that's been potentially exculpatory would have been turned over, but I don't believe that there is any at this point.
All right. You also, sir, have, Mr. Caneiro, have the right to be furnished with all exculpatory evidence. That's evidence that would tend to exonerate you, known to or in the possession of the prosecutor. Mr. Decker, you have provided that as well, all exculpatory evidence known to you in your possession?
Yes, Judge, I have.
All right. You also have the following rights at this hearing, sir. You have the right to present witnesses, you have the right to cross-examine any witnesses who may appear at this hearing, and you have the right to present information by proffer or otherwise. You understand each of these rights, sir?
I do.
All right. You also have the right to testify at this hearing. You do not have to testify if you choose not to do so. If you do elect to testify, your testimony shall not be admissible on the issue of guilt in any other judicial proceedings. Do you understand that, sir?
I do.
I should advise you, however, that if you do elect to testify at this pretrial detention hearing, your testimony shall be admissible in any or all the following proceedings. Any proceedings related to your subsequent failure to appear when required, if applicable. Any proceedings related to any subsequent offenses committed during the release, if applicable. Any proceedings related to your subsequent violation of any conditions of release, if applicable. Any subsequent perjury proceedings, if applicable. And for the purpose of impeachment in any subsequent proceedings, if applicable. Do you understand your right to testify or not to testify, as the case may be?
I do.
Has your attorney explained each of these rights to you?
Yes.
Has your attorney answered all of your questions regarding your rights at the detention hearing?
Yes.
Do you need any more time to speak with your attorney about the detention hearing and your rights at the hearing?
No.
All right. Counsel for the defense, have you explained each of these rights to your client?
We have, Your Honor.
All right. Are you satisfied that he understands these rights?
Yes.
Have you reviewed with your client the information provided by the prosecutor?
We have.
And have you had enough time to discuss this matter with your client?
We have.
All right. Now, one more thing, Mr. Caneiro, is anyone forcing you to waive this pretrial detention hearing?
No.
Are you under the influence of any drugs or alcohol today?
No, I'm not.
Do counsel have any additional questions relative to this waiver of the detention hearing?
No, Your Honor.
No, Your Honor.
Okay. State have any further questions?
I do not. I'm satisfied.
All right. I'm satisfied that having read the defendant his rights that he would have had at the pretrial detention hearing, that he's knowing and voluntarily waiving his rights, and I will direct that he be detained. All right. Anything else from counsel? No?
No, Your Honor.
All right.
No, Your Honor.
Thank you very much.
Thank you.
So you noticed his limp. That seems to be about it here. All right, so you noticed that he had a limp. So he got in a car accident. I'm not sure when, but he got in a car accident and he had a limp. So he kind of stopped working. So he was collecting disability, but his wife was collecting his salary from the pest and the computer companies, and that was like $225,000, I think, somewhere around there. So his wife was collecting his salary. He got in a car accident, and he then went on disability. So he was, creating fraud even back then. So yeah, when you see him limp, that's why, because he got in a car accident. I think he hurt his back. I believe. I think he hurt his back. So. Danny, when is this trial? Jury selection starts today. They're currently in jury selection. We've heard a couple of reports that it may take a couple days and maybe next week still before it actually. But we're going to watch. I have a bunch of hearings, so hopefully towards the end of that, they'll say they'll give us a little bit more indication of that, because right now I'm just sort of going off of news reports and people talking. So, hey Barry, good to see you. Aaron says he had multiple surgeries. All right, Deviant, have a good night's sleep. Next Monday openings. So we'll I don't know other than what you guys are talking about. So I'm not sure where you're getting that information from, which is entirely cool. I just don't know. I want to hear it from the judge. So I'm hoping. It's usually the last hearing that there was one in September. So I'm hoping that they will let us know then when they what the schedule is. All right, so now I want to move on to, this is from December 3rd. So that was November 30th. And again, we always remember the victims here. It's always about the victims, not about the defendant per se. But I want to show this.
And a family
before we move on to actual hearings. So this is our last news clip, and then we're going to get to some hearings. And again, it's jury selections going on right now, with the hope that a trial will begin. Well, hopefully it'll begin as soon as they get a jury. And it seems like maybe next week it might take off, but we'll see. We'll see.
And a family murdered inside their mansion in Colts Neck, New Jersey is laid to rest together.
Well, a funeral was held for Keith Caneiro, his wife Jennifer, and their two young children, Jesse and Sophia, yesterday. The family of four was cremated and their remains were placed in a single urn. 4 red roses were arranged around it. Caneiro's older brother Paul is accused of killing them and then setting their mansion on fire. He pleaded not guilty to the charges.
Well, that was a lot a lot faster than I thought. I thought that was longer. But it's only 25 seconds. So there you go. I thought there would have been more. All right. Colts Neck. Colts Neck. That's where this is taking place. Let me pull this up again. So Colts Neck, New Jersey, as in like a horse, Colts Neck. So again, this is where it's taking place. All right, that's where it's taking place. Here's the Jersey Shore. You hear all about the Jersey Shore. There's the Jersey Shore. Sandy Hook. There's not Connecticut Sandy Hook, but there's a Sandy Hook. Of course, there's Brooklyn, Staten Island. New York City's there, so it's very close. And again, this is where Bruce Springsteen has a home here, Queen Latifah, Jon Stewart, among others. So there's Asbury Park right there. So Asbury Park is right here. There's the Stone Pony, which of course, there's the Stone Pony. Oh shoot, I just lost my pin. Anyway, this is where it is. I just lost my pin. So Ocean Township. There's Ocean Township. And here's Colts Neck over here. So there's Colts Neck over there. So very, very affluent, very well-to-do section of, there's the Colts Neck Golf Club. Very affluent place in New Jersey. So, okay. Show Asbury Park. Yeah, here's Asbury Park. There's the hotel, Asbury Hotel. You're welcome, little Lulu. Thank you for being with us. Yeah, Asbury Park's down here somewhere. It's not coming up for me right now. I don't know why. There's Ocean Grove, Columns. I can't find Asbury Park now. Right in here, though, isn't it? Anyway. It was coming up, now it's not. Long Beach Island I've been to. There's the Asbury Hotel. And there's the Stone Pony. Oh, here's Asbury Park. There's Asbury Park right here. So Ocean Township. There's Asbury Park. So, all right. All right, so let's get back to some pretrial hearings. So now we're actually going to get into some hearings. This is from 2024. So again, he had private representation, but they stopped because there was a problem with discovery. There was something, okay, here, I wrote it down here. So the firm of Ansel, Grimm, and Aaron left, this was in March. This was a press release that they put out in March of 2019. So this was before COVID. So March 28th, 2019, the firm of Ansel, Grimm, and Aaron, PC, left after reviewing discovery, and Caneiro's defense will be handled by Monmouth County Public Defender's Office and his new attorney, Michael Wick. So Mitchell Ansel says, we didn't quit. The rules of professional conduct forced us to withdraw, I should say, and it's very frustrating. It feels like it's being implied that we just decided not to represent him anymore, and that's just not accurate. As lawyers, we have taken an oath, and we have to abide by the rules of professional conduct. So there was some kind of conflict of interest, but it had to do with, I thought it had to do with discovery. Yeah, after reviewing discovery. So, Brian, you've been to Seaside Heights? JMS, as far as I can tell, the motive, which from what I've heard, from what the prosecutor said, from what I've been able to ascertain, is that they were in a partnership together. Keith had started a computer company, and he had a contract with Citibank, which you guys all know is huge bank. And then they also had a pest control company, and there was a trust fund for the kids, and Paul controlled that. Paul, I guess, ran the finances. So Paul was running the finances. He was skimming money, I think to the tune of something like $90,000. And Keith and his wife Jennifer were like, where's all this money going? So they kind of put a pause on everything, and they wanted to sell the company, actually. So it seems right now the motive from the state is alleging that it's about financial greed. There was some talk about Paul having a mistress. I don't know. I haven't been able to confirm that, but one of the reports I read yesterday, or one of the YouTube channels I watched, that they said he had a mistress. I don't know if that's rumor or not, so I'm not going to go too much further about that. So, well, JMS, there's 3 reasons. COVID was one. His attorneys leaving was a second. And then the third reason is that state has come up with, they're using a new technology for DNA, and the attorneys need time to counteract that with their experts. So there's 3 reasons, 3 big reasons. COVID, well, your attorney's leaving, COVID, and then DNA technology, experts. So 3 big reasons. All right, so let's get to an actual live hearing. Well, not live. Not live. An actual hearing from November of 2024. We already saw his him entering his plea. So now let's get to.
Discovery was turned over. You're saying.
Sorry. Let's get to this, and it seems like our audio is really good, which I'm excited about. Okay. All right. So this is from November 13th, I'll go ahead and I'll pin this. So a hearing, November 13th, 2024. All right. All right, so this is a hearing from November 13th of 2024. Let's see, he fought the DNA expert. Who fought the DNA? Oh, Paul fought it? Oh, okay, that makes sense. Yeah, so the defense wanted to have their own expert. All right, let me pull this back up. Okay, here we go.
That will never be considered a drop-in by StarMix?
So far, we have not changed that 250 RFU threshold, and so you can have a higher confidence that it is not from drop-in if it's above 250 RFU.
Understood. The next parameter on there is saturation, which you previously explained. Can you explain, and I'm particularly referring to pages 6 to 7, what was done with respect to saturation in that parameter?
So for saturation, some of the 99 single source profiles that were generated the peaks were very high, and so they were used in the saturation study. But also we purposely put in very high amounts of DNA into the amplification process to sort of get to that level. So we had 7 different samples that were amplified, not at our normal target DNA amount, but a much higher excessive amount. And
we're back on the record. This is State of New Jersey versus Paul Caneiro. We are continuing with the Daubert hearing under indictment 19020283. Can I have the appearances of counsel for the record?
Good afternoon, Your Honor. Assistant Prosecutor Nicole Wallace on behalf of the state.
Good afternoon, Judge Chris Decker, Assistant Monmouth County Prosecutor. Good afternoon, Your Honor. Mike Wicke on behalf of Paul Caneiro, who is seated to my left.
Good afternoon, Your Honor. Christopher Godin on behalf of Mr. Caneiro, who is present in court to my left.
Good afternoon, Your Honor. Victoria Howard, also on behalf of Mr. Caneiro.
Okay, good afternoon, everyone. Our witness is back on the stand. We're about to start cross-examination. Counsel, are you ready to proceed?
Yes, Your Honor.
Okay, go ahead.
If I could get just the demonstrative set up. I think I have to ask the clerk to project it, right?
Yeah.
Can I proceed, Your Honor?
You can.
Good. Can we agree that you're not a software engineer?
Yes.
Your background is in forensic DNA analysis?
Yes.
You were not involved in StarMix's development?
That's correct.
You've never seen the StarMix source code?
That's correct.
You're not aware then of how the source code actually implements the StarMix model?
That's correct.
You're also aware that when StarMix releases a new version, they will frequently change the model?
I don't know if I was aware of that, no.
So that they will actually, or so you were not aware that in between at least some versions of StarMix, they will actually change the scientific model that they use?
Are you referring to the source code?
No, I'm referring now to the model again. I apologize.
The model being?
The actual model that StarMix implements.
Well, there are many changes with every new version, so I can't speak specifically to any one of those changes.
But you're aware, for example, that in the earlier versions of StarMix, degradation was modeled linearly? Now it's exponentially?
I would have to look at that information because I don't know at what version that would have changed.
Are you aware of how allele variance is modeled?
To some extent, yes.
Can you explain your understanding of that to me?
Allele variance, there's a few different, I think 2 or 3 different ways that you can model peak-height variances in general. And the only one I can recall off the top of my head is, I believe it stands for the longest continuous chain. I may be wrong about that. But I do know that there are at least 2 or 3 ways of looking at peak height variances, and all of those are assessed, and the best one for each locus is established.
And just to be clear, I'm not talking about the stutter variances, I'm talking about the allele variances.
I think any variances would be under that.
You believe that they're both the same?
No, but I believe that they have different ways of looking at them and assessing them.
So you're not familiar with something called the Duncan-Taylor quantum effect?
No.
You've never heard of that?
I believe I've heard of it, but I couldn't speak to it.
You're aware also that burn-in process has changed over the course of the software?
Yes, I am aware to some extent.
You're familiar with something called Smart Start?
No, I'm not familiar with that.
And can we agree that even if the actual model itself does not change, it's possible that the way that the model gets implemented in the source code could change between versions, right?
I wouldn't be able to speak to that.
You wouldn't be aware of that?
Correct.
Like I said, because you're not involved in any of that, you're not here to offer an opinion. I understand.
That's correct.
Now, in addition to not being a software engineer, can we agree that you're not a theoretical Bayesian statistician?
Yes.
You're aware that StarMix uses a Metropolis Hastings sampling method?
It's involved in the procedure, yes.
You're aware, though, that that's not the only sampling algorithm that an MC algorithm can use, right?
That's the only one that I'm familiar with because that's the only one that StarMix uses.
So you're not familiar with, for example, the Hamiltonian Monte Carlo? As a result of that, you can't speak to the relative advantages or disadvantages of using one versus the other.
That's correct.
Would it be fair to say that prior to your exposure to StarMix, you did not have any experience with Markov chain Monte Carlo algorithms?
That's correct.
You had never heard of the Gelman-Rubin diagnostic prior to StarMix?
That's correct.
You're aware that the Gelman-Rubin diagnostic is not the only way of measuring chain convergence?
Yes.
You don't know why that diagnostic was chosen over others, though?
No.
Do you know how the Gelman-Rubin diagnostic is calculated?
I don't believe I do, no.
Even a little bit? You're not familiar with it at all?
I'm familiar with it as much as I need to be able to review the data in a StarMix report and to evaluate and determine if I can use that data, but beyond that, no.
So then can you tell me the extent to which you are familiar with it, please?
Regarding the Gelman-Rubin,
How it works, how it's calculated, what the inputs are?
the information that I have about Gelman-Rubin is what I spoke to already, which is basically that when data is input into StarMix, that there will be these 8 chains or 8 starting points, if you will, where the software tries to determine these genotypes and then give them weights. And basically, it goes through a resampling process, which is what's been referred to as the MCMC, or Markov Chain Monte Carlo resampling choice, I guess, if you will. And basically, the StarMix will go through, the software will go through a series of guesses, and guessing as to which genotypes make sense, which alleles might go with another allele, more than another allele going with a third allele. And so it will give weights after all these resampling events have occurred. And these 8 chains are resampling basically along the way, and once they converge or they come to an area of convergence, you would expect a Gelman-Rubin to be of a number that is 1.20 or less, and that indicates that these chains have converged close enough to each other that the StarMix has basically explained the DNA profile well. And if the number is higher than that, then you might want to reevaluate your number of contributors. You might want to look at your profile and see if there's any artifacts that you may have missed. But that is the extent of my knowledge regarding Gelman-Rubin.
So as a practical matter, you know that you want it to be as close to 1 as possible, and you certainly want it to be below 1.2, right?
1.20, yes.
But aside from that, you don't really understand what it represents or what it is or how it's calculated.
I don't have any knowledge of anything beyond what I've said.
Understood. I'd like to talk about validation. You spoke about this on direct a little bit. We can agree that there are differences between a developmental validation and an internal validation?
Yes.
This is a distinction that SWGDAN makes as well, right?
Yes.
And this doesn't just apply to StarMix, this applies to any software.
Any procedure, any instrument?
Any method.
Any method.
If Promega wants to sell a new amplification kit, they have to demonstrate its reliability with a developmental validation.
Yes.
And as you said on direct, the developmental validations are ordinarily much more comprehensive and broad than an internal validation.
Yes, I would agree with that.
Fundamentally, in an internal validation, you're trying to simply show that you can get this set up properly in your laboratory.
Essentially, yes.
And when you go to do an internal validation study, you don't do that before the developmental validation study, right?
That's correct.
You only do an internal validation study if you believe that it's been shown to be reliable in the developmental validation study.
Correct.
Internal validation studies are important.
Yes.
They help you demonstrate that a lab can reliably apply a given method.
Correct.
They also help you figure out the limitations of a given method.
That's correct as well.
For that reason, they also help you determine what the standard operating procedures are going to be for that method.
That's correct.
They're also a requirement, am I right?
Yes.
The FBI quality assurance standards require every CODIS certified laboratory to do that.
Every accredited laboratory, yes.
Every CODIS, accredited laboratory. If you were to violate those standards, your lab could lose access to CODIS.
That's possible, yes.
You cannot yourself implement a method if you haven't conducted an internal validation study.
That's correct.
Even if other labs have successfully conducted their own internal validation studies.
That's correct.
Every laboratory is different.
Yes.
You can't substitute one lab's internal validation study for another.
That's correct.
And you would never do that.
It's required of us to do so, internal validations in our laboratory.
But even if it wasn't required of you under the quality assurance standards, you would still not do that, right?
I believe it's a best practice.
I want to talk about a couple of the specific samples that you mentioned on your direct. You talked about an 80-to-1 mixture as being the most extreme in terms of mixture proportions, right?
Correct.
And that 80-to-1 mixture then had a minor contributor with 12 picograms.
Correct.
About how many copies of the human genome is 12 picograms?
One cell has, I believe, 7 picograms, so it's less than 2 cells.
How many 80-to-1 mixtures did your lab study in the internal validation study?
We tested 2. There was an 80-to-1 and then a 1-to-80.
So you only tested 2 mixtures that had an 80-to-1 or a 1-to-80 mixture ratio?
Yes.
So you only tested 2 mixtures that had a minor contributor with 12 picograms?
Correct.
I want to touch on SWGDAM. Do you know how many SWGDAM members there are?
I believe it's approximately 50.
And there are most of them in the law enforcement community?
And academics as well.
The SWGDAM is an organization that was started by the FBI.
I believe so, but I'm not sure.
You're aware that the executive director of SWGDAM serves at the pleasure of the FBI laboratory director?
I believe that's correct.
I want to talk before moving on about the idea of a sample being suitable for analysis. I think you may have touched on this during your direct, but can you give me an explanation or your explanation of what the difference between a sample being suitable for analysis is versus not?
Well, in our laboratory, a DNA profile has to have results at least 5 of the 24 areas that we test for, 5 loci. And if it has less, that we call it too limited, and we will not draw conclusions on that sample.
Do you have statistics on the number of samples that your lab analyzes in a given year?
Not at hand, but I'm sure we have them.
They'd be available though?
I'm sure we could compile them.
And do you know what, presently at least, what percentage of your samples are marked as not suitable for analysis?
No, I don't have a number.
And so then you also wouldn't have a number for what percent of your samples were marked not suitable for analysis prior to StarMix either, right?
That's correct.
Would it be fair to say, though, that it would almost certainly be larger than now that you're using StarMix?
The type of statistic had nothing to do really with our ability to use a profile for comparison. We would look at the profile. I cannot recall what our threshold was of getting results prior to StarMix, or prior to using this kit called Global Filer, I should say, but it has really nothing to do with statistics, which is StarMix.
Maybe I wasn't clear. Would it be fair to say that now that you use StarMix, a smaller portion of the samples that your lab analyzes are marked as not suitable for comparison? You can analyze more samples now than you used to be able to prior to StarMix.
Well, that is true, but what you started to ask me was about samples that were too limited, meaning, again, if they had results at 5 loci or more. And so now the question is slightly different in that you're asking, I believe, if we can evaluate more samples with StarMix, and we can. We can evaluate 4 persons where we never could before, and more 3-person mixtures.
And you said earlier that you may be able to actually compile the data on that to see how much that has changed with the use of StarMix?
Again, you were asking me about samples that were too limited, and I had said yes, I believe we could compile that data. I think it would be very difficult to compile the data that you're now asking for, but I suppose it might be possible.
But you don't regularly track it yourself?
Correct.
Let's talk about the developmental, the SWGDAM internal validation guidelines. Could we please publish to the room? Specifically, I'm referring to States Exhibit S6. That's S6, right? Referring to S6, specifically I am at page 8. Can we agree that we are at the section of these guidelines talking about internal validation?
Yes.
Can we agree that the third sentence up there says that some DNA typing results may or may not be determined to be suitable for analysis?
I'm sorry, where are you referring?
Right there, the first sentence on the second paragraph. Depending on the features and capabilities of the probabilistic genotyping system, some DNA typing results may or may not be determined to be suitable for such an analysis.
Correct.
Can we agree that that's what we were just discussing a few minutes ago?
That would refer to the limited samples, the 2 limited.
The next sentence directs laboratories to identify data features that would render a profile appropriate or inappropriate for probabilistic genotyping. Sorry, I need a yes over.
Oh, I'm sorry, yes.
The next sentence after that says that data should be selected to test the system's capabilities and identify its limitations.
Yes.
And those limitations, like we said, are how you create rules for determining whether a sample is suitable for an analysis or not.
Yes.
Do you have a sense of how many people were involved just within your laboratory in the StarMix internal validation study? The first one you did for 2.4?
That would be myself and my laboratory director.
Just the two of you?
Yes.
How many hours did you spend on that internal validation study?
I wouldn't be able to estimate how many hours. These were over months, and each one involved the running of samples, many samples.
And you personally, or the lab director personally ran those samples?
I personally ran those samples.
You didn't use any other lab techs?
Not for that, no.
Would it be fair to say that it was at least hundreds of hours of work that you did?
I really couldn't say. It's possible.
You spoke on direct about how there's really 2 phases to the internal validation study, the parameter study, right? That's the first phase?
Correct.
And then the sort of more what we think of as the internal validation study itself, right?
Correct.
When you're doing the parameter study, you want to make sure that you're using samples that are representative of the type of data that you see in casework, right?
Well, in that particular, in the setting of parameters, you're trying to show StarMix all the different variations that a single source profile might look like.
But again, a single source profile encountered in casework.
Yes, but not from the wide variety of sample types that we obtain DNA results from.
So it's not important then for the parameter study to use the kinds of samples that you would expect to find in casework?
It's important for the parameter study to give as much information as possible. So those single source DNA profiles were basically from blood, blood stains or swabs from the inside of the mouth, which we do encounter in casework. But it was more important during the internal validation study portion to be able to have representative samples that you would see in casework, so mixtures of all different kinds and ratios.
That was in the internal validation study, the second phase.
Correct.
But just to be clear, for the first phase, it is your testimony that it's not important to use samples that are representative of the range of samples one would expect to find in casework.
As to the extent of how much DNA was present in those samples, yes. You would want to represent what you would see in casework, but not the type of sample.
So in terms of mixture proportions, things like that?
Even in the single source profiles, we looked at, like for example, the saturation study that was part of the setting the parameters. That would be looking at samples that you might get in a particular case where the DNA is excessive. it should not be that high, but so it was representative of some samples that we get that could be saturated.
We can agree that ESR was involved in your parameter study?
Yes.
One of the documents that you received when you purchased the StarMix license was an internal validation guide, right?
I don't recall that.
You don't recall that?
From ESR?
From ESR.
No, I don't recall that.
Was StarMix the first probabilistic genotyping system that your lab had tried to validate?
Yes.
So you had never calculated allele or stutter variances prior to using StarMix?
That's correct.
You'd never calculated locus-specific amplification efficiencies prior to using StarMix?
That's correct.
Now, when you, as you said on direct, you mixed the samples together, correct? For the internal validation study?
Correct.
You analyzed them?
Yes.
And then you sent those electropherograms to ESR?
That's correct.
And then they created the parameter study document that you saw on direct, right?
That's correct.
For the record, I am putting up For the record, I'm putting up S10. It should be the estimation of StarMix parameters. Is this the same document that you saw on direct, S10?
I believe so, yes.
And this is the document that contains all of your laboratory-specific StarMix parameters, right?
That's correct.
Are you aware of how ESR calculated those parameters?
I did not go through all the calculations with them, so no.
You testified on direct that I think that they use something called Model Maker?
Yes.
You're not familiar with how Model Maker works?
I've never used it myself, no.
Are you aware of whether or not Model Maker uses its own MC algorithm?
I'm not aware of that, no.
In either event, you just have the answers here from whatever that algorithm was, right?
The answers for the allele and stutter peak height variances and that locus-specific amplification efficiency, yes.
You did not technically review the conclusions in this document?
I did, yes.
Well, you read the document, right?
Correct.
But you didn't conduct an independent technical review of what ESR did to get to the numbers in this document, did you?
No.
Like you just said, you don't know how they used Model Maker to calculate the parameters that your laboratory used.
Not specifically, no.
I want to go to the first page right here. Can we agree that there's a disclaimer on the front page of this?
Yes.
Can we agree that that disclaimer says this document is a guide only? Can we agree that it says that?
Yes.
Can we agree that the third sentence says, however, ESR makes no express or implied warranty regarding such information or data and hereby expressly disclaims all legal liability and responsibility to persons or entities that use or access this document and its content?
It does say that, yes.
Before we move on, I want to talk about your laboratory's drop-in parameters. You're familiar with drop-in being described as DNA raining from the ceiling?
I've never heard it called.
Or snowing from the ceiling, I think, sorry.
No, I've never heard that.
It's unexplainable, or at least unexplained.
And non-reproducible.
That's right, it can't be replicated.
Correct.
Would it be fair to call drop-in noise?
It could be noise.
In your parameter study, was drop-in modeling turned on?
Well, drop-in was one of the parameters that would be assessed, would be determined.
Well, do you know how the drop-in parameter was determined?
Yes.
Can you tell us?
So, as I mentioned before, we did not see any drop-in in the samples that we gave to ESR to do the study. And so they looked at other laboratory drop-in rates. And these laboratories had the same, they were using the same systems we were using. The same instrument, the same kit, the same what's called cycle number, which is how many times those billions of copies, how many cycles are needed to make those billions of copies. And it used a default drop-in rate, since we didn't see any, from all of those different laboratories that were similar to us. And that was 250 RFUs.
The record, I am turning down to the section of the parameter study discussing drop-in. We're at page 6 of 23. Are we looking at the same thing?
Again, we're on S10?
Yes, that's correct.
Yes.
Now, can we agree that it does say there that your laboratory observed an insufficient drop-in peaks within the 29 cycle profiles to inform a gamma prior distribution?
Yes.
Can you tell me what the difference between, well, first before that, and can we agree that as a result, rather than using a gamma prior distribution, your laboratory used a uniform distribution?
Yes, that's what it says, yes.
Can you explain to me what the difference between a gamma distribution and a uniform distribution is?
No.
Can we agree that your laboratory still uses a uniform distribution for drop-in peaks?
Yes.
Now, this particular document was made in 2017.
Yes.
So in 2017, your laboratory did not have enough data on drop-in events to be able to model it with a gamma distribution, correct?
Correct.
It's been 7 years since this document was created?
Yes.
Your laboratory still hasn't seen enough drop-in events to be able to model it with a gamma distribution?
Yes, because you would need to be able to determine that an allele was drop-in.
Do you know what a uniform distribution is?
I'm not familiar with that term, no.
Like we said, after ESR calculated your laboratory parameters, you could move on to the second part of the validation study, right?
Correct.
And this is the part of your internal validation where you applied the SWIG-DAN guidelines explicitly?
Yes.
ESR was involved in this as well?
Yes.
Much like with the parameter study, you made the mixtures and sent the electropherograms to ESR?
That's correct.
You did not have anyone within your laboratory conduct the deconvolutions themselves?
No.
That was StarMix that did that, or ESR?
For 2.4.6, that's correct.
Yes. And so all of the charts and graphs on your internal validation study document were created by StarMix?
Yes.
Not by your laboratory?
By ESR.
Excuse me. All right, I'm going to move to S11. This is the internal validation of StarMix version 2.4 in your laboratory?
Yes.
Can we agree that the first page of this internal validation study document has the same disclaimer as the parameter study document?
Yes, it does.
I would like to talk about section D. Specifically, the record, Your Honor, I am on page 11 of 50 of the internal validation study. We are looking at the sensitivity and specificity plots, right?
I believe so, yes.
Now, the y-axis there is the log of the likelihood ratio?
Yes.
Calculated for a given sample?
Yes.
The x-axis is RFU?
The x-axis is, I believe that is the likelihood ratio. No, I apologize. Yes, the RFUs, yes.
The average peak height for a given sample?
Correct.
Where did that average peak height come from?
I'm not sure. I would think that it was from the samples that had been run, and Model Maker had accepted a range of average peak heights, or made a range of average peak heights. But I don't really know for sure.
So you're not sure how the average peak heights for these were calculated?
Well, these graphs are separated into the 2-person mixtures, 3-person mixtures, and so on. So it could be from those particular mixtures that the average peak heights were determined.
But did these numbers come from Star Mix or somewhere else?
They were calculated by ESR.
How did ESR calculate it?
I obviously don't know specifically.
You don't know whether they used Star Mix or not?
No, I don't know that.
You spoke on direct about a couple of samples from this study that had shoulder peaks.
I don't believe I did.
Were there not 2 false exclusions that were the result of shoulder peaks?
They were not from shoulder peaks. They were unresolved, 2 peaks that were unresolved because their sizes were so close to each other that the software only recognized one and not both.
And the software here being the Gene Mapper software?
That's correct.
You were able to look at these electrophorograms and see what you're talking about, this 1 base pair resolution issue?
Yes.
You reviewed all of these electrophorograms prior to sending them to ESR, right?
That's correct.
You didn't notice this when you sent them to ESR originally?
I don't recall if I noticed or not, but it would still be important to see how StarMix would evaluate something like that.
So you're not sure whether you noticed those before you sent them to StarMix or after StarMix sent you the results?
Yeah, I do not recall.
Before moving on, I want to talk about the Gelman-Rubin diagnostic just one more time. I know we said that that threshold of 1.20 is the threshold for whether or not the chains have converged?
That's correct.
So you're saying that if your Gelman-Rubin diagnostic is below 1.2, the chains have converged?
That is my understanding, yes.
And where did you get this information from? How did you learn it?
From ESR.
Do you recall what ESR said? They just gave you that number, 1.2?
That was information, I believe, that was in the internal validation studies summary that we're seeing here. I believe that number comes from that study.
So you believe that that number came from this internal validation study?
I should say it didn't come from this study, but it was presented in this study as one of the troubleshooting methods. Yes, I believe it's in this particular study summary.
And you don't know, though, why 1.2 is the threshold for convergence versus not?
That's correct.
I want to clarify something from your direct because I don't fully understand it. You had spoke about I think you called it the performance check for 2.5.11, right?
Correct.
And you re-ran Model Maker on 2.5.11, right?
Yes.
I would like to show you the charts. Let me see. So I think we're at S12. We agree that these 2 charts right here on page 2 have the allele and stutter variances?
Yes.
Now you testify on direct that between version 2.4.06 and 2.5.11, the allele and stutter variances were the same.
We're basically the same. No significant difference.
I was going to say we can agree that these are 2 different distributions that are on this chart, right?
They have slight differences, yes.
They have slight differences, which means they're not the same.
That's correct.
After you conducted this parameter study, you did this Model Maker study again, did you choose to go with the 2.5.11 parameters or the 2.4.6 parameters?
Because they were basically similar, or not significantly different, it was recommended to us that we keep the parameters from 2.4.6.
Who recommended it?
The person from ESR that we were working with.
Why did they recommend it?
Because in their minds it hadn't significantly changed.
But there are some small differences, right?
Some small differences, yes.
And you had already done the work to calculate these new distributions for 2.5.11, right?
That work was done by ESR.
But to be clear, you could have simply started using these new distributions with these new parameters, right?
If that had been recommended to us, we would have.
You also said on direct that the reason why you didn't do this initially was because you didn't know that you had to when you had a new version of StarMix that you were implementing?
That's correct.
ESR didn't tell you that you needed to do that?
I'm not sure that they told me or not, but I did not remember, and therefore we just went ahead with our performance check.
Are you aware of whether or not the model that StarMix is implementing is different between 2.4.06 and 2.5.11?
I don't think I recall knowing that.
You're not as sure one way or the other?
No, I don't recall that.
Now, like we said, one of the goals of an internal validation study is to establish a given method's limitations.
Yes.
In the case of probabilistic genotyping, we're talking about mixture complexity, right?
That is one of the possible limitations, yes.
Mixture complexity is a sort of catch-all term for how difficult it is to determine who the contributors to a mixture are.
Yes.
More complex mixtures are more difficult to analyze than less complex mixtures.
And more equal parts mixtures as well.
So for one example, if a mixture has more contributors, that can make the mixture more complex.
That's correct.
So if you have more contributors, it can make the mixture more difficult to analyze. Doesn't always have to, but it can.
It can cause a result where deconvolution can't occur. Basically, when you have more people in a mixture, you can have situations where it cannot pull out any individual DNA profile.
But generally, mixtures with more contributors are more complex than mixtures with less contributors.
I would agree with that, yes.
Degradation is something else that can cause a mixture to be more complex.
That's correct.
Particularly if you have samples where one of your contributors is highly degraded and one of your contributors is less degraded.
That's correct.
Contributor ratios can also add to complexity.
I suppose.
Like you said earlier, if you have a bunch of contributors that are very similar in size, that can be a difficult mixture to analyze.
That's correct.
For the same reason, if you have one major contributor and then several small low-level contributors, those several small low-level contributors can also be difficult to distinguish between. Another source of complexity is total template amount.
Yes, if you have very low levels, yes.
If you have low-level mixtures, it's more difficult to analyze.
It can be impossible to analyze.
Allele sharing is another example of complexity, right?
That's correct.
Allele sharing is when contributors to a mixture have the same alleles in a given locus?
Yes.
When contributors share alleles with each other, you have an increased risk of false inclusions.
Yes.
Can we agree that related individuals share a lot of alleles with each other?
Yes.
More than, at least, just average in the general population?
Yes.
That means that relatedness is another source of complexity.
Yes.
Samples that have a lot of related contributors are more complicated to analyze than samples that don't. All other things being equal.
I don't know if I would say that they're more complicated, but you would have to factor in the relatedness issue if there was a related individual.
Can we agree that related contributors can also cause an analyst to underestimate the number of contributors?
Yes.
You're also more likely to underestimate the number of contributors when you have a low template profile, right?
Yes.
You're also more likely to underestimate the number of contributors when you have a profile with a lot of degradation.
It's possible, yes.
And obviously, if you have a profile with related contributors, low template, and a lot of degradation, that's much more difficult to analyze. That's a much more complex mixture.
It can be, yes.
When we're talking about the kinds of mixtures that your lab can reliably analyze, can we agree that one of those mixtures, or one of those limitations, is the number of contributors?
Yes.
Your lab tested 3- and 4-person mixtures in its internal validation study.
And 2-person mixtures, yes.
And 2-person mixtures. As a result, your analysts are not permitted to analyze 5- and 6-person mixtures.
That's correct.
You've established other limits as well?
Yes.
So for example, you found that when samples have a DNA concentration of less than 120 picograms per microliter, they have to be amplified again?
I believe it's lower than that number, but I cannot recall at this time.
Would it help if I were to provide you with a copy of your letter that you wrote to the court?
Yes, it would. Thank you.
Your Honor, let the record reflect that I am approaching the witness with what has been marked as State's Exhibit S2. So can you tell us what that threshold is?
That if we have results at the quantitation step, it's the second step of the DNA analysis, that we will re-amplify if it is less than essentially 12 picograms per microliter.
12 picograms.
12 picograms per microliter.
I was off by a factor of 10. And this is done to assist with determining the number of contributors.
Yes.
Because below that threshold, you see more dropout.
Yes.
You also require 5 loci as the minimum for a DNA profile interpretation?
That's correct.
Is that 5 loci per contributor or just total?
Well, it would depend, but mainly it's just total.
So if you have an electropherogram that has at least one allele and at least 5 loci, then you can analyze it.
Yes, we would use it for comparison.
Will your lab report a statistic that has a minor contributor that's less than 2% of the overall mixture?
No.
You will not do that?
Correct.
So if you have a minor contributor that has 2% or less of the overall mixture proportions, your lab will mark that as not suitable for comparison.
It's less than 2%, but yes, we will not use it for comparison.
And why was 2% chosen?
2% was chosen, which goes back to the 80-to-1 and 1-to-80 mixture ratios that we looked at, with that one part being 12 picograms, that was the lowest. And we also, for determining the percentage, we looked at the 80-to-1, the 1-to-80, 40-to-1, and the 1-to-40. And when those were run through StarMix, that minor contributor, that one-part person, the one-part contributor, was in the range of 2%, sometimes a little higher, sometimes a little lower. So our laboratory decided that 2% was the average ratio of that contributor, that we would not, that was, equal roughly to the 12 picograms that we didn't want to go under because we hadn't validated under. So that 2% is our cutoff, and if StarMix determines that a contributor is 2%, or sorry, less than 2%, then of the mixture, then we won't use it for comparison.
Now, can we agree that in casework you don't know the actual mixture proportions?
Correct.
Because you don't know the ground truth.
That's true.
So you have to rely on the mixture proportions that are calculated by StarMix.
That's true, yes.
And when you conducted your internal validation study, did you, as a part of that study, do any analysis of whether the mixture proportions calculated by StarMix are accurate?
We did not do any additional studies, no.
how the DNA quantitation step works?
The DNA quantitation step? So when we quantitate a sample, we add different reagents to the sample to sort of mimic the amplification process, which is the third step of the process. But instead of looking at the actual result from that amplification, during the quantitation step, we're trying to see how much DNA is present and how quickly the DNA that we have in a sample crosses a threshold. And that place where it crosses the threshold will be compared to a standard curve. So known amounts of DNA that have been gone through this quantitation step and are known to be certain amounts of DNA, we will generate a standard curve from that, and where our sample crosses this threshold, we will compare it to this standard curve, and we will extrapolate or determine from the standard curve points the quantitation of our sample. So we use a standard curve to compare our sample and then generate this estimated amount of DNA that's in our forensic sample.
Can you explain to me what is actually being measured in this process?
What's being measured is the amplification of one particular location of DNA that all humans have.
It's only one?
I believe it's only one, yes.
So it's not the STR loci that you were talking about earlier?
Correct.
This is a different part of the human genome than what gets measured in the third step?
That's correct.
But you're saying that every human being has exactly one of these?
Has this one location, yes.
So what you're saying then is that different people, if they give the same amount of DNA, or at least if your quantitation step measures the same amount of DNA, you should get the same output in terms of peak heights?
We can estimate from the amount of DNA in the sample what we expect to find in the DNA profile as far as peak heights. And that's why we have a cutoff, again, another threshold at the quantitation step, where if the sample doesn't have that much DNA, we won't even go forward and try it, because we know through our internal validation studies that we're not going to obtain a DNA profile that we can use.
Now, your lab also noted that, like you said on direct, for LRs of less than 3,000, you see an increase in false inclusions.
For likelihood ratios that are below 3,000.
The phrase that your lab uses, at least in its disclaimer, is adventitious match?
Yes.
Whose phrase is that?
It is a common phrase in forensic DNA analysis. I don't know who coined it, though.
You're not sure where it came from?
No, it's very common.
You also say that as the mixture's average peak height, or at least as the component's average peak height, drops below 300 RFU, Starfix's ability to distinguish between true and false contributors is diminished?
Yes. Yes.
You spoke a little bit on direct about the random match probability. And you said that one of the issues with the random match probability was that it was limited?
Yes.
Can you explain what you meant by that again?
Well, in our laboratory, we could only use it on single source profiles, or we also had something called a modified random match probability that we used on two-person profiles, that we could not distinguish one contributor's DNA profile from the other. We could put it into the equation and be able to get a statistic. So if the sample was a three-person and it was indistinguishable, we could not use that result for comparison because we didn't have a statistic for it. We could only use random match if we could draw out or separate out a major contributor's DNA profile from a three-person mixture.
That's correct. You would have an interpreted single-source profile at that point.
Correct.
You would look at the mixture and you would effectively manually deconvolute it.
Correct. We had calculations in place that would help us do that.
But then you could use the random match probability for a mixture, at least certain kinds of mixtures.
Certain kinds of mixtures, yes.
Are you aware of whether or not star mix can be used to calculate a random match probability?
I'm not aware of that.
Are you aware that the New Jersey State Police Lab uses star mix to calculate a random match probability?
No, I'm not aware of that.
Are you aware of laboratories using the 99% genotype weight as a threshold for calculating a random match probability?
No, I'm not familiar with that.
Can we agree, though, that that is a threshold that CODIS uses?
I'm not aware of that, no.
You're not aware of that? You also said on direct that in situations where you have multiple LRs that get calculated, the most conservative LR is reported?
Yes.
And the most conservative LR is the smallest one?
Is the lower one, yes.
When you say lower, do you mean lower in magnitude, like closer to 1, or just always lower? Like if it's an exclusionary LR?
If it's an exclusionary LR, it will be the one that's closest to 1.
The one that's closest to 1?
Yes.
And you consider that to be the most conservative?
I believe that is accepted, yes.
Before we finish here, I want to clarify just a couple more things. Can we agree that you're not here to offer a specific opinion on any of the evidence samples that were analyzed in this case?
That's correct.
You did not review the New Jersey State Police Lab analysis?
That's correct.
The New Jersey State Police analysis was conducted with StarMix version 2.8? You're unaware of that?
I'm unaware of that, yes.
You're also not here to offer an opinion on the Bodie evidence either?
That's correct.
You haven't technically reviewed any of the samples in this case?
That's correct.
You haven't reviewed any of the StarMix deconvolution or LR reports?
That's correct.
You're just here to testify about your laboratory?
Yes.
Nothing further, Your Honor.
Redirect.
Thank you, Your Honor. Ms. Ganem, on cross-examination, drop-in was discussed with you. Do you recall that?
Yes.
Now, drop-in is essentially contamination, isn't that right?
That's a possibility. It might also be elevated noise. We do try to separate that out by the analytical threshold. It could be another contributor as well that we're only detecting very minimally.
And you indicated that you had not seen a lot of drop-in at your lab with your tests. Is that correct?
Well, it's very hard to assess if we've seen it or not because the samples that we're looking at, we don't know the answer to. We do know the answer for proficiency test samples after we've done the test, and so we can only evaluate those, and we haven't seen any drop-in in those samples.
There was some talk about allele sharing. Do you recall that on cross?
Yes.
Now, allele sharing, whether it's fortuitous or it's due to relatedness, that's not a star mix issue. Is that right?
That's correct.
Okay. It's essentially the nature of genetics itself. Is that correct?
That's correct.
And analysts have had to deal with that prior to star mix. Is that right?
That's correct.
Now, who determines whether whether a sample is suitable for comparison with regard to, or suitable for StarMix with regard to running that through StarMix?
In my laboratory, we only run samples through StarMix if we have visually not been able to exclude an individual as being a contributor to a mixture.
But it's the analyst that makes that determination, is that right?
Correct.
Okay. And I know this has been discussed, but you don't necessarily know the weight in terms of nanograms or picograms of a minor, for example, in a mixture until the data is run through StarMix. Is that right?
Well, we don't even know it at that point. We only know the percentage of that contributor in the mixture via StarMix.
And same with ratio proportions, would that be correct also?
Yes.
It was discussed that the purpose of the internal validation is to test samples that would normally be represented in casework. Do you recall that?
Yes.
And that's accurate, right?
Yes.
Okay. Are you able to validate for every single possible scenario?
No.
And why is that?
because every sample every forensic sample is unique to itself. We try to encompass all the possible variables of ratios, mixture ratios, different amounts of template input DNA, but we can never test every single situation and scenario.
Now, is a low likelihood ratio that supports inclusion of a non-contributor, is that an error or mistake of the software?
No.
Is it essentially the result is dependent on what you would be looking at in the mixture, is that right?
Yes, if you have a partial DNA profile, you have not complete results. That can be a situation where you're including more individuals. If you have a four-person mixture where you have a lot of information, that also allows for a lot of different genotype combinations to be considered by StarMix, and that could also possibly falsely include someone.
There was some discussion both on direct and on cross of the likelihood ratio and the way it was reported out. In other words, the most conservative statistic reported out. Is that right?
Yes.
And when you say the most conservative statistic, is that in favor of the person of interest whose reference sample you're comparing it to?
Yes, that would be considered conservative.
I may have one moment, Judge. I have nothing further, Your Honor.
Brief recross, Your Honor. Sure. Can we agree that your internal validation study did not look at related contributors?
That's correct.
You spoke on redirect about visual exclusion prior to running a sample through StarMix?
That's correct.
What is your laboratory's policy on whether a sample can be visually excluded or not?
If there is evidence at not each of the loci, but at a majority of the loci that a person would be excluded given the number of contributors that we've already determined, then there's no need to put the profile through StarMix.
You need then to have a majority of the loci show that that person could not have been a contributor?
Yes, or it can be even a few loci, or possibly even one, depending on how many, the number of contributors in the mixture.
So you would possibly exclude somebody from a mixture on the basis of one locus prior to putting it into StarMix?
It's possible. It's possible.
And I apologize, this is something I didn't ask you earlier. Do you have a sense of how much money your laboratory spent purchasing the StarMix licenses?
I'm not involved in the purchasing.
So you don't know how much money the Union County Prosecutor's Office spent to purchase StarMix?
No, I don't.
To validate it?
No, I don't.
To train your analysts to use it?
I believe the training that ESR provides, I want to say it was in the range of $3,000 per person, but I believe that's the case.
But you're not generally aware of all of the money that was spent on StarMix?
That's correct.
Nothing further.
Prosecutor, anything else?
No, thank you, Your Honor.
All right, you may step down. Thank you. You can call your next witness.
The state calls Kristen Naughton. Judge, if I may step out to grab her?
Sure.
She's in the hallway.
Thank you, by the way.
Just watch your step. If you don't mind, as you come over, we could just take that exhibit away.
Yes.
And if you don't mind putting your left hand on the Bible, raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. Once you get seated and comfortable, can you state your full name for the record and spell your last name, please?
So my name is Kristen Naughton. Last name is spelled Naughton.
Thank you. Prosecutor, go ahead.
Good afternoon, Ms. Naughton.
Hi.
What do you do for a living?
I am the Director of Validation and Quality Control at Bodie Technology.
So are you essentially a research or validation scientist?
Yes, validation scientist.
Okay, and you said you're employed at Bodie Technology?
Yes.
Where is that located?
Lorton, Virginia.
And what is that Bodie Technology, essentially?
It's a private DNA testing laboratory.
When did you begin employment at Bodie?
August 2003.
Now, what are your responsibilities as the Director of Validation and Quality Control?
Yes. So I oversee two departments. The validation department performs all of our validation work at our company prior to casework operations using that technology in real casework. And then the quality control group does testing on reagents that come in our door before we use them. So if we determine a reagent is a critical reagent part of the process, that group performs quality control testing on every new lot we receive prior to it being used.
As the Director of Validation, do you have a team of scientists or validation scientists?
Yes.
Okay. Can you explain that and how that works and what it's comprised of?
Sure. So that team is responsible. They get delegated various validation projects. Our team looks at new technology or published literature to determine if there's something that our lab should be performing to help improve the types of cases that we could, the DNA results in the types of cases. So that could be anything from a DNA extraction method to, in this case, would be like a software validation.
Can you tell the court a little bit about Bodie Lab in general and the different departments?
Yeah, so the majority of our laboratory performs the casework DNA testing, and then we have support and research groups that function primarily kind of outside of that operational group. So like I said, the validation group kind of falls within one of those research groups where we look at that new technology and determine what might be applicable that we want to use in casework. Another research group develops like different types of products that might help crime scene collection and things like that.
So essentially you have the research or validation scientists and then you have the DNA analysts who process and analyze DNA.
Correct, and my group works really closely with the technical leader, which oversees the casework operations group for what we decide to validate.
I'd like to go over your educational and professional background as it relates to your profession. I'm showing counsel what's been marked as S16.
Thank you. 16, you said?
S16, Judge, yes. Ms. Naughton, I'm showing you what's been marked as S16. Do you recognize that?
Yeah, so this is my CV.
Okay. It's essentially your curriculum vitae, is that right?
Correct.
Is that, was that document created by you?
Yes.
And does that reflect your education and your training and experience?
Yes.
Okay. Can you summarize your education for us?
So I have a bachelor's degree from North Carolina State University. I have a Bachelor of Science in Biochemistry, a Bachelor of Arts in Chemistry with a minor focus in genetics.
Now you indicated that you're a validation or a research scientist. Are you considered also a DNA analyst?
So technically in our company, the DNA analyst role is defined very specifically by the FBI quality assurance standards. And those are analysts that have gone through training and authorization to perform DNA analysis on casework. So I don't fall quite under that title, but we perform all the same laboratory procedures, perform the same DNA analysis that a DNA analyst would perform. And in fact, the new technology that we validate, we then train the DNA analyst to use.
Now, in your educational background, Well, let me ask you this. Do you know whether there are certain courses that a DNA analyst is required to take in their educational training and background?
Correct. That's defined in the FBI quality assurance standards that they need to take biochemistry, molecular biology, genetics, and statistics.
Did you take those courses?
I do have those courses.
Approximately how many DNA samples have you processed and analyzed over the course of your career?
Thousands.
I want to move on to your professional experience prior to Bodie. So from the time you graduated college, it looks like in 1999, is that right?
Correct.
And then you began at Bodie on what date?
August 2003.
Okay. Prior to that, between college and when you began at Bodie, what did you do? Where did you work?
So I had a couple different positions in the research field still about DNA testing, but it wasn't necessarily focused on forensics. So some agriculture, some plant biology, and one company that was like doing medical diagnostic testing.
Okay. That brings us to 2003 when you started at Bodie. Is that right?
Correct.
Okay. When you initially began your employment at Bodie, what were you hired as? What was your title and your responsibilities?
At that time, it's called research scientist. That would be the equivalent of the validation scientist title today.
And what were your responsibilities as a research scientist?
So when I started, I was performing the laboratory work for validations. I was analyzing the data. I was writing up the validation summaries. And I was under the direction of my supervisor.
Did you do that from August of 2003 to November of 2013?
Yes.
And approximately how many validations did you perform during that time?
I would probably say average of 10 per year, so of some sort. There's various types of validations, whether it's developmental validation, internal validation, validation modifications. So probably by this point in my career, I've performed hundreds of validations.
What types of things were you validating?
Again, it varies wildly from we could get a new piece of plastic in the lab that we need to test, or a new DNA extraction, quantification method, amplification method, detection method, software.
And what were your specific responsibilities as a research scientist when you were doing these validations? Like, what specific work did you perform?
So that was performing all the laboratory techniques in the lab, creating the mock samples that we would need, or the control samples that we would use during our validation. Again, analyzing the data, interpreting the results from that, and writing up a validation summary.
Okay, now you were a research scientist doing validations until approximately, it looks like December of 2013, is that right?
That's when my title changed, but I'm still doing validations today.
Okay, so you're currently still doing validations, and your title changed in December of 2013?
Correct.
To what?
So 2013 would have changed to validation services manager. So in this role, and even prior to this, not only could I perform internal validations at Bodie, but we also provide validation services at other agencies. So a local or state laboratory could hire us to come in and help with their validation process at their lab. And so we would come in and perform the laboratory work there. We'd, again, analyze their data following their SOPs, write up the validation summary, and provide training back to that lab.
So other labs would essentially sometimes outsource their internal validations to you?
Correct.
Approximately how many validations did you conduct or did you oversee during that period between December of 2013 and September of 2016?
So I was performing even external validations as early as 2003 as well, with an average of about 2 contracts per year, so maybe a dozen or so.
Now, in October of 2016, your curriculum vitae indicates that you became the Director of Validation, Training, and Quality Control. Is that right?
Correct.
Was that considered a promotion?
Yes.
Okay. And what were your responsibilities as the director? And you touched on it before a little bit, but as the Director of Validation and then Training and Quality Control?
Yeah, so this had an extra department than I talked about previously, where it was our training department, and our training department oversees the continual growth of our employees through that progression of casework analysts. So at Bodie, we start at working in the lab, and then you progress all the way through analysis, and that time period of training could take anywhere from a year to 2 years to get through the entire process. So we had another department with staff of trainers that would provide that continual career growth training.
And then that, in January, it looks like, of 2022, what, if anything, changed with respect to your title?
The training department got their own director at that time so that they could focus on, again, the career growth, and I could focus on the validation side.
So in total, over the course of your career, approximately how many forensic DNA validations did you perform and or oversee?
Of course, I'm sorry, can you repeat that?
I'm sorry, sure. If you can estimate, approximately how many validations did you perform and or oversee in the course of your career?
Oh, the career, hundreds, yes.
Now, is there any mandatory continuing education for a validation or research scientist?
No, only technically the DNA analyst role applies to follow the quality assurance standards.
Is there anything that you do to continue your education nonetheless?
Yeah, I still attend conferences when I can. I do a lot of journal article readings, especially when it comes to a new technology. We do a lot of webinar-based learning or specific training on that new technology prior to us even developing a validation plan for testing.
Are you a member of any professional memberships?
Currently, I'm currently a member of the American Society of Crime Laboratory Directors.
What is that?
It's a professional organization for forensic laboratory management.
Now, I'm looking at your CV where it says presentations given, and there are numerous ones on here. Are you able to summarize those? Is there a common thread, or are they on different topics?
They're on a lot of different topics, but they all center around validations that I've either performed or reviewed or worked with my colleagues on.
And I see under special projects indicated Baltimore County 2022 Star Mix validations. Do you see that?
Yes.
What is that?
So that particular one was not about necessarily validating the software for that laboratory, but we went in and performed the laboratory work, meaning that we created the control samples that they then used in their validation.
Now, if you know, how long has Bodie been conducting DNA analysis?
So we were founded in 1995, and they've been doing DNA testing since then.
Is the lab accredited?
Yes.
By what organizations?
It's currently accredited by ANSI National Accreditation Board. And we are accredited to the ISO 17085 2017 standards, as well as the FBI quality assurance standards. And we follow that agency's supplemental forensic requirements as well.
I'm showing counsel what's been marked as S17 and S18.
Thank you.
I'm showing you what's been marked as S17 and then S18. Now, looking at S17, is that one page?
Yes.
Okay, and then S18 is 2 pages, is that right?
Sorry. Yes.
Okay, and what is S17?
So this is our certificate of accreditation that was issued by the ANSI National Accreditation Board, showing that we passed their audit requirements and accreditation requirements.
Okay, and is there an expiration date on that at the bottom?
Apologies.
Specifically.
Oh, I see it. Yes, April 30th, 2025.
And what is S18?
So this is this specific scope that they accredited us to, so all the different parameters of our testing that have fallen under our accreditation.
Your Honor, at this time, the state seeks to move S16, S17, and S18 to evidence.
No objection. So moved.
Now, in addition to being accredited to the 2 standards that you just indicated, the quality assurance standards and the ISO standards, does Bodie follow any guidelines?
So the SWGDAM, our scientific working group for DNA analysis methods, they have more more specifications or guidelines and clarifications that stem from the FBI quality assurance standards that we also follow.
Okay. And does the lab also have its own standard operating procedures?
Yes.
And who's responsible for creating those?
The technical leader is responsible for issuing those or approving the final versions of those. My team does help support, develop those, or edit those as needed.
With regard to ensuring that the standards that we discussed and the SWGDM guidelines are met, is your lab audited?
Yes.
Can you explain that audit process?
Yeah, so every year there is some sort of assessment done on the laboratory, whether it's an internal audit, clients visiting, different areas. It could be a remote audit of our stuff, and then every 4 years is a larger assessment where auditors would come into our laboratory, watch what's going on in the laboratory, as well as review all the documentation between the previous audit.
Okay. And now with regard specifically to your role in validations, what kinds of safeguards or standard operating procedures are used to ensure the integrity of results and the limitation of contamination and things like that?
So we follow all the same standard operating procedures that a DNA analyst would in casework, especially for a technology that is already implemented and online. So a couple of examples could be that during extraction we run a reagent blank, and that will show that the reagents and the process was free from contamination. During amplification we run a positive and negative control, again the positive control showing that the amplification product worked as expected.
With respect to validations, is there any level of review, such as peer review or a technical review?
Yes, so the validations undergo several layers of review. Usually one of our senior validation scientists does a peer review first, and then I would provide a second review and review technical content and the data. The next review would be our technical leader, that she accepts the technical information that's been presented and that it meets the quality assurance standards and other standards that we follow. And then it's also pushed to several other lab director management in our company, including the laboratory director, a senior scientist, the director of applied research, and our quality assurance manager.
Now, does Bodie use probabilistic genotyping software?
Yes.
What's the name of the software that it uses?
StarMix or SDRMix.
And what version?
We are currently using 2.5.11.
Are you in the process of getting another version?
Yeah, the version 2.9 is in the process of being validated, but we have not, that hasn't gone through final technical review or implementation for our casework to use yet.
Now, do you have a role in that validation that's currently taking place?
Yes, I assigned the project so far to a validation scientist to perform, and I reviewed the testing plan and authorized what the testing plan should be for them.
Okay, and why did the lab choose to upgrade from 2.5.11 to this current version?
There's several new features that, again, can help enhance the different feature or the different tools that we. There are new features in the software that will help us more than what we're currently using, as well as one of the main features of moving to this software that we didn't get to in between is there's a large efficiency gain on the computer hardware side of that it takes less time to run per sample.
Now, did the lab begin using StarMix in casework in 2018?
Yes.
Okay, did you have a say or a role in deciding whether ultimately to purchase StarMix?
I was involved in conversations about the options for different probabilistic genotyping software, but ultimately, because we are an outsourced lab, the decision to go with StarMix was mainly client-driven. That a lot of our clients were implementing that software.
Did you also do your own research on StarMix and the developmental validations prior to the lab purchasing it?
Yes.
Okay. And were you satisfied with those?
Yes, it had a fully published developmental validation at the time and a standardized curriculum course that you could take to learn how to use the software.
Did StarMix version 2.5.11 undergo an internal validation at your lab?
Yes.
And what was your involvement with that?
So I reviewed the validation after it was complete along with our technical leader, And together with the technical leader, we were able to develop the standard operating procedures and train subsequent DNA analysts.
Upon your review of that validation, did you find that it complied with the SWGDM guidelines for probabilistic genotyping?
Yes.
Okay. What was the time frame of that internal validation?
So we started it in 2017, and it took about a year to get all the data through analysis and the summary written up before we were able to train.
And then you went live in 2018 with that?
Correct.
In other words, you used it in casework in 2018?
I believe, yeah, at the end of 2018 would have been the first DNA analyst signed off.
Can you describe your STAR mix training?
So before the validation, the director of applied research and myself went to an ESR training, which is the manufacturer of the software. It was 4 days long. It was located in Topeka, Kansas, at a laboratory there that was hosting the training.
Once STAR mix was validated, who was responsible for training the DNA analysts at Bodie?
The technical leader and myself took that lead role.
Did they also undergo the STAR mix training that you had through ESR?
Yes, we currently still send all of our DNA analysts that are learning STAR mix to the ESR training first before they enter our internal training program.
Now, does Bodie perform DNA analysis and validations for agencies in other states as well?
Yes.
Once the internal validation of STAR mix was completed and prior to going live with it, did any outside forensic science commission or organizations have to sign off on it?
So all of our clients would have had to review our validation and accept that our standard operating procedures would meet the requirements for the data that they would accept back to their lab. We also, in particular, I would think of the New York State Department of Health reviews every validation before any case can be processed with that technology in New York. So no matter which local agency in New York, the state agency has to review and approve that validation. Most of the other states, it's down to the lab itself that has outsourced to us approving it, so it could be local, state.
In what percentage of cases does Bodie use STAR mix for?
We are probably about 50% right now on clients who would prefer us to use STAR mix over manual interpretation.
Are there certain standard operating procedures that are used as guidance to determine when you're going to use STAR mix versus manual interpretation?
Sure, so the primary decision is if that client can review and accept our data. So the client guidelines would, if their lab is not online with STAR mix yet, then we perform manual interpretation. And then secondary to that, we can review each mixture itself and determine if it's eligible or suitable for STAR mix. And then after it's run through STAR mix, we can also still decide to perform manual interpretation as well.
So certainly you would have to make the decision prior to running something through STAR mix as to whether it was suitable for STAR mix based upon your validation guidelines.
Suitable and also client approved to use.
Okay, and we'll get to the suitability shortly. Approximately how many STAR mix runs and analysis have you conducted in the course of your career?
So using the actual software myself, I've run a couple dozen samples through myself, but I've reviewed probably hundreds of analyses from STAR mix.
Judge, at this time, the state would move to qualify the witness as an expert in the field of forensic DNA analysis and forensic DNA validations.
No objection.
Okay. You'll be qualified as an expert. Go ahead.
Thank you, Your Honor. What, if any, involvement did ESR have with your internal validation?
So we did not hire them to perform our internal validation, but per our scope of service technical support, they were there to help advise us if we wanted to ask them questions or came across something that we didn't fully understand. We were asking them questions along the way to help evaluate our data.
And did they assist you with those questions?
Yes.
Because it was their software that they created, right? Now, are there essentially two parts to an internal validation process?
For STAR mix, there's the first part where you almost calibrate the software to learn what your data looks like, and then we perform the internal validation. That's very unique to the STAR mix software.
Why is it important for STAR mix to learn what the output of your instrumentation looks like. Why is that important for StarMix to know that and to have that?
So StarMix does rely on biological models, and so it needs to know what peak heights and what peak variance is expected from data specifically processed in our laboratory from our extraction procedures run on our genetic analyzers.
Is that essentially because StarMix weighs those things and factors that into its probability determinations?
Yes. And it uses those to also help determine how well an evidence sample lines up to what you observed in your validation.
Are you referring to the diagnostics?
Yes.
With that? Okay. After the two parts to your internal validation process were completed, were any documents prepared summarizing them?
Yeah, there's two separate summary documents.
And can you just explain what those are briefly?
Yeah, so there's the summary of that estimation of parameters, first step of the calibration of the software. And then the second summary is the internal validation.
Now, those document summaries, do they include every single test that was done and all of the underlying data?
So it includes a summary of all the tests that were performed, but there is a massive amount of underlying data that's included in other raw data binders that I think probably total over 50,000 pages of data.
Okay. And do you know whether in this particular case that underlying data was made available to the state and the defense?
I believe it was.
And we talked a little bit just now about the purpose of the setting of the parameters. Can you describe your lab instruments?
So we run 3,500 genetic analyzers. It's a capillary electrophoresis instrument. The particular version that we have can run 24 samples at a time per injection.
The court has already heard testimony with regard to the DNA basics and the four-step laboratory process, so I'm not going to necessarily ask you about that right now, but in a nutshell, I want to talk about the parameters. When you're running the tests to calibrate these parameters, what kinds of samples are you using?
So these would have been lab extracted samples that were used to create known template amounts to run through the laboratory process. So we would have extracted the DNA in our laboratory, quantified the amount of DNA that were in those samples, created the template amounts that we needed to calibrate or test the software, provide the software the information that we were looking for. In this particular validation, we used the globofilar amplification chemistry, and then run on the 3,500 genetic analyzer, and then we analyze the data with GeneMap or IDX software prior to it going into StarMix.
And those samples that you used, were they all single source or single donor samples for that?
For the estimation of parameters part, yes.
Where did they come from?
They're lab staff donated buccal swabs.
Now, once the parameters were determined, what was done with those parameter values?
So those were then entered into or imported into StarMix as the settings that would be used to analyze the rest of the validation samples.
Okay, is there something in StarMix called Model Maker?
Yes.
Okay, and are you familiar with that?
Yes.
Okay, what is that?
So Model Maker is a tool within StarMix that once you import your data, it looks at the peak variance, the peak height, it looks at each testing location that's within that chemistry and helps define what like a pristine sample would look like so that it has that biological model to compare back to.
And is Model Maker essentially the place in the software where these parameter values were entered into?
Model Maker, the final result of Model Maker generates some of those values that are then imported into the settings.
You mentioned that a summary of the estimation of parameters was provided after that testing was done. Do you recall that?
Correct.
Okay. I'm showing counsel what's been marked as S19. Judge, you can have it. Ms. Norton, I'm showing you S19. Do you recognize that?
Yes, this is our summary of the first part of that validation process.
All right, and is this document 33 pages approximately?
Yes.
Like here, 33? Okay. Who prepared this document?
So our validation scientist assigned to this project would have prepared it in conjunction with our director of applied research.
Is there a date on here that reflects when it was prepared?
The final draft version, or the final version that was approved is September 2018.
Looking at page 1, do you see where it lists numbers 1 through 8?
Yes.
At the bottom. What are those?
So those are the different studies that went into setting the parameters that StarMix would need.
Can you let us or tell us what those are, 1 through 8?
So sure. So the first one is analytical threshold. The second is looking at stutter ratios. The third is a size regression. 4 is allelic drop-in modeling. 5 is signal saturation. 6 is allele and stutter peak height variance. 7 is locus-specific amplification efficiency. And 8 is allele frequencies and theta values.
You've indicated that the single source samples for this came from known donors. How many single source donors or samples were there for this study, the setting up parameters?
I believe there's 132.
How much template was targeted per amplification result?
It depends on the study that you're talking about. For stutter ratios, 1 nanogram, which is our optimal amount for global filer, was targeted. And then for, let's see, some of the samples that went into Model Maker, which would be to evaluate number 6 and 7 and number 5. Those would be a variety of template amounts, all the way starting at 2 nanograms down to 25 picograms.
When you're talking about template, what is that? What are you referring to?
The amount of DNA that went into an amplification reaction.
How is that measured?
So during the process of DNA testing after extraction, we have a quantification method that can estimate how much human DNA in our sample. And then from that, we can extrapolate and do calculations for how much we are putting into the final amplification reaction.
The court has heard testimony previously about something called RFU.
Yes.
What, if any, interaction or overlap does that have with template?
So the template amount of nanograms, as that goes up, your RFU, or relative fluorescence units value off of the the genetic analyzer, should also increase.
And is the RFU correlated to the peak heights on an electropharogram?
Correct.
Now, of these 132 single source samples, did you create something called sensitivity samples?
Yes, that would be the dilutions from these samples that went from 2 nanograms down to 25 picograms.
Okay, now those were used for the second part of the validation, is that right?
No, they were used in this part as well.
As well, okay, but also for the second part of the validation?
Correct.
Okay. What was the purpose of creating these sensitivity samples, and what are they?
So as part of Model Maker, you need to teach the software to look at a variety of peak heights. So you want to see from saturated or very high RFU signal down to very little genetic information or low RFU.
How is that done?
In the lab?
Yes.
Okay, so in the lab, again, based on that quantification estimate that we have from our assay there, we can then calculate and do a serial dilution with pipetting and diluting out the product, and then adding certain amount of that into our amplification reaction, and we can control how much estimated amount of, in terms of nanograms or picograms, the amount of DNA that went into that amplification reaction.
I want to ask you whether a contamination assessment was done, but I first want to ask you, what is contamination?
So contamination is the introduction of exogenous DNA into a sample, so something that may not have originated from, in casework, like the evidence sample itself, but maybe originated from the lab or the processing.
What is the purpose of a contamination assessment?
That's to determine that you can, in this particular case, it's to determine that you can see contamination of allelic drop-in is more of the contamination that the software is looking in. So when it's not true contamination of a sample, but it could be a single peak, we call that allelic drop-in, and we want to make sure that StarMix or the software is not weighting that single peak overly confident as a true allele.
So drop-in can be a source of contamination?
In a way, yes.
And was a contamination assessment done in this validation?
Yes.
And that's what was later used to model allelic drop-in?
Correct.
Can you explain how that contamination assessment was done?
Sure. So we evaluated separate than the validation control studies that we performed. We look at actual casework. We looked at 500 reagent blanks and negative controls that were run through real casework samples. And those are controls that should have no DNA in it. So we looked at how often did we see peaks that were in those controls, again, knowing that they should not have any DNA.
How often was that?
It's less than 1%, and of that time, it was usually only a single peak up to 250 RFU that was observed.
Okay. I'd like to turn to each of the 8 lab-specific parameters and go over those with you.
Sure.
Specifically, I'm looking at page 3. The first one is analytical threshold. What is that?
So analytical threshold is the setting at which we can define that a signal coming off of the 3500 is a true allelic peak and not background noise.
What is the purpose of having an analytical threshold in the forensic DNA lab?
To be confident in that the signal that you are detecting is, again, truly allelic versus noise of the system.
Now, was analytical threshold determined here as part of this validation, or was it determined at some other time?
Yeah, that would have been determined as part of our global filer amplification chemistry validation.
And what was that analytical threshold determined to be in your lab?
125 RFU.
Okay, and again, you explained RFU, that correlates to the peak heights?
Yes.
So if there's a peak that's seen below the analytical threshold, what would be done with that?
Nothing in terms of what StarMix can see, nothing in terms of what could be contributed to a true allelic peak above analytical threshold. We do lower our peak detection threshold for looking at negatives, so we do look lower in that baseline to see if there's any contamination. So we do have the ability to kind of look below that analytical threshold visually to determine if there's other low-level genetic information there that is not above the analytical threshold.
The next parameter on page 3 is stutter ratios. What, if anything, did you do to determine that parameter?
So that was the bulk of this, the 132 samples. We went through, amplified those, targeting 1 nanogram, which again is the optimal amount for this chemistry that we used. And then we looked allele by allele at what the stutter or artifact byproduct is of that process and what ratio that is to the true allele.
Are there different types of stutter?
Yes. So there's,
find those?
Yeah, sure. There's back stutter and -1 repeat stutter. There's forward stutter. Some testing locations have half stutter.
What's the most common type?
And -1 repeat.
And can you explain what that is?
Sure. So short tandem repeats, or STRs, are multiple fragment lengths of the same repeated sequence, and the biological process of doing that with the enzyme that's in that amplification process to make those copies sometimes creates that byproduct where it'll have 1 repeat less showing up, and it's at a very defined, well-modeled percentage compared to the true allelic peak.
How does StarMix change the interpretation of stutter, if any?
So in GMapper IDX, we set a binary stutter filter, and it's well above what we have observed in validation to make sure we're not calling a stutter peak allelic. StarMix has a little bit more sophisticated biological modeling that allows not just a set stutter filter at each testing location, but it's looking fragment size by fragment size to determine what is the most best explanation of that ratio to the true allelic peak.
Are there something called stutter filters at the lab?
Yeah, so the stutter filter is applied in that GeneMapper IDX software, and again, that's set at validation of that chemistry, where we set it at kind of an artificially high threshold that we're going to make sure that we're not calling a stutter peak a true allelic peak.
When an electropharogram gets run through star mix for deconvolution, what, if anything, happens to those stutter filters, or what does the analyst do with those stutter filters?
Yeah, so the initial interpretation is made with those stutter filters on so that they can determine number of contributors and how much approximate RFU they're expecting per contributor. And then they have to reanalyze that sample with those stutter filters turned off, because StarMix uses that data in their biological modeling to help determine true allelic peaks.
Essentially, would it be fair to say that StarMix takes stutter into consideration because it has the ability to statistically weigh and account for stutter?
Yes.
And with manual interpretation, was that a different case?
It's a very binary decision, I think, because the stutter filter is set. So if it's filtered out, it can't be considered allelic. If it's in stutter position, our manual interpretation SOP still has some analyst discretion if it's just barely above for them to call it indistinguishable from stutter.
So what, if anything, did the lab do with regard to setting the parameters for stutter in this particular study?
So that was evaluating, again, all 132 of those donors, locus by locus, fragment length by fragment length, and determining what ratios we were seeing in that known data for true allelic peak height compared to the stutter ratio generated during the laboratory process.
The next, number 3, the next parameter is size regression on page 6. What is that size regression?
So size regression in StarMix is going to model if there is a decrease in peak height as the testing locations get larger in size. So if you have a degraded DNA sample, you'll tend to have larger RFU or electropherogram peaks kind of on that left-hand side of the electropherogram, and then they'll get much shorter or even drop out on the right-hand side as the fragment lengths get longer. So this size regression file that came from ESR is that mathematical algorithm that'll help predict how much RFU decrease you're going to see as you increase your fragment length of your sample.
Okay, and what was the value of that parameter, or what was done with it after testing?
So that particular file had no testing. It was just imported in from ESR. Again, it's their algorithm that they use to explain or help later in the StarMix reports. We'll see that degradation value and how that's calculated.
Okay, you mentioned degradation. What is degradation and what causes it?
So degradation is when intact DNA has been fragmented, so there may be a lot of shorter fragments that our current or amplification technology may not be able to detect larger fragments. If it's fragmented enough that you can't detect out past 300 or 400 base pairs, you may only see a partial profile. It can be caused by UV exposure, heat, moisture.
The next parameter on here, number 4, is allelic drop-in, and you did discuss drop-in, or we discussed it briefly.
Correct.
What was done to test this parameter?
So this parameter was defined by, that was us looking at those 500 casework reagent blanks and negative controls and data mining when we would call something contamination versus when we would call it allelic drop-in. If it could not be sourced from any other sample, it got designated as allelic drop-in. And yeah, those are characterized here. Again, most of the, less than 1% of the time was the value that we saw across our casework operations when it was observed, and the majority of the time was only a single peak observed, less than 250 RFU.
And is that essentially what your drop-in cap is, 250 RFU?
Correct.
What does that mean?
That's the setting where in StarMix, if it's above 250 RFU, it's going to consider it a true allelic peak and not just a drop-in peak.
The next parameter, and I'm looking at page 7 now, is signal saturation.
Yes.
What is that, and what was done to get the value for that parameter or test that?
So that was part of our sensitivity study where we went up above where our optimal DNA template amount is. And on the genetic analyzer, it uses a camera to detect fluorescence. So you can think of it kind of when you take a picture. If you take a picture pointed at the sun, you get some oversaturation of that camera where the sunlight is really bright. So that can happen in a genetic analyzer as well. If there's a lot of fluorescent signal, it's going to oversaturate the camera detection and as well as the software that analyzes that detection. So there's a cap on our 3500s that we really only see up to about 30,000 RFU, and then the signal is kind of plateau after that. That doesn't necessarily mean there's not more DNA in there, but the signal saturation from the genetic analyzer is there.
Okay, and what was the maximum, or what was the parameter that was set for that, for saturation? And again, I'm looking at page 7.
Yeah, so we saw alleles up to 30,000 RFU, but I believe we set it at 25,000 RFU where we started to see that plateau. 25,000 RFU is where we also started to see a huge increase in the number of artifacts that would occur when the camera is saturated, where it would be hard to interpret the profile.
Okay, so what would the lab do, for example, if it has a peak that is over that cap, that 25,000?
Yeah, sure. So we have a process in our laboratory that if the signal is saturated on our 3500, we can dilute that amplification product and then reload it on the genetic analyzer, and that would decrease the signal that the camera is seeing.
The next parameter, and this is specifically pages 8 through 11, allele and stutter peak height variance. What is that?
So that is going to be the information that when we put the sensitivity studies into Model Maker, the allele and peak height variance is going to be modeled by the software using that Model Maker tool that we talked about. And then it's going to provide a distribution curve of where most of the samples fall within.
Why is that important to model that?
It's good to know when you're running unknown samples how that falls against your modeling, because the software does use biological modeling. So you want to know when the evidence sample maybe does not look like what you had used during the validation.
And what specifically was done to model that and to test this particular parameter?
So this was 110 single source samples, again diluted from 2 nanograms all the way in a serial dilution at several templates across, all the way down to 25 picograms. That was run across, we have 5 genetic analyzers, so we were looking at if there's any signal differences between the 5 genetic analyzers that would cause us to need to potentially model each genetic analyzer as its own model.
When you do this testing, do you use all 5 of your genetic analyzers?
And in this particular validation, we did, yes.
Okay. The next parameter is pages 8 through 11. It's the locus-specific amplification efficiency. Can you explain what that is?
Yeah, so in GlobalFiler, there are 24 different testing locations that are amplified at the same time in the same reaction. So balancing all of those testing locations to generate approximately the same quality of product at each testing location was done by the manufacturer of the chemistry. And then this would study inherently there's always going to be like maybe one testing or a couple testing locations that perform a little less than some of the other ones. So this provides the software with what is an expected profile difference across. So you may have like lower peak heights at testing site number 1 versus higher at testing site number 4, and that's normal and how a normal sample would look.
When you say testing sites, you're talking about loci?
Loci, yeah.
Specific loci, so there could be trends that maybe an allele at this loci might be higher or lower.
Yeah.
The next, I believe it's the last, number 8 of the parameters, is the allele frequencies and theta values on page 11.
Yeah, so again, this is not data that we generated at the lab, but this is just documented what allele frequencies we use, and we use the publication from NIST.
Can you explain what allele frequencies are and how they're used, why they're important?
Yeah, so that drives the statistical weight of the profile observed. There's an independent study, a population study for each of the U.S. populations that would document how often each allele at that testing location or loci is observed in a population and determine the frequency. So that helps determine the weight of observing a specific profile compared to the weight of observing another random unrelated profile in the U.S. population.
Just turning to page 11, I'm looking at specifically S19, pages 31 to 33, Appendix 8. What specifically are we looking at here?
So those are the final settings after the whole estimation of parameters or calibration of the software was done. Those are the final settings that were applied in the software to be used throughout the remainder of the validation.
Now, once these parameters were set and optimized, did you move forward with part 2 of the validation?
Yes.
Okay, and were these parameters input into StarMix to the software?
Yeah, part of this validation would have been documenting and finalizing those settings, and those settings would not have been changed.
And now, all of this information that is in this particular summary document, the charts and the tables, etc., would they be required to be read by the DNA analysts who perform the casework prior, as part of their training, essentially?
Yes.
Okay. Turning to the validation portion of the internal validation, what is the purpose of that? Why is it conducted?
So that's to make sure that we can internally show that the formulas that are applied and the mixtures that are going to be interpreted within that software are based on known genotypes and known results are performing accurately.
Okay. And per the SWGDM guidelines, is it essential that the lab conduct testing on the types of samples that would be seen in casework?
Yeah, that's one of the requirements.
Okay. And is it possible to test every single scenario that you would see in casework?
No.
What samples were used for this portion of the validation?
So it varies. We did continue with some single source testing, and we also then did 2 to 4 person mixtures.
Okay, when you say mixtures, is that something that the lab created?
Correct.
From known donors?
Yes, correct.
Okay, and where did those donors come from?
Again, it's the lab staff that donated so that we could extract the DNA at our laboratory. And then we made those mixtures based on, again, the known quantity of those samples diluted to specific ratios that we would mix in a tube and then amplify that.
And again, that's important so that you could test StarMix and you would know whether StarMix is essentially getting it right because you know the ground truth of those mixtures. Is
Correct.
That right?
Yes.
Okay. Was all of the lab work, the 4-step lab processing of those samples to get a DNA profile, the electropharogram, was that all done at Bodie?
Yes.
And who was that done by?
Our validation scientist.
Was there any documentation, I think you mentioned it before, but was there any documentation with regard to this portion of the testing?
You mean the validation summary?
Itself, yeah.
Yeah, the validation summary itself, yes.
And again, that's just a summary of the validation?
Correct. There's separate validation binders that contain all the DNA, all the laboratory worksheets, all the calculations that were done in the lab to create those samples.
I'm showing counsel what's been marked as S147. And for the copy.
Thank you.
Ms. Norton, I'm showing you what's been marked as S147. Do you recognize that?
Yes, this is our internal validation summary.
And is there a date on here that reflects when this was finalized?
October 2018.
And is this 44 pages long?
Yes.
All right. And the way this is set up is it's outlined essentially sections A through M that outline all of the testing that was done. Is that right?
Yes.
Right, and then on pages 31 and 32, there are conclusions for each section. Is that right?
Yes.
Now, did you, I should ask you, who created this document?
So this would have been the same validation scientist and the director of applied research worked jointly on this prior to myself and the technical leader reviewing it.
Okay, and did you review this as part of your duties and responsibilities with this validation?
Yeah, and the review process is interactive where we would have comments back and they would provide feedback and corrections and update clarifications within it.
And are the DNA analysts required to read this document as well prior to their, as part of their training?
Yes.
I want to turn to page 3 of S-147. Specifically, there's a table there that says Table 1, Overview of Samples Tested for Validation of STAR Mix. Do you see that?
Yes.
And then there's A through M reflected?
Yes.
A through M, is that essentially the different testing that was done?
Yeah, each of those would have a specific reason for that section and the testing performed and across the whole validation would satisfy all of the FBI QAS requirements and the SWIG dam recommendations.
And what is the other material that's reflected in this particular chart? What is it showing?
So each section will have how many samples were used for that particular study, whether it was single source or a mixed sample, provides sample details about number of contributors, template amount that was amplified, and then it also is kind of specific to what was the point of us doing that study, where it would give us why are we performing this.
So if we could turn to section A, where it says accuracy of STAR mix interpretation and mathematical calculations. That begins on page 7.
Okay.
Can you explain what section A is and what was tested and why it was important?
Yeah, so this is essentially another sensitivity study. So the sensitivity study in biological modeling was used to determine how profiles would look. So this is now looking at that, and as you run these samples through STAR Mix to actually interpret the DNA profile, is it interpreting compared to what we expect the profile to be, and also what's the likelihood ratio that's calculated at the end compared to the known reference. So as you see less and less genetic information from a DNA profile, your likelihood ratio should decrease in strength.
And that's essentially how the likelihood ratio in STAR Mix is supposed to work, is that correct?
Yes.
Now, these particular samples that were used, the data that was used here, was this all single samples?
Single source, yes.
Single source samples, okay. And it indicates 11 samples were used from a dilution series, is that right?
Correct.
Okay. Can you explain what specifically was done with regard to these samples and the specific testing?
So sure, so in the lab prior to amplification, they would have gone through, after quantification that we knew how much DNA was in that extract, it would have gone through a serial dilution to dilute out how much amplification product we then added to the amplification reaction. So those concentrations, again, range from 2 nanogram down to 25 picograms. And yeah, as we looked at that through the genetic analyzer, we saw that majority of them could produce full profiles, and then as you get down in less than 100 picograms, you start to see potential of allelic dropout.
Looking at page 7, figure 1, where it says plot of log LR versus input DNA template RFU, do you see that?
Yes.
And what is that plot and figure reflecting?
So that's plotting the likelihood ratio. The log is basically, if you look at those numbers, 29 means 29 zeros, essentially, at the end of that statistical value. So approximately 700 RFU, you see all the same value, although that actual number could have varied a little bit within the STAR Mix report, but very minimally and comparatively to the strength of the profile. And then you start to see a decrease, and a rather sharp decrease as you start having less template RFU. So in STAR Mix, template amount is measured in peak heights, whereas in the laboratory we measure how much template goes into a reaction in amount of DNA, so nanograms. But again, those two should correlate very well.
And what, if any, conclusions were drawn with respect to this testing?
So this was when we compared statistical calculations of the likelihood ratio to manually calculating using Excel. We got the same exact value, showing that the software was accurately calculating the likelihood ratio. And then we also wanted to and did observe that as you have less genetic information, you have a lower likelihood ratio.
Okay, so you, just so I'm clear on this, you were able to manually calculate a likelihood ratio for a particular sample here.
Correct.
And compare that to the likelihood ratio that was given by StarMix.
Correct.
And how did that fare?
It was pretty identical, minus potentially some like rounding and Excel differences, minor differences.
Okay, so did it show that essentially StarMix was accurately calculating the weight of the evidence?
Correct.
Turning to page 10, section B, the effect of peak heights on interpretation. Can you explain what that is and what this study, the purpose of this study was?
Yeah, so this goes back to that camera saturation potential limit on the genetic analyzer. So when the signal of a true allelic peak is so tall that the camera is saturated, that peak may not be the true relative fluorescent units versus the camera limit of that. So then sometimes the stutter ratio is thrown off because the stutter peak is much smaller, usually less than 10% of that true peak. So that stutter peak would still be the true fluorescence unit for that peak, but you wouldn't get the expected modeling, basically, or diagnostic on your stutter ratio to that true allelic peak.
I'd like you to turn, if you could, to page 11, specifically figures 4A and 4B. What are we looking at here?
So that is two of the diagnostics that are in every StarMix report, looking at the allele variance and the stutter variance. The mountain that you see in the graph that is a distribution curve of where most of your data should fall. So if you start to see that your diagnostic value is towards the tail, like in the top graph 4A, you see that that dot of how it interpreted the data is way off to the right of the graph. That is a result of that stutter and allele the signal saturation on the 3500.
Now, the court has heard about primary diagnostics and secondary diagnostics. Which diagnostic would this be part of?
This would be secondary.
And what was the conclusion of the outcome of this testing?
That these diagnostic tools are helpful in identifying potentially that the profile is not falling within the modeled parameters.
Turning to page 12, section C, where it says intuitiveness of weights with mixtures. I believe that's pages 12 to 13. Can you explain what the purpose of this testing was?
So this is further evaluation of simple two-person mixtures. Again, checking the intuitiveness of the result.
When you say intuitiveness, I'm sorry to stop you. What do you mean by that?
So every time, even before you run StarMix, we can visually see the electropherogram or the data in GMAP or IDX. And the DNA analyst is trained to determine how many contributors, what approximate ratio am I expecting, what approximate peak heights am I expecting from each contributor. So they're going to have that base knowledge before we even run StarMix to compare to. So you want to make sure that the StarMix results are in line with what your visual interpretation of the profile is.
So essentially, with this particular study, you created a mix of two donors, is that right?
Yes.
And did you play around with the mixture proportions?
Yes.
Okay, and what specifically was the outcome of that?
So when going section by section, when the mixture is 8-to-1, visually you're going to have a very major contributor on your data, and you should be able to deconvolute or separate out which alleles belong to contributor 1 versus contributor 2. We're also looking at mixture ratios in StarMix, how close those estimates were to what we knew we put into the reaction. So an 8-to-1 would be an expected contribution of 89% and 11%, and StarMix estimated 88% and 12%, so very close to the ground truth that we knew. And then the last column in table 6 talks about how much could it how much of the genotype per contributor could it actually pull out. So again, when you have an 8-to-1 ratio, it's fairly easy to assign the genotype to each contributor. So that's kind of reflecting that from the major you could get 100% complete deduced profile, from the minor 31% complete.
And then when you get down to a 1-to-1 ratio mixture, what happens there?
Yeah, so the 50-50 mixture, star mix estimated 60-40, which again we consider fairly close to the expected ground truth. And then we expect that it should not be able to pull a profile. And I think this pulled one allele or something that probably was shared between the two donors.
Why is it more difficult to deconvolute a mixture when proportions are closer together, for example, like a 1-to-1?
Sure. So if the peak heights are all the same from both contributors, it's impossible without any other background knowledge to know which allele belongs to which contributor. So part of the continuous, fully continuous probabilistic genotyping is to utilize peak heights to inform potentially being able to determine which peaks came from one contributor versus another.
All right, we're going to take a break. We've been at this for well over 2 hours. I'll give everybody a 10-minute break and we'll start right back up.
Standing in his heels, you know. We're standing. Oh, you said it, but you don't look it. Don't worry, you look great. You're sweaty. I know.
I'm just going to step out and use the bathroom.
Yeah. It's a lot, right? A lot. Exactly. Bob. Yeah.
Were you nervous that somebody else was leaving?
No.
All right.
Got nowhere to go. Just right here.
Thank you.
No problem.
Good one, Stan. No. Are you sure? Yeah. You know what? We're just why not listening to
It's hard to sit in those chairs. They're not that comfortable.
No, they're not.
I don't know how you're sitting.
I'm new.
Great chairs. Right? And every time I move, it's like, everyone hears it.
Tested, so ranging.
Tested here.
And every time I move, it's like, everyone hears it.
What specifically was tested here and what data was used?
So this is the range of number of contributor samples that we tested, so ranging from 2 to 4, so including 2-person, 3-person, and 4 contributor mixtures, as well as a range of template amount, specifically looking at that lowest contributor amount made in the mixture.
Were you also, now you're testing sensitivity, were you also testing specificity here?
Yeah, so this is also looking at in the mixture when you potentially would include a random individual instead of the known individual, as well as possibly when the known individual does not have enough genetic information and could fall to the exclusionary support side of the likelihood ratio.
Is it essentially fair to say that in terms of sensitivity, is that the ability of the software to reliably determine the DNA profile of a known donor?
Yes.
Okay. And then on the other hand, with specificity, is that essentially the ability of the software to exclude a non-donor?
Yes.
All right. So can you explain your testing here and what those conclusions were?
So in total, there was 101 mixtures that went through this particular section of the study. Again, these were lab-created mixtures at known ratios that we knew the known donors to the mixtures. So those were run through StarMix for interpretation and then run through the statistical portion of StarMix to calculate the likelihood ratio.
Okay, and this was essentially 2, 3, and 4-person donors, is that correct?
Yes.
Okay, and I guess I should ask, with respect to the outcome of this validation, is there a limit on the number of contributors that Bodie has found in the validation for the suitability of StarMix?
Yes, if we believe the number of contributors is greater than 4 contributors to the mixture, it is not suitable for StarMix.
So essentially, what was the outcome of this testing? Can you summarize that?
Yes, so as average peak height from each contributor increased, you had a better ability to distinguish between true donors and non-donors to the mixture. And as you have less and less genetic information represented by the RFU amount of allele on that electropherogram, then the weight of the likelihood ratio tended towards 1.
And is that essentially how likelihood ratios are supposed to work and how StarMix is supposed
Correct.
to work?
A likelihood ratio of 1 is uninformative, meaning that it's equally likely that a random match could explain, or a random profile could explain the evidence versus the reference profile.
Okay. And then as you get higher than 1, that would support inclusion?
Correct.
And anything less than 1 would support exclusion?
Correct.
And does Bodie follow the SWGDM guidelines with respect to the verbal chart and equivalence for likelihood ratios?
Yes, so that was after the validation. SWGDM came out with guidelines that were defined the range that they wanted all U.S. testimony to follow for verbal scale of representing what the likelihood ratio meant.
Does Bodie have an uninformative range or an inconclusive range based on the validation?
An LR of exactly 1 is uninformative.
Okay. And then essentially Bodie would go by the SWGDM guidelines with respect to the verbal equivalent of that when testifying in court, is that right?
Correct. The SWGDM guidelines recommend not having an inconclusive range, but reporting the LR as it is with the verbal scale equivalency of how much support that is.
I'd ask you to turn to page 14 here where it says figure series 6. Do you see that?
Yes.
And there's 6A, B, and C.
Yes.
What does this reflect?
So these are the likelihood ratios from those 101 interpretations for the known donor. So the red dots would represent the true known donors to the mixture, and the blue dots are 500 randomly simulated profiles that were searched and compared to the profile.
Okay. And based upon your testing here and your review of the validation, how did StarMix fare with respect to this testing?
It performed as expected, meaning that, again, as less and less genetic information was available, the chance of an adventitious match to another genetic profile was increased. There's a summary in our appendix of the exact values when a known donor to the mixture fell below 1 or supported support for exclusion, and then the same for the random generated DNA profiles for when they went above 1.
Okay. Are you talking about false inclusions and false exclusions, essentially?
Yes. Mm-hmm.
Okay. The false inclusions and false exclusions, is that you indicate that's documented in this summary?
Yes, it's in appendix.
Is that appendix 4?
Yes.
And is that on pages 41 to 42?
Yes.
We could turn to those pages for a moment. Sure. I'd like to ask you some questions. What was the highest likelihood ratio here supporting inclusion of a non-donor in each category?
So the highest in the 2-person, sorry, can you repeat your?
I'm sorry, what was the highest likelihood ratio here supporting inclusion of a non-donor for each of the categories, like a 2-person, 3-person, 4-person mixture?
Okay, so sure, that would be the false positives per se, and the highest in a 2-person is a likelihood ratio of 2.6982. In the 3-person...
Let me just stop you for a second. What would the verbal equivalent of that be?
I don't have that table in front of me, but I think it's limited support.
Oh, I can actually show that.
Sure.
I'm sorry, Judge, if I may just have one moment.
Sure.
I'll come back to that question.
Okay.
Thank you. All right, I'm sorry, so you indicated the highest likelihood ratio supporting inclusion of a non-donor, specifically for a 2-person mixture, and that was a 2.6 something?
Yes, that's the log likelihood ratio, yes.
Okay, and then how about the 3-person mixtures?
So the log likelihood ratio is 1.6326 for 3-person.
And what about a 4-person mixture?
2.1592.
Now, in this particular section, Section D, what was the lowest percentage of a minor contributor to a mixture that is seen in this study, or in this summary?
I'm sorry, can you repeat that one?
Sure. And essentially, I can refer you to pages 36 and 37, Appendix 2, and I'll ask the question again. So in this particular section, Section D, what is the lowest percentage of a minor contributor to a mixture that was calculated here?
It's approximately 5%. I believe the 20 to 1 actually comes out to 4.7%.
Okay, and so what was the lowest amount of DNA of a minor contributor in this particular section in terms of weight, picograms?
So the theoretical calculated based on the quantification estimate of our assay is 25 picograms.
Okay. And you testified earlier that these validation summaries are just that, they're summaries. Were any samples tested in this particular section, so Section D, that are not reflected in the summary where the minor contributor to a mixture was lower than 5% and or lower than 25 picograms?
So in this section D, while the theoretical value was intended to be 5%, StarMix estimated it at 3% of the mixture.
Okay. How about any other sections? Were there other sections of testing done where the minor was less than 5% of the mixture and or less than 25 picograms?
So sure. So there's another section coming up later in the validation that we'll talk about, which is our mock evidence samples. So these are samples that we did not intentionally create known mixture ratios versus take mock evidence item and run that through the laboratory and process that.
And did you also do something called N+1 testing?
Yes. So another section in here looks at if you were to estimate the number of contributors incorrectly, what's the impact of estimating one contributor higher and one contributor lower than the true value?
Okay, now aside from the N+1 testing, were you asked to summarize the 3 samples, so section D and the samples in section L, were you asked to summarize those and put them in a letter, and specifically the samples where the minor was below 5% and or 25 picograms?
Yes.
I'm showing counsel what's been marked as S20. Andy, word a copy of S20.
Thank you.
Ms. Naughton, I'm showing you S20. What is that? Sorry.
So this is a memo I wrote after looking again at that data package that we've provided that has the 50,000 pages. There's more information in that than what was summarized. The samples themselves are summarized in this, but we were able to look more specifically at different pieces of those reports. And this summarizes 3 of those samples.
Okay, let's talk about the first sample on page 1 of your letter. Yes. That's summarized. And that looks like a 1.
Objection, Your Honor. May we approach?
Sure. That is up to them and where we were, but we're all over the case and allow this information to be testified to. When your objections noted for the record. Of course you can.
I very specifically said that September
At that point through the summer, every month you thought that you were going to be done by the end of that particular month with the analysis, and it was just never done. So it's nobody's fault. I don't blame you in any regard. But I'm not going to lose the state from being able to testify as to this information, considering it goes to whether ultimately, in this court's mind, whether it's reliable or not. You know, the weight of the evidence obviously will be different if you would get to that point in the trial. You can make your arguments at that point, but as of right now, I'm going to allow it in. So your objection is noted for the record.
Ms. Naughton, I'm going to ask you if you can look at page 1 of the letter, and that letter was something that was provided by you, is that correct?
Yes.
And is that dated April 26, 2024?
Yes.
And is that 2 pages?
Yes.
Okay. On page 1, do you see down here where you have summary of contributors?
Yes.
What essentially is this information that you're including in this letter here?
So this is a screenshot from the STR mixed deconvolution report for this particular sample that was in section D of our validation study.
And where does this come from? Does it come from a summary, the underlying data, or something else?
So it's the underlying data. It's the report that STAR Mix generates at the end of its run. For how it interpreted the mixture. This portion has nothing to do with a likelihood ratio calculation at this point. It's just about the interpretation of the DNA profile.
So essentially in section D, is this a 4-person mixture?
Yes.
And is the mixture ratio here a 10 to 5 to 2 to 1?
Correct.
What is the lowest donor estimated to be in terms of percent?
It's around 5% based on the theoretical mixture ratio.
Okay. Now I'm looking at where you have, you see where you have template RFU?
In that summary of contributor screenshot?
Mm-hmm.
Yes.
Okay. And you have 1, 2, 3, and 4 as the contributors?
Correct.
Which is the most minor contributor, 1, 2, 3, or 4?
Contributor 4.
Okay. And what does the mixture proportion say under contributor 4?
3%.
It's 3%, okay. And then underneath that is the degradation statistic, is that right?
Correct.
Was there an electrophoregram that was provided with respect to this underlying sample?
Yes, it can be found in our validation data binder.
Okay. Showing the defense what's been marked as S155. Can I handle copies of the report? Please note I'm showing you what's marked as 155, S155. What is that?
So this is the DNA profile electrophoregram that comes out of that GeneMapper IDX software.
Okay. And how do we know that this electrophoregram is related to this particular sample that you put in your letter on page 1?
So it would be more or less the sample name, which is in the header, kind of above the first red boxes that say mix 10_5_2_1. It's very small print.
And just so I'm clear, the estimated amount of contribution of contributor number 4 here, so the most minor, what is that reflected as in the deconvolution report?
So in this particular amplification, it was targeted at 100 picograms.
Okay. But the percentage of contribution, what was that for the most minor?
Was targeted at 5%, but StarMix estimates it at 3%.
Okay. There are certain alleles on this electrophoregram that are highlighted. Who highlighted those?
I did.
Okay. What was the purpose of highlighting those?
So we know the genetic profile of contributor 4, so I was demonstrating that even at a 3% mixture in this particular profile, that donor's profile is highly represented throughout the profile.
Ms. Wallace, this is the last question on this area because I'd like to expand the record on what we just did at sidebar.
I can make it the last question, Judge.
Okay. I'm going to ask for you to step down. You're going to have to be back here for your sake, sorry. But tomorrow at 9 o'clock, we're going to start right at 9 o'clock. So if you don't mind, I would appreciate that.
Yes,
between now and tomorrow morning, you're not allowed to, other than logistical maybe issues, you can't talk to the prosecutor's office about anything that's going on here today. You're under oath. Don't talk to anybody else about what's going on with this. You'll just be back tomorrow morning, 9 o'clock, okay?
Okay.
All right, thank you. There was an objection that was placed on the record that I want to flesh out in a little bit more detail so that the record is abundantly clear as to where we are. So the documents that were just, I'm asking you, Ms. Wallace, the documents that this witness is referring to, the 50,000 pages and the items that were turned over, when were they turned over and discovered?
The underlying data was turned over.
Sorry, excuse me. I have these in my hand.
May I grab those?
Judge, I can tell you that there were 2 separate disclosures because initially what we received from Bodie were 2 separate PDF documents that were not searchable. They were around, I believe, 50,000 pages. We then requested that they send us the data in a usable format, and on June 20th, that's when we received the actual file system that was used for the internal validation study that actually had all of the individual deconvolution reports separated and organized like they are in the internal validation study. It's my position that the initial 2 PDF documents were unusable, and it's, I'm not going to suggest that it was intentional, but it sure doesn't seem unintentional.
So that means that you're saying it's intentional, which I have concern. I want you to be careful with using those types of words. And all I asked was a specific question. I wanted to know when the discovery was turned over. You're saying that that it was turned over, and the original documents that were turned over, you were not able to read until they sent it in a different format. Prosecutor, I don't care. Ms. Wallace, Mr. Decker, I don't care. Or one of you. I just want to make sure that the record is abundantly clear as to this. Obviously, this letter comes out on April 26th of 2024. I'm trying to find out, number one, what precipitated this letter, and number two, what is the discovery that we're talking about, and when was it turned over, so that it's clear as to how much time the defense had it, and what they did or didn't do with it is up to them.
Understood, Judge. I think we received, Bodie put everything, all the data underlying their validation. They put it on an FTP site, gave us the username, password on May 22nd, 2024. I believe I shared it that day. I'd have to double check. Maybe the next day. I think when I didn't know what was in that site, to be honest, until we gave it to them. I'm sure they looked at it before we did. I know at some point they didn't like the format, and I don't mean Mr. Code, I assume it's his experts, didn't like the format that it was in, and then asked for certain things. Like every time in this case, we then went to our experts, or we went to StarMix or ESR, and we said, this is what they asked for, tell us yes or no, and whatever. So they wound up giving some additional data, and I'll take Mr. Godin's word for it as to whatever that date was.
So here's the thing, Mr. Decker. I'm not here to take anyone's word. I'm here to know whatever the truth is. So here's what I'm going to ask you to do. Tonight, I want you to take a look at it. I want the record to be abundantly clear as to when these items were turned over. Mr. Godin just made an allegation against the prosecutor's office that sit down, Mr. Godin.
Not the prosecutor's office, Your Honor.
Well, it doesn't matter to me. It's the way that you just said it on the record. We're going to make sure it's clear, because if there is an issue, and whether it's StarMix or somebody else, I'm going to get to the bottom of it during this hearing. Mr. Decker, so I'm going to ask between you and Ms. Wallace, I want to know when these items were turned over. I want to know the formats of how they were originally turned over, how it was changed, what the significance was as far as you knew it, and we're going to flesh this out tomorrow morning at 9 o'clock before we continue on with the testimony of this particular witness. So, Mr. Caneiro, you're going to be brought back downstairs, and we'll start back up tomorrow morning. Please make sure that you're ready to go, because we're going to start right at 9 o'clock. So everyone, please be prepared to be ready to start right at 9 o'clock. I'll address any other issues at 9 o'clock tomorrow morning. Thank you.
Thank you, Judge.
Thank you.
Wow. So that was it. Here, I thought this was going to go for another hour. Yeah, that's it. I thought this was going to go for another hour. Holy smokes. So 2:30. All right. So that cuts down our day by at least another hour, which is not a bad thing. Yeah. So basically they're bringing in, all right, here's the recap that I was able to figure out so far. Obviously, we still need tomorrow. We still need to hear, tomorrow in their world, not for us. So the prosecution wants to bring in DNA testing from StarMix, which tests very minute cells, particles, DNA, whatever. I guess DNA would be the best word. And the defense says no. It's more like theoretical, or what is it? It's Hold on a sec. It involves probabilistic evidence. So the defense, it's based on statistical modeling. So it's not just direct DNA. Like we've seen enough trials now where you have DNA, you put it in the in the centrifuge, they put it in the oven, the easy bake oven, all that stuff. Here, I should not be covering. I don't want to I shouldn't be covering them. You put it in the easy bake oven and out pops your results. So apparently Star Mix, which has been around since around 2012, they go more for minute, low level and mixed DNA samples. So using Star Mix, it's a new technology, and I was on their website. Here, we can check out their website real quick. You see Star Mix. Starmix.com. All right, here's their website. See if I can. Okay, yep, accept all cookies. Come on. All right, hold on. All right, can I scroll through there? All right, just give me a second. All right, so here's Star Mix's website. Go over here. So here's their website. Right, so they're New Zealand based. So they're New Zealand based. Oh, here, let's see if we know let's watch this. So I turned the volume down because we'll probably get smacked for that audio. Tayo Toys, you're going to be in the still photographer pool for the au pair IRS agent. Oh, man. That's going to be the 12th. I don't know if we're going to be able to cover that because we're going to be in this trial. That's going to be a tough one. That's going to be a good trial, too. So they say that the majority of their it's based on statistical what is it? Statistical probability? No, what do they call it? Probabilistic genotyping software. So that's Star Mix. So it's low-level mixed DNA samples that were originally considered unsuitable for traditional DNA analysis. And the defense is saying Star Mix relies on statistical modeling, not direct DNA identification. So it'll be interesting to see what the judge rules. I did not see a ruling. He must have ruled. So he must have ruled on this. Let me just get out of here. So this is what that's hard to read. All right, let me just get out of here. All right, so that's what's being argued right now. That's what's being argued right now. So we'll go back to the next hearing, which is the day after. All right, let's see what this is about. Let's see if they sort it out. All right, Abe, direct DNA identification also relies on statistical modeling. You can't do it without it. I wonder if StarMix uses AI technology. They've been around since 2012. Hold on. About Us. Yeah, it's been developed by New Zealand government-owned research. Here's StarMix. Resolves more DNA mixtures. I found where they've helped like hundreds of thousands of cases, I should say. So what can it do? With an ever-growing range of functions underpinned by world-leading statistical and biological modeling, StarMix enables forensic biologists to, and then this whole thing, resolve mixed DNA profiles without reference to known contributors, enter a contributor number range when performing. Oh, William, thank you. W. Williamson, thank you for the cups of coffee. Appreciate that. Compare references. So it seems like the biggest thing is you don't need a known contributor. So that's kind of big, right? It's mostly for identifying DNA out of mixture samples. Yeah, out of mixed samples. Right? To me, it seems like you don't have a known contributor. That's pretty big. You can compare reference DNA profiles to single source and mixed DNA profiles, like Abe, what you're saying right there. That seems. Oh, and they've been talking. We heard a lot of word of. Listen to me stutter. We heard a lot of talk about stutter so far. Model any type of stutter observed within your STR profiling kit, now including improved dropout modeling, allowing analysis of DNA profiles with a low or even no analytical threshold. Combine multiple amplifications of the same DNA extract into one interpretation, even when generated with different multiplexes. Search a deconvoluted DNA profile directly against the database without the need to interpret a single source component. So that, to me, seems like what the sticking point is here. That they don't have a known contributor, and you can interpret it without the need for a single source, which, Abe, is what you're saying again with the mixed samples. So I can see why the defense wants it out, and I can see why the state wants it in. Now, I don't know if we heard yet, but there was bloody clothes found in Paul's, I think, basement or something, and the DNA came back to Sophia, who's the little girl, little 8-year-old. So I guess they were able to get DNA off of that. I guess that's one of the reasons why they're arguing. All right, let's get back to this. Cover that up. And all right, so this is from the following day, which is November 14th. So let me just pin that. So this is a hearing. Actually, it's a Daubert hearing. Daubert hearing from November, what did I say, 14th? 14th, 2024. So it's essentially, I think, play on crime. You said it. What is this? A voir dire? It is kind of like a voir dire in a sense. They're just trying to figure out should this be allowed in. So it is kind of like a voir dire, sort of. I know we've seen Daubert hearings before, in the sense of Karen Reed specifically with several of their witnesses. You know, are they going to be allowed in to testify? And if so, how much are they going to be allowed in to testify? All right, so this is continuation of the hearing from the 13th of November, 2024.
Talk about it on the other end now. So once you have a deconvolution report, what does the analyst do in terms of analyzing that?
The first thing that we do is we look at the diagnostics and both the secondary diagnostics as well as the primary diagnostics. So primary, basically, we look at the deconvolution and look at it compared to the electropherogram. Does this make sense? Is this intuitive to what?
I'm going to ask you, what do you mean by that? Makes sense, intuitive?
Like if you say I have a very high peak for one contributor that's way higher than the other, say 15-15 at one location. And the decon says it's that the first contributor is like a 14-13. And it wouldn't make sense because you have a big 15-15 there. So you have to look at the data that you have from the electropherogram, because that's the data that you're analyzing. And you have to look to see if the decisions made by StarMix make sense.
What other things are you looking at on the deconvolution report?
We're looking at the diagnostics to make sure that everything is indicated to have run properly. So if we we input the number of contributors into the software. So if we were to put the wrong number of contributors in, or if we had left in an artifact or something that wasn't real, the diagnostics would kind of let us know that something's amok.
So once you have your deconvolution report and you see the percentage of contributors, is there any sort of blanket rule where if you see a contributor below a certain percent that you would not run a comparison for that?
No, ours isn't. Our SOP does not account for percent. Ours accounts for each contributor has to be represented unambiguously, meaning it's not in the stutter position. At least 3 locations. So we have to be sure that it's a foreign allele at more than three or more locations for that contributor to be considered suitable for interpretation.
We're going to be looking at many deconvolution reports momentarily, but can you just explain how within a deconvolution report the contributors, if it's a mixture, are separated out?
The software is basically trying to figure out what the best explanation of the data is. So if we told the software that there's 2 contributors in there, they're looking at the peak heights of the DNA profile of the contributors that are in there and try to make the sense of which ones belong to which ones. So it'll say, this is what we think are the best choices for contributor 1. These are the ones that make the most sense. And each genotype combination is given a weight. So that weight helps you determine how likely it is that's the correct answer.
And do the slots or contributor positions, for example, number 1, number 2, correlate to anything else that's estimated by StarMix?
It's usually when there's no conditioning, which I can go into what that is if you want, but we didn't condition in this case. But if you're not conditioning on an individual, then the contributor 1 position is the one who's contributing the largest estimated amount of DNA, and then contributor 2 is the next spot down, and then so forth.
Now, if you did contribute or contribution, would that be, where would that person go? Would they always be in the number 1 slot?
Yes, the conditioned individual is always just automatically assigned the number 1 spot by the software, regardless of whether they contributed 5% or 95%.
All right, so in terms of further analysis of the deconvolution report, so once you have your deconvolution report, what, if anything, do you do with that report visually?
Once we have established that we think that the run is a good, valid, intuitive run, then if we have any references, that's when we will make any comparisons from the reference to the deconvolution report.
And when you say comparisons, is that something that's done visually first?
Yes.
Can you explain that?
So basically, I'll take a reference profile and I will go location by location for each of the contributors that were deemed suitable for interpretation. And I'll say, is it possible that this person is here at this location? And go location by location to see if it's possible that that person is there. And if there's something that is saying, it's not possible for this person to be there, then we will say we have a visual exclusion. It's not possible for them to be there.
And if you have a visual exclusion, then obviously you don't run them through StarMix, right?
Right, you don't run them through StarMix.
If you can't visually exclude a reference sample, how specifically would you run a comparison of that sample to the deconvoluted profiles?
So we take the deconvolution that was done by StarMix, and we basically drag that back into StarMix, and then we drag a reference profile into the software, and then it will do a comparison and generate a likelihood ratio on how likely it is that this person is included or excluded.
Can you explain a likelihood ratio and what that is?
The likelihood ratio is basically it's looking at two different propositions or hypotheses. So it's the likelihood that this DNA profile is from this person, and however other many, like so where, say for this example, the mixture is 3. So it's that the person of interest is the contributor of the profile and 2 other individuals, unknown, unrelated individuals, versus it not being that person and it being from 3 unknown, unrelated individuals.
And can you talk a little bit about what would support, the numbers that would support an inclusion or an exclusion or inconclusive?
We have a verbal chart that we use that was created by SWGNAM, which is the governing body of DNA analysis. So basically a LR of 1 is uninformative. Anything above 1 is support for inclusion or exclusion depending on what the stat is. And then they go up and from basically limited support, moderate support, strong support, very strong support, depending on how big the number is.
In casework, in addition to the reports generated by StarMix, so the deconvolution reports and or likelihood ratio reports, do you as the analyst also write a report of your conclusions and analyses?
Yes, I do.
Okay. And you indicated that those reports would be subject to multiple layers of review.
Yes.
Was all of your work reviewed in this particular case?
Yes, it was.
All right, turning to this case, were you assigned to perform DNA testing on certain items of evidence relating to State of New Jersey versus Paul Caneiro?
Yes, I was.
On June 18th of 2020, did Bodie receive items from the prosecutor's office in Monmouth County relating to this case?
Yes.
Do you recall what those items were?
There was a pair of pants, I think 6 sets of gloves, and some swabs from the scene.
Was there also a knife that was...
A knife, yes.
Taken
I forgot
to...
about the knife, yes.
All right, and there was 6 latex gloves?
Yes.
Okay. Just prior to receiving those items, on June 4th of 2020, what, if anything else, did Bodie receive from the prosecutor's office with regard to this case?
We received already developed profiles for Jesse, Jennifer, Sophia, Paul, and Keith Caneiro.
Now, did you in fact perform DNA analysis on the items that were received on June 18th of 2020?
No, we only received the completed profiles.
Okay, but not the reference samples, but the indicated pair of hands and all of that.
Sorry.
Okay.
Yes.
Of those items that you performed the DNA analysis on, did you utilize StarMix?
On some of them, yes.
Do you recall how many samples you utilized StarMix for?
13, I believe.
Okay, and then for another sample, did you use manual interpretation?
I did.
And why was that, if you recall?
StarMix did not give an intuitive answer when we used the software. So because of that, this is where it's important that we can still go back and do manual interpretation.
And then for another sample, was there in fact too little data to even run?
Yes.
Okay, so no conclusions were made on that. Okay, so we're dealing with 13 samples that StarMix was used for.
Correct.
With regard to all of those aforementioned items, did you write a report?
I did.
Showing counsel what's been marked as S23. Your Honor, S23. Ms. Reed, I'm showing you S23. Do you recognize that?
Your name or mine.
Oh, I'm sorry. That's mine. Yes, sorry. I think that's maybe too.
Yeah, here you go.
Thank you.
Yes, this is my report.
I'm sorry, what was the S number?
I'm sorry, Judge?
What's the exhibit number?
Oh, this was
23.
Yes, 23. Okay. This report is dated November 19th of 2021?
Yes, it is.
Okay. And is this report 9 pages?
Yes, it is.
Now, the first page, is that essentially a review form?
Yes.
And what is that? What is that for?
This is where we record when review was done and both the self-review as well as technical and admin review. And we record where we have done, we call it Bodie Match. It's basically a software program that we use to ensure that the sample does not hit any known contaminants, anybody from the staff,
or any other samples that it was processed with.
Okay, and are there signatures on the front of that page or initials?
Yes.
Okay, and does that indicate that all of that was completed, all of that review?
Yes.
Okay. I kind of want to go through the structure of your report first, just so we can understand what we're looking at. Page 1 of your report, so if you flip over to page, it says 1 of 9. That has the Bodie case number on it?
Yes.
And is that CCA 2076-0119?
Yes.
Okay, and it has an agency case number?
Yes.
And is that MCP 1800780?
Yes, it is.
And then under that, you see where it says victims?
Yes.
Okay, and whose names are there?
Jennifer Caneiro, Jesse Caneiro, Sophia Caneiro, and Keith Caneiro.
Okay, and then suspects?
Is Paul Caneiro.
Okay, are those the 5 individuals that you received reference samples for?
Yes, they are.
Okay, now on page 2, you flip over to page 2, where it says DNA profiles received. You have next to each individual's name, you have a number. So for example, 1 is Jennifer Caneiro. You see that?
Yes.
Okay, and what are those numbers in reference to, the 1 through 4 and then the 20?
Those were the numbers that were assigned by whoever processed them externally.
Okay. I want to ask you to flip over now to page 5. I'm sorry, not page 5. It's actually going to be page 9. Page 9 of the report. You'll see that there's a chart here. What is that we're looking at?
Those are the profiles from the victims and the suspect that were provided to us.
So these are the allele charts from each of the victims and suspect?
Yes.
And then I'm going to ask you now just to turn back to that page, not the very first page, but the first page of your report, where it has the Bodie case number on it. All right, do you see this is a list of evidence here?
Yes.
Okay, and then that spills over onto page 2, is that right?
Correct.
And then on page 2, you have STR processing, results, conclusions, and statistics, is that right?
Yes.
Then that goes over onto page 3, is that correct?
Yes.
And then you have some notes, and those go over onto page 4, is that right?
Correct.
And then on page 4, you have where it says likelihood ratio, support, qualifying statement. You see that?
Yes.
And then page 5, there's a chart there. What is that?
That's a summary, a chart that we use in instances where we have a lot of samples. We create a chart that will summarize my results.
So that chart reflects the 13 samples and the results that were utilized with StarMix?
Yes.
Okay. Now, in addition to receiving this evidence, specifically you indicate the pair of pants and the gloves and the knife and the swabs on June 18th of 2020, were other items of evidence later received by Bodie from the prosecutor's office, specifically in February of 2021?
Yes.
Was DNA analysis performed on those?
Yes.
Okay. Now, on those, you did not utilize StarMix, is that correct?
Correct.
That is not the subject of this hearing?
Yes.
I'd like to go over on page 1, just so we understand how the evidence is delineated. Looking at first, under Bodie's sample name, you have EO1. Do you see that?
Yes.
What does EO1 correlate to?
EO1 correlates to the pair of genes.
Okay. And then you have an A, B, and a C. What is the A?
A is the interior thigh above the knee.
What about the B?
Interior waistband.
And the C?
Area 1, which was exterior front right thigh with red-brown staining.
Okay. Now, for samples A and C, is it fair to say that StarMix was used?
A and C, yes.
And for B, was StarMix used?
No, it was not.
Okay. Now we move on to sample EO2. EO2 through EO7. Are those essentially 6 pairs of black latex gloves?
They are 6
gloves.
6 gloves. Yeah, not pairs, 6 gloves.
So with each glove, so you have 6 altogether, EO2 through EO7. And then under each one, you have an A and a B. Do you see that?
Yes.
For each one, does A reflect what is deemed the exterior of the glove?
Yes.
And does the B reflect what is deemed the interior of the glove?
Yes, it does.
And then you have EO8 What is that?
That is the Microtech Ultratech D double edge automatic knife.
Okay, and there's a note, note number 8 on page 3 that indicates that that was inventory but not further examined. Is that right?
That is correct, yes.
So we're not dealing with that in this particular hearing. Then you have EO9. What is that?
This is AMB swab, DNA swab of reddish stain from the south side of the kitchen island.
Okay. How about E10?
AMC swab, DNA swab of reddish stain from the lower kitchen cabinet.
And how about E11?
AMD swab, DNA swab of reddish stain from the pull-out drawer just below the sink.
Okay, for each of those swabs for 9, 10, and 11, was star mix utilized?
Yes, they were.
Okay, and specifically, is that what you received or swabs from the prosecutor's office?
Yes, it was.
I'd like you to turn to page 2, if you could, of your report. There's some terminology there that we're ultimately going to see in table 1 that I'd like to go over with you.
Okay.
I'm looking at 5A, where it says assumed number of contributors. Do you see that?
Yes.
How is that defined?
The assumed number of contributors is when I'm doing my analysis. Prior to doing star mix, I do my best to determine, based on the evidence or the profile that we have, the number of contributors that are present in the profile.
And then do you see 5B?
Yes.
Suitable contributors. How is that defined?
It is the contributors that are suitable for comparison in the mixture obtained. Any contributors not listed are not suitable for comparisons due to limited data obtained.
Okay, and what makes them suitable for comparison?
They have to have that at least 3 unambiguous alleles.
How about 5C, combination possible?
It refers to the possibility of any included references all being present together in the sample at the same time.
Okay, and how about 5D, visually excluded?
Refers to exclusions of compared references from the interpretable portions or suitable portions of the mixture obtained.
Okay, and then 5E and 5F.
So this is where this is the statement that we would use to state the statistic. And for an inclusion, it would be assuming a mixture of N individuals, which is the number of contributors. This mixture DNA profile obtained is at least this number times more likely if it originated from this reference and N minus 1. So if there's 3 individuals, it would be 2 there. Unknown, unrelated contributors, then from N, unknown, unrelated contributors. And N equals the total number of contributors.
And then on page 4 of 9, is there a verbal chart there with a qualifying statement for the likelihood ratios?
Yes, there is.
Can you just take us through that?
Yes. So a LR of 1 is considered to be uninformative. Greater than 1 and less than 100 is limited support. 100 through less than 10,000 is moderate support. 10,000 to a million is strong support. And a million above, equal to and greater than a million is very strong support.
Now, when you testify in court as a DNA analyst to your results, is this essentially the chart that is used and the language that is used for star mix samples?
Yes, it is.
I'd like to deal with the 2 samples that were not subject to star mix just briefly. And I'm looking at EO1B, which is the jeans interior waistband.
Yes.
Can you explain what was done with that?
So a DNA profile was obtained. It was partial and it was too low level. Too limited data was obtained, so no conclusions could be made on the partial profile.
Okay. And is there a note on note 10 on page 4 regarding this as well?
Yes.
Okay, and what does that note reflect?
It says, for sample EO1B, the profile greater than analytical threshold gives the appearance of being a single source contributor. However, because of alleles seen below threshold and the possible sharing of alleles with the minor observed below analytical threshold, this profile was reported as a mixture and deemed inconclusive for interpretation.
So essentially, is this an example of how a DNA analyst would look at an electropherogram and deem it not suitable for star mix?
Yes, it is.
I'd like to turn to EO2A in your report.
The DNA profile obtained from EO2A is consistent with a mixture of 2 individuals, including a major female contributor. This deduced major component matches the DNA profile obtained from Sophia Caneiro. And the probability of randomly selecting an unrelated individual with his DNA profile is at least 1 in 14 octillion. And all of the other references submitted were excluded as being possible contributors of the major components.
Okay, and why was this sample, why did you use manual interpretation in star mix?
So we used star mix, and I put in it being as a mixture of 2, and when star mix interpreted it tried to force, there wasn't enough data for the second contributor, so it kind of wanted to split up contributor 1 and contributor 2, like the DNA, into 2 separate contributors. So it wasn't intuitive. With the major contributor, we're expecting the contribution percentage to be above 75% for the major, and it was much more equal on the deconvolutions. That wasn't intuitive.
Is this essentially an example of how an analyst would have to analyze something now on the back end? So after you get a deconvolution report, like we spoke about before, if it doesn't deconvolute properly, if there's something unintuitive about it, you would use manual interpretation, or you would not proceed further with star mix.
That's correct, yes.
Now, did you also, is there also a case note with regard to this particular sample?
Yes, there is. It's not in this report, but
all right, I'm going to show it to you. And why is there a case note? Why was more documented about this?
Because we want to document why it didn't work, to show that we did try it, and this is the reason why we chose to interpret manually and not report the results that were obtained from star mix.
Were there also electrophorograms run, obviously, in this particular case as well? I'm showing counsel what's been marked as S27 for sample 2A. And then S29, which is the case note. And your statistic, was that also reported out on something called Population Statistics Global Filer?
Yes.
And I'm showing counsel what's been marked as S28. Maybe get the jump copies of the same. Mislead. Okay. I'm handing you what's been marked as S27. What is that?
That is the electropherogram for sample EO2A.
Okay, and how about S28? What is that?
That is the statistics workbook for that same sample.
For sample 2A?
Yes.
And again, what is that statistic?
That is the random match probability statistic that was performed for the major component.
Okay, and what was the outcome of that? What is that statistic?
That was the 1 in 14 octillion in the U.S. population.
As to which?
To Sophia.
To Sophia,
yes.
Okay, and I'm showing you what's been marked as S29. Do you recognize that?
Yes, that's the case note.
And what does that case note reflect?
The case note states that sample EO2 was determined to be a mixture of 2 individuals. The initial star mix run had a Gelman-Rubin convergence diagnostics of 1.5, and after an additional 450,000 iterations per chain, the Gelman-Rubin convergence diagnostic was then 1.9. It was thought that a possible unresolved allele was causing the mixture to not deconvolute properly. The sample was rerun under the high resolution 3500 setting. The allele was not resolved, so star mix was run with the D2 locus ignored. This star mix run resulted in a GR of 1.38 initially and 1.41 after an additional 450,000 iterations. The technical leader advised to manually change the number of additional iterations to 5 million. These settings resulted in a GR 1.38. It was determined that the deconvolution may not be modeling correctly due to the limited data obtained from the second contributor, and that all additional alleles were in a stutter position with the exception of the Y at amylogenin. Due to the inability of StarMix to correctly model the mixture, the sample was manually interpreted.
Take that back to me, thank you. So did this time the state would seek to invest 27, 28, 29?
Okay. So moved.
Ms. Freed, did you also provide a letter dated October 17, 2024, partly responding to or addressing sample 2A?
Yes.
And was that the result of you receiving and reading a report from one of the defense's experts?
Yes.
Particularly Carl Reich?
Yes.
Okay. And do you also speak about another issue in that letter?
Yes.
And what issue is that?
I can't remember.
Okay.
I'm sorry.
I showed it to you.
Yeah.
Okay. I'm going to show counsel what's been marked as S20, S24, sorry.
Glitch.
S24?
Glitch?
Yeah,
Sorry.
That's okay. Show me what's been marked as S24.
They're kind of, yeah.
Yes. Can you explain, you don't have to read the letter, but just briefly what you're responding to in that letter?
Basically, he stated, Mr. Wright stated that that we had a glitch. Basically, that an unresolved allele is something that's not seen in the field, and that it's unique to our laboratory, and it is something. And this was a response to that, stating that it is something that we see. We have a validation for it, and it's widely seen in the field, as well as like GeneMapper, a company that produces GeneMapper IDX, the software, actually like submitted a letter saying that they'd seen this.
And do you discuss sample 2A in that letter as well?
Yes.
Okay. And just can you summarize that?
I'll have to find it, I'm sorry. Speaks about the sometimes Starbucks not being able to intuitively decon when there's a very low amount of DNA from a second contributor.
State system invest 24 inheritance. I'd like to turn to the 13 samples that were analyzed utilizing StarMix. I'm going to ask if you can turn on your report to page 5, table 1.
Yes.
Let me first ask you, what version of StarMix was used?
Version 2.5.11.
Now, table 1, we're looking at the first column with EO1A1. Do you see that there?
Yes.
Okay. And EO1A1, is that the gene's interior thigh above knee?
Yes.
Okay. And how many contributors were assumed there?
3.
Okay. And that was something that that you looked at? You looked at the electrocardiogram for that?
Yes.
Okay. How about contributors that were suitable for comparison?
Only contributors 1 and 2 were suitable for comparisons.
Okay. And when did you determine that? Was it prior to running through StarMix or after?
Prior to running.
Okay. to show you, let me show you defense counsel first. S30, S31, and S32. Do you recognize those?
Yes.
Okay, what are those?
These are the electropherograms. The electropherograms for the samples.
Okay, there's essentially 3 electropherograms there, is that right?
Yes.
Okay, why are there 3?
So one will be, so we ran samples one time, and then we realized that we may have this unresolved allele. So we tried reloading them with the different setting on the 3500 to hopefully resolve that allele. So then we have a second run, and then the one that we ended up reporting, whether it was the first or the second run, would then have a star mix EPG, which will have the stutter filters turned off.
Okay, and can you delineate which is which of the 3?
Based on the page numbers, whatever is the earliest page number will be the reported one, followed by the star mix. These are a couple of duplicates. Okay. All right. These are. Oh, okay. This is the same sample. I'm so sorry. These are just duplicates. Okay. So this is the reported one.
And is that S what?
S31.
Okay. When you say reported, what does that mean?
It's the one that we reported the results for.
Okay.
In the actual report.
Can I take that from you for a moment so I can get a copy? There we go.
Okay.
Hand me a copy to discharge of S31. Did you want to?
And then the S32 would be the star mix version, which has the stutter filters turned off, and that is the profile that was actually put into the star mix software.
Can I take that from you? Handing around a copy of S32. And how about that last one, S30?
This was the unreported load.
Okay. And again, why do you have that unreported one?
You have to report to include everything that was done to any of the samples in the case file.
Giving Your Honor a copy of S30. Thank you. Okay, so you have the 3 electropherograms in front of you for sample E01A, right?
Yes.
Okay. Was the deconvolution report also run?
Yes.
Okay. I think I showed counsel as 33, the deconvolution report. And Your Honor, a copy of the deconvolution report for E01A. Did you recognize that?
Yes, that is the deconvolution report for E01A.
The S number on that deconvolution report?
S33.
Thank you.
Okay. I'd like to take a look at that deconvolution report. If you could, this is the first time I believe that we're actually looking at this in court in this proceeding, a deconvolution of full report.
Okay.
So if you could take us through this first page.
So the first page includes details, the software version, who ran it, when it was ran, how long it took, and under the detail section. And then the run parameters is telling it, that's where it states how many contributors were determined to be in the profile. The kit is the kit that we used, in this case it was Global Filer, and then the sample file name. And then the next section is case number, and then the sample name, and the seed is a random number, a random place that the software decided to start doing its interpretation or deconvolution. And then there's a note where I will always put the notes about what contributors are not suitable on this first page.
Okay. Under where it says post burn-in summary, what is that?
Those are basically the secondary diagnostics that we check to make sure that the deconvolution ran properly.
Okay, now when you turn the page over to page 2, you see where it says component interpretation?
Yes.
And it says contributor 1, 82%?
Yes.
Okay, what does that reflect?
So this is the deconvoluted results, deconvolution results for contributor 1. And the 82% is what is also summarized on the first page. It's basically the percent of contribution that StarMix has estimated is contributing for that to the DNA profile.
Okay, so essentially on page 1, under summary of contributors, you have 3 contributors, is that right?
Yes. Yes.
And you have the number 1 spot is at 82% estimated percentage, and then the number 2 spot is at 17% estimated, is that right?
Correct.
And the number 3 spot is at 1% estimated, is that right?
Yes.
Now the only 2 contributors that you deemed suitable for comparison here, is it true that it's number 1 and 2?
Yes.
All right, again, looking at that page 2, so contributor 1, where it says you have locus, do you see that?
Yes.
And then you have the next column, you have genotype.
Yes.
And then you have weight, do you see that? And then component, and it has above 99%, do you see that?
Yes.
Can you explain what that means and how you would read this?
So the locus is each of the loci that are tested in the kit. And then it's just listing it in that one column. The genotype is going to list all of the possible genotypes that StarMix has determined are a possibility for that contributor. The third column is weight. It's basically saying how confident is StarMix that this allele is, or this genotype combination is the right one. And then the component above 99% is if StarMix has, confidence above, equal to, or greater than 99%, it's going to pull it over into this component section, kind of like creating a allele table.
Okay. And then, so it has this component interpretation. Will it have that for each contributor?
Yes.
Okay. So you can see you have on page, looks like 2 of 13, you have contributor 1 and then contributor 2 starting on the bottom, right?
Correct.
And then it goes over into contributor 3 starting on page 5, is that right?
Correct.
On page 9 of 13, where it says component interpretation summary above 90 or equal to or above 99%.
Yes.
Why is that there? What does it mean?
It's basically summarizing for the 3 components what StarMix has called above 99%.
And then if you turn to page 11, do you see where it says variance charts and stutter variants?
Yes.
What are those?
Those are charts that correspond to the secondary diagnostic on the first page. Basically, if the point falls within the bell, it's acceptable or it's expected.
So these diagnostics, these secondary diagnostics, are also things that you're looking at after the decon is run, right?
Yes, absolutely.
And then finally, that last page there, looks like it's not last, but it's 12 of 13 and then 13 of 13, where it says settings.
Yes.
What is that referring to?
These are the settings that are set when we run the run, the StarMix run. And usually these are not altered by me; they're set, and for each kit.
Okay. I'd like you to take a look at page 5 again of your report. That first column, sample EO1A1.
Yes.
You have certain boxes where it delineates visually excluded. Do you see that?
Yes.
Okay, so who in this particular case, what samples were visually excluded?
Jennifer Caneiro, Jesse Caneiro, and Keith Caneiro.
Okay. So essentially, did you visually excluded those?
Yes.
Can you tell us how you did that?
So basically, I'll take the allele table from those for each reference, and I will go locus by locus to make a comparison to see if it's possible.
When you say you take the allele chart, is that the allele chart that we pointed out in your report?
Yes.
The reference sample. Okay. And then when you visually exclude, are you looking at the deconvolution report to do that?
Yes.
Okay. Specifically where?
So we do each contributor separately. So I'll start with contributor 1, and I'll go through. And so the only possible genotype, according to StarMix, is 1515 for D3. So if you go across the only 2 people, if you go across page 9 with all of the references at D3, the only 2 possibilities there are Sophia and Paul. And then you just go down location by location to see So for contributor 1, Sophia is the only possibility for VW. And then you go down location by location until you hit something that's an exclusion. So we already know that from just these first 2 loci that everyone is excluded because no one can have a 1718 except for Sophia. But you still go down and make sure that everything makes sense. And then you go on to the next contributor, and with 100 or with what greater 99.99%. They pulled a 15-15 for the second contributor as well. So again, the only 2 that can be included there are Sophia and Paul.
And just to be clear, when you're looking at that component interpretation summary, so for example, contributor 1, are you looking to exclude, are you looking under genotype, or are you looking at the ones that they pulled under component?
You're looking at genotype.
Okay, and all the possible ones.
And all the possibilities, okay. Yes. So if you look for there is a second one for D3. There is a second possibility. It's only 0.01%, but it's still a possibility. And so D3, there is no 14-15 there. So again, they're fully excluded. So
okay. And so you were able to exclude visually Jennifer Caneiro?
Yes.
And Jesse Caneiro?
Yes.
And Keith Caneiro?
Yes.
Okay. Were you able to exclude Sophia?
No.
How about Paul Caneiro?
No.
Okay, and so because you couldn't visually exclude them, what did you do next?
Then you take those profiles and you run them in StarMix again to generate the likelihood ratio. They call it an LR per previous. So the previous is basically this deconvolution report is what it's referring to. So this previous report, and then it generates the likelihood ratio report.
When you run a comparison, so for example, in this case, you run a comparison with Sophia and Paul Caneiro, do you do that together or separately?
You do it separately, and then if both parties, if it's possible, let me rephrase that. If both parties are giving support for inclusion, then you need to run them together to see if it's possible that they're there together, or if they, a lot of times, or it's possible that it's one. Either one could be there or the other, and not both.
Okay, we'll talk a little bit more about that, but is that reflected under where it says in page 5 of 9 in your report, combination possible?
Yes.
Is that why that's there?
Yes.
Okay. Did you run comparisons with this particular sample to Sophia Caneiro and Paul Caneiro?
Yes, I did.
And were likelihood ratio reports generated?
Yes.
And did you run them together as well?
Yes.
So were there 3 likelihood ratio reports generated?
Yes.
I'm going to take the deconvolution. Actually, I'm going to take that back from you for now.
Okay.
And the other exhibits, except for your report. Okay. I'm sorry, I just have a moment. I'm going to show you, showing council first, what's been marked as S34, S35, and S36, the 3 likelihood ratio reports. Oops. Yes, for EO1, EO1A. Would Your Honor like a copy?
Yes, please.
That is S36. Ms. Reed, I'm going to show you what's been marked. I have my pants here as S34, S35, and S36, and I have copies too. Okay, let's start with S34. What is that?
This is the LR from previous report for Sophia, comparing her to the deconvolution for EO1A.
Okay, and what does this first page reflect?
It's the details are the same as the other report. It's the version, the user, the time, and then number of contributors, kit, sample profile, and then under the contributors, that would be the reference that we're looking at in this case, or in this run.
Okay, so let's start at the top here, where it says run parameters on that first page on the right-hand side.
Yes.
Contributors, you have 3?
Yes.
Is that something that gets input by you?
It's already inputted because it was pulled from the previous run.
And then where you have known contributors under HP, do you see that?
Yes.
And next to that is reference number 3, Sophia Caneiro. Do you see that?
Yes.
Okay. Is this essentially the hypothesis right there?
Yes.
Can you explain that and how you do that?
It's so in the software, when you drag the reference profile in for the comparison, there are settings that you can click. Basically, if you're asking the question if it's Sophia and 2 unknown unrelated individuals versus 3 unknown unrelated individuals. If both parties, or if everyone agrees that Sophia should be there, then that would be conditioning basically, and we would there's a different box that you would check, and it would say, everybody agrees that Sophia should be here.
There's no conditioning done in this case.
No.
Can you tell us specifically what this hypothesis was? How you would verbally say it?
So I don't. It would become from the report that assuming a mixture of 3 individuals, this mixture DNA profile obtained is at least. You want me to read the statistic for this?
Well, I would like you to read how you input this hypothesis. So you have Sophia Caneiro there. So is it, if there's 3 contributors, assumed contributors, would it be Sophia Caneiro and 2 unknown unrelated?
Yes.
And then, so that would be the top of the fraction essentially?
Yes.
It's a fraction. And then on the bottom it would be 3 unknown unrelated. Is that right?
Yes, that's correct.
Okay. Where specifically in this report is the likelihood ratio that you reported in this case?
So it will be on page 2 and 3 are the final likelihood ratios if they take each location, the likelihood ratio for each location, and then come up with the final, combining all of those together. Is the last number at the bottom of those columns. So, and we always report the most conservative one, so the one that favors the defense or not being Sophia the most. So in this case,
Hold on.
Oh, sorry.
You're confusing me now. What document are you looking at?
We're looking at S34.
All right, I thought you said you went back to your report. I'm sorry.
Oh no! So when I was reading, I wanted to get the verbiage correct. So when I was reading,
I'm on S34. What were you just talking about? What page?
Page 2 and 3 have, if you see, per locus likelihood ratios, and then at the top it'll say CAUC, and that's for Caucasian, AA for African American.
Got it.
So we look at those 2, and then Hispanic on the 3rd page, and we will report the most conservative. In this case, it was the Caucasian.
Okay, and can you just read that number so we know where it is?
It's 4 point. It's the 90 under the category that says 99% one-sided lower HPD interval. It's 4.78558 to the 23rd power.
And is that essentially on the 2nd page of that likelihood ratio report?
And then we have a useful workbook that translates that from that number to a word.
Okay, so I'm going to then ask you to turn to the last page of that deconvolution report.
Yes.
Do you see where it says likelihood ratio report?
Yes.
Okay, what is this page that we're looking at?
That's what I was just talking about. This is where we put that number in, and it gives you the common, so the numbers, like a whole bunch of numbers. It gives you the verbiage, so 470 sextillion, or 4.700 sextillion. And then it also gives you the support that would correspond to that chart that was in the report.
So this document, that very last page, was that something that was created by the lab?
Yes, this is.
Not by Starbucks?
Not by Starbucks.
Okay, turning to your report under Sophia Caneiro, column 1 for EO1A1, what is the likelihood ratio there?
ratio is listed as 470 sextillion, or very strong support for inclusion.
Okay. And are you able to say that how it would be reported out, how you would say it to a jury in court?
Yes, I can. That's back. So, assuming a mixture of 3 individuals, this mixture DNA profile obtained is at least 470 sextillion times more likely if it originated from Sophia Caneiro and 2 unknown unrelated contributors than if from 3 unknown unrelated contributors.
I'm going to take that back. And did you also run a comparison for reference sample 20, Paul Caneiro, in this case?
Yes.
And is that what's in front of you as S35?
Yes.
Okay. You know, I should have asked you, under, and I can show it to you again, S34, which slot was Sophia put in?
Contributor 1.
She was in the contributor 1 spot?
Yes.
And I can show you again. I apologize, I should have asked you, but I'm showing you S34 again. I'm going to show you the deconvolution report because I want to ask you what percentage contribution everyone is listed as. I'm sorry, I'm showing you S33. This is the deconvolution report. So Sophia was in slot 1?
Yes.
Is there an estimated RFU and percent contribution?
The estimated percent contribution is 82%.
All right, turning to S35 now, which you have in front of you. Is that the likelihood ratio report that was run when you ran the reference sample with Paul Caneiro?
Yes.
Okay, and what was the outcome of that?
He was listed as, he was put in a contributor 2 spot, and then the likelihood ratio that was reported was 3.755 to the 18th power, or 3.7 quintillion.
Okay. And is that 3.7 quintillion, that's reflected in under E01A1 in your report, that first column?
Yes. And this is also very strong support.
Okay, and again, can you just one more time say how you would say that that likelihood ratio in court to a jury?
Assuming a mixture of 3 individuals, this mixture DNA profile obtained is at least 3.7 quintillion times more likely if it originated from Paul Caneiro and 2 unknown unrelated contributors than if from 3 unknown unrelated contributors.
Looking at the deconvolution report, what is the estimated percentage of slot 2 where Paul Caneiro is reflected?
17%.
17%, okay, and how about the RFU?
That is 844.
Okay. And finally, did you run a likelihood ratio or a comparison with both of them?
Yes, I did.
Okay. And I'm going to ask, I believe you have it in front of you, to look at S36.
Yes.
Can you explain, again, why did you do this? Why did you run the 2 of them together?
To see if it was possible for them both to be there at the same time.
And was it?
Yes.
Okay, how do you know that? Like, what in the report tells you that?
So if it wasn't possible, then you would get an exclusionary stat, or like the stat would be either 0 or not possible, negative. So because, and these are both, like Sophia is still in contributor 1 position, Paul is in contributor 2 position, and together their likelihood ratio is positive. It's the likelihood of them both being there is positive, and it's even more positive than individually.
So it's even higher than each individual likelihood ratio.
Yes.
Is this essentially conditioning?
No, this is just saying if it's possibly that they're both there. Conditioning is where, like, say if it were my jacket, I would condition upon me being here and kind of subtract me from the profile so that you can look at whoever's left.
Is there a statistic in here? In this report?
We don't report the statistic, but it is in the deconvolution report. But it's more of just it's a tool to show whether it's possible that they're both there.
Can you just tell us where and what page that's on, just so we can all see it?
So the statistic, the likelihood ratio that the software calculated are on pages 2 and 3.
Okay, and where is that?
It's that bottom number. So for Caucasian, it would be 3.57302 to the 42nd power.
Okay. Is that the most conservative?
That is the most conservative.
Okay, but again, you don't report that one.
Don't report.
You're reporting the ones that are even lower, essentially, for each of them.
All of them?
Yes, just not your report.
Okay.
Your Honor, at this time, the state would seek to move into evidence S30 through S36.
So moved.
I'd like to look at sample E01C now. Is that essentially reflected on page 5 of your report in that second column where it ends with E01C1?
Yes.
Okay. And what sample are we looking at here?
This is the, from the genes, the area 1, exterior front right thigh, red-brown staining.
Previous sample that we just spoke about was from the jeans, interior thigh above knee, right?
Correct.
And this is also from the jeans now?
Yes.
What was your estimated or assumed number of contributors here that's reflected in your report?
1.
Okay, and suitable for contributors for comparison?
All of them.
Just that one?
Yeah.
Okay. Were you able to visually exclude any of the other reference samples from that?
Everyone except for Sophia was visually excluded.
So essentially you ran, you had electrophorograms running this particular case?
Yes.
Again, and it was those 3 that you discussed before?
Yes.
Showing counsel what's been marked as S37, 3839 3 electrophorograms for E1C. Would Your Honor like copies?
Thank you.
Showing what's been marked as S37, S38, S38, and S39. Are those the 3 electrophorograms run in this particular case?
Yes.
Which one was the one that was reported, if you could say it, reflected by the number that's on there after S?
S37.
And how about the one that was run through StarMix with the stutter filters off?
S39.
Was the deconvolution report run in this particular case?
Yes.
Showing counsel what's been marked as S40, deconvolution report. Do you want copies or?
I'm okay, thank you.
I'm showing you what's been marked as S40. Is that the deconvolution report for this sample E01C?
Yes, it is.
Okay, and how many profiles were deconvoluted here?
1.
There was 1. Okay, and that's what's the percentage of contribution?
100%.
100%, because it's 1. And the template RFU?
And template RFU is 2,300.
Okay, and you indicated that you were able to visually exclude all the other reference samples except Sophia Caneiro.
Yes.
And did you do that in the same way as you explained in the last sample?
We may not even have to do the decon. It's one contributor, so I would probably do that just visually against the ELG, the electrophoregram. Yeah.
Did you run a likelihood ratio report or comparison in this case?
Yes.
Showing counsel what's been marked as S41, what's been marked as S41. Is that the likelihood ratio report that came from the comparison?
Yes.
And what does that reflect?
This shows a statistic of 2.1 septillion, which is very strong support for inclusion.
Okay, and that's of Sophia Caneiro?
Yes.
Okay. Judge, at this time, the state seeks to move into evidence S37, 38, 39, which are the electropharograms, S40, the deconvolution report, and S41, the likelihood ratio report for EO1C.
Okay, so moved.
I'd like to turn to sample EO2A. Do you see that?
EO2A was not on this chart.
Oh, sorry. Okay. That was one of that's
manual.
One side of one glove. Is that right?
Yes.
Okay. EO2B.
Correct. Yes. This is
the star mix used for that?
Yes.
And is that reflected as the interior of one glove?
Yes.
Were electropharograms produced in this particular case?
Yes.
Okay, and was a deconvolution report run?
Yes.
What are the assumed number of contributors that you assigned here?
2.
And were they both suitable for comparison?
Yes.
Was anyone in this particular case able to be visually excluded?
Jennifer, Jesse, and Keith.
I'm showing counsel what's been marked as S42, 43, and 44, the electropharograms for the sample, as well as S45, the deconvolution report for the sample. And Ms. Reed, I'm going to show you the same thing and ask you, what is S30? 45.
S45 is the deconvolution report.
S42
is the.
There's just copies of what was on there.
I see. So this is
S42.
So this is the report. S43 is the reported copy, and S42 is the load that wasn't reported.
And S44 is what?
The star mix.
And these again are 3 electropharograms in this particular case?
Yes.
Okay. And you have in front of you as well the deconvolution report, is that right?
Yes.
Can you explain to us on here what the deconvolution report, what was deconvoluted out in terms of contributors and percentage?
The 2 contributors were, contributor 1 contributed approximately 94%, and contributor 2 contributed approximately 6%.
Was anyone able to be visually excluded in this particular sample, from the sample?
Jennifer, Jesse, and Keith.
As a result, were likelihood ratio reports run or comparisons made?
Yes.
Okay, and who was that to?
To Sophia and Paul.
Okay. We're going to show counsel what's been marked as S46, 47, and 48, the likelihood ratio reports for this sample. I'm showing you S46. S47 and S48. I'm going to just go over them in one moment. Okay, S46. Is that the likelihood ratio report where Sophia Caneiro was run?
Yes.
Okay, and again, this is the same hypothesis that you indicated before.
Yes.
What was the outcome of that in terms of summary of contributors?
So the summary of contributors placed Sophia in the contributor 1 percentage. Contributor 1 spot, sorry.
1 spot, okay. What was the percent, estimated percent?
The estimated percent was 94%.
Okay, and the likelihood ratio?
Was 1 septillion, which is very strong support.
And that's for Sophia Caneiro?
Yes.
Okay, I'm going to ask you to look at S47. Is that the likelihood ratio report for the run with Paul Caneiro?
Yes, it was.
Okay, and in terms of contributors, summary of contributors, what slot was he put in?
He was put into the 2nd contributor spot.
What's the estimated percentage of contribution there?
6%.
And what is the likelihood ratio?
43,000, which is strong support for inclusion.
Oh, yes, I'm sorry, yes. Was there a third one where they were run together?
Yes, they were run together. And the likelihood ratio was higher than either of the two run separately.
Okay, and that reflected what about the profile?
That they could both be in the mixture together.
And again, the rest of the reference samples were excluded visually?
Yes.
Okay, I'm going to take this back to the deconvolution report. So does this time the state would seek to move S42 through S48 into evidence?
Okay. Let's move.
I'd like to turn next to sample E03A. Does this reflect the exterior of another glove?
Yes.
So E03A, what was your assigned number of contributors there?
2.
Okay. Were any of the reference samples visually excluded?
Jennifer, Jesse, and Keith.
Okay. With regard to the 2 reference samples that could not be excluded, so Mr. Caneiro, or Paul Caneiro, and Sophia, what was done with those?
They were run through individually and then together. And Sophia had a statistic of 100 quadrillion, which is very strong support for inclusion, and Paul had 45 quadrillion, which is also very strong support for inclusion, and they could be in that profile together.
Try to do this quickly. I'm showing council what's been marked as S49, S50, and S51, and S52, and then S53, 54, and 55. These are the likelihood ratio reports. Okay, so I'm showing you I'll show you first S49. What is that?
This is the reported.
Ledger paragraph?
Yes.
Okay.
Just wanted to check.
I'm going to give you all of them. S49, 50, and 51. You can tell us which one is reported.
The reported one is S50, and then S51 is the star mix, and S49 is the unreported load.
I'm going to show you the deconvolution report S52. Okay. How many profiles are deconvoluted out?
2.
Okay. And what is specifically indicated that on, well, let me ask you, what are the percentages for each one?
Contributor 1 was 59%, and contributor 2 was 41%.
Okay. I'm going to show you what's been marked as S53. Do you recognize that?
Yes.
What is that?
The likelihood ratio report for Sophia.
Okay, and what was her percent contribution?
That was
the mixture. I'm sorry, I shouldn't be contribution.
59%.
And I'm going to show you what's been marked as S54. What is that?
That is the likelihood ratio report for Paul.
Okay, and what was his reflected estimated percent of contribution on the deconvolution report?
41%.
41%, okay. And again, what was the likelihood ratio for Sophia Caneiro?
It was 100 quadrillion.
And how about for Paul Caneiro?
45 quadrillion.
Okay.
Let's see the deconvolution reports for EO6B. Could I please see the deconvolution report for EO6B? Or is that what you're going through right now?
I'm on EO3, yes.
Sorry.
And I'm sorry, I should have asked you, but did you also run these together?
Yes.
Okay, and what was the outcome of that?
That they could be there together.
And that's reflected in your report?
Yes.
Judge, at this time, the state would seek to move S49 through S55 into evidence for sample 3A.
Objection. In evidence.
Judge, can I have 1 moment to confer with you?
Sure.
I'd like to turn to to sample EO3B. Okay, and is that reflected in your report?
Yes.
Okay, and what are the assumed number of contributors for that sample? 2. Okay, and again, I should ask you, is that sample the interior of a gun?
Yes.
And in terms of those 2 contributors that you assigned, are either of those suitable for comparison?
Yes, both of them.
Now, in this particular case, was any of the reference samples, were any of those able to be visually excluded?
No.
They were not. Okay. Showing counsel what's been marked as S56, 57, and 58, and 59. So the 3 electropharograms in the deconvolution report for this sample EO3B. Okay, I'm going to show you the same as 56, 57, and 58. Okay, are those the electropharograms that were run in this particular case?
Yes.
And can you delineate which is which by number?
57 was the recorded, and 58 was the star mix, and 56 was the unrecorded mode.
And what is S59?
S59 is the deconvolution report for the sample.
Okay. So under summary of contributors, essentially we see here, are there 2 contributors that's reflected?
Yes.
Okay, and can you delineate the mixture proportions there?
Contributor 1 was estimated to contribute 86%, and contributor 2 was 14%.
Okay. Now, because you could not visually exclude in this particular case any of the reference samples, what, if anything, did you do with those samples?
When we can't visually exclude, we have to run an LR, or likelihood ratio, to just establish the statistic, to give weight.
And did you do that in this case?
Yes, I did.
So you ran a likelihood ratio report, a comparison for each of the 5 contributors here?
Yes.
And was a likelihood ratio report spit out or printed out from star mix for each of those?
Yes.
I'm showing counsel what's been marked as S60, 61. S60 it looks like. 61, 62, 63, 64, and 65. These are the likelihood ratio reports. Do you want to... All right, I'm showing you S62 through, S60, 61, 62, 63, 64, and 65. All right, let's start with S60. is that the likelihood ratio report for Sophia Caneiro for sample EO3B?
Yes.
Okay, and what does that reflect?
She was placed in the contributor 1 position.
What is your percentage of that?
86%. And that is a statistic of 750 quintillion, or very strong support for inclusion.
How about S61? Is that the likelihood ratio report for Paul Caneiro?
Yes, it is.
Okay, and what does that reflect?
He was placed in the contributor 2 position, which corresponds to 14% contribution. And he had a statistic of 400,000, which is strong support for inclusion.
Okay, and what is S62?
S62 is Sophia and Paul being run together.
And what does that reflect?
Sophia is placed in the contributor 1 position, Paul is placed in the contributor 2, and it is reflecting that it's possible for them to be there together.
Okay, what is S63?
S63 is Jennifer Canario's likelihood ratio report.
Okay, and what does that reflect?
It's reflecting support for exclusion from the profile.
Okay, so this is the first time we're seeing this now. It's actually reflecting that she is excluded or support for exclusion.
Correct.
Is there a likelihood ratio for that?
It's 480. And do you want me to read the verbiage just
for
one
this
line?
one so we can hear what an exclusion sounds like?
So, assuming a mixture of 2 individuals, this mixture DNA profile is at least 480 times more likely if it originated from 2 unknown, unrelated contributors than from Jennifer Caneiro and 1 unknown, unrelated contributor.
Can we look at S64?
Yes.
And what is that?
This is the likelihood ratio for Jesse Caneiro.
Okay, and what does that reflect?
It reflects a 37,000 strong support for exclusion.
Okay, so the likelihood ratio is 37,000.
Yes.
Okay, and S65?
X65 is Keith Caneiro likelihood ratio, and it is showing would be 630 moderate support for exclusion.
Yeah, thank you. Your Honor, this time the state would seek to move S56 through S65 into evidence.
In evidence. Okay, we're going to take our afternoon break. We'll start back up at 3:25.
Essentially, I told you one more time. 82. Is that good enough? You guys want to put this one here? I want to put a table here. Dirty business. It was great.
I think a lot of people.
I see like the top of your head. I see like the forehead.
I think tonight.
Nice man.
All rise. Third court's back in session. The Honorable Judge Mark Lee presiding.
Direct examination. Go ahead.
Thank you. Ms. Reed, I'd like to turn to sample 4A. Specifically, is that the exterior of another glove?
Yes, it is.
Okay, were electropharograms run for this particular sample?
Yes, they were.
How about a deconvolution report?
Yes.
I'm showing counsel what's been marked as S66, 67, and 68, which are the electropharograms, and S69, which is the deconvolution report. Okay, I'm going to show you S66 through S68. What are those?
S68 is the reported. No, I'm sorry. That's not correct. S67 is the reported. These are. Hold up. S67 is the reported. S68 is the star mix, and S66 is the unreported load.
And again, this is for sample EO4A1.
Yes.
Okay, I'm showing you what's been marked as S69. Do you recognize that?
Yes.
And what is that?
That is the deconvolution report for sample EO4A.
All right, turning to your chart on your report under EO4A1, what was the assumed number of contributors that you assigned?
2.
And which of those, if any, were suitable?
All of them.
Okay, and were any visually excluded?
Yes, Jennifer, Jesse, and Keith.
When that deconvolution report was run, how many profiles were deconvoluted out?
There were 2. Contributor 1 was 97%, and contributor 2 was 3%.
Now, was a likelihood ratio report run in this particular case?
Yes.
For the 2 contributors that you could not visually exclude?
Yes, Sophia and Paul.
I'm going to show you. I'm showing counsel S70 and S71, so the likelihood ratio reports. Actually, S70 should be S72 as well. Okay, showing you what's been marked as S70. What is that?
This is the likelihood ratio report for Sophia for EO4A.
What's S71?
Likelihood ratio for Paul for EO4A.
And S72.
And that is the likelihood ratio report with both of them.
Okay, the likelihood ratio report for the comparison that was run with Sophia. What does that reflect?
She was placed in the contributor 1 spot, which is 97%, and it has a likelihood ratio of 986 tillion, which is very strong support for inclusion.
Okay, and how about with respect to S71? That's the likelihood ratio report with the comparison run for Paul Caneiro?
Yes, it is. He was placed in the contributor 2 position, and it is a statistic of 200 million, which is very strong support for inclusion.
Okay, and what percentage contribution was he?
3%.
3%, okay. And what's the RFU there, the estimated RFU?
For Paul is 200, for contributor 2 is 216, and for contributor 1 is 6,519.
Now, finally, were Sophia and Paul run together?
Yes.
Okay, and is that reflected in S72?
Yes.
Is that the likelihood ratio report for them run together?
Yes.
And what does that reflect?
It reflects that they can be there together.
Okay.
My glasses are very dirty and I can barely see them. Thank you so much.
Judge, at this time, the state would seek to move S66, 67, 68, 69, 70, 71, and 72 into evidence.
Objection. Good evidence.
So that was EO4A. EO4B, the interior of the glove. There was no star mix done on there, is that right?
Yes, that sample stopped at quantification. There was no DNA detected.
I'd like you to turn to EO5A, please.
Yes.
Okay. With regard to that sample, is that an exterior of another glove?
Yes, it is.
Exterior, okay. And what is the assumed number of contributors that you assigned?
3.
Okay, and how about the ones that are suitable for comparison?
Only contributor 1 was suitable for comparison.
Okay, and do you know why that was?
There's 2 limited data for the other 2 contributors.
Okay. Were any of the reference profiles visually excluded after the deconvolution report was run?
Everyone was excluded except for Sophia.
Except for Sophia. I'm showing counsel what's been marked as S73, 74, and 75 lecture paragraphs. And then S76 is the deconvolution report, and S77 likelihood ratio report. I'm going to show you what's been marked as S73, 74, and 75. Are these lecture paragraphs with regard to this particular sample?
Yes, they are.
Can you state which was the reported one and which was the star mix run?
74 was the reported, 75 is the star mix, and 73 is the unreported load.
I'm showing you what's been marked as S76 and S77. Let's look at S76 first. What is that?
That is the deconvolution report for sample EO5A.
Okay. And can you explain the profile that was deconvoluted out there?
There were 3 profiles deconvoluted out, but only contributor 1 was deemed suitable for comparisons, and contributor 1 contributed approximately 94% of the profile.
Okay. Was a comparison made with regard to the one reference sample that could not be visually excluded?
Yes.
And again, that was Sophia Caneiro?
Correct.
Okay. And is that reflected in S77?
Yes.
Okay. And what does that likelihood ratio report reflect?
It reflects that she was placed in the contributor 1 position, and that the likelihood ratio is 726 tillion, which is very strong support for inclusion.
And at this time, the state seeks to move S73, 74, 75, and 76 into evidence.
Objection.
I'm sorry, and 77, which is the likelihood ratio report.
Evidence.
We've just looked at EO5A, which was the exterior of a glove. EO5B, was that the interior of a glove?
Yes.
That same glove? Okay, no star mix was used for that, is that right?
Correct.
So let's move on to EO6A. Is that the exterior of a glove?
Yes.
And is that reflected in your chart?
Yes.
Okay, I'm looking at EO6A1. What are the assumed number of contributors there that you assigned?
2.
Okay, and how about the ones that were suitable for comparison?
Both of them were.
Okay. And were any of the reference samples visually excluded?
Jennifer, Jesse, and Keith were excluded.
Okay. With regard to the 2 that were not excluded, Sophia and Paul Caneiro, what did you do with those?
We ran a likelihood ratio based on the deconvolution, and we got a stat of 876 tillion for Sophia, which is
the deconvolution report, S81, and then the likelihood ratio report, which is S82, S83, and S84. We're going to start with these together, S78, 79, and S80. Are these 3 lecture paragrams that relate to this particular sample, EO6A1?
Yes.
Okay. Which is the reported?
79 is the reported, 80 is the star mix, and 78 is the unreported load.
Okay. I'm showing you S82. What is that?
That is the LR from...
Sorry, I showed the wrong thing. I'm showing you what's marked as S81. What's that one here? What is that?
Deconvolution report.
Okay.
For EO6A.
And I'm going to show you what's been marked as S82, 83, and 84. Generally speaking, what are those?
Those are the likelihood ratio reports for Paul, Sophia, and then together. And there is support for them being there together.
Okay, so with respect to S82, the likelihood ratio report, is that for Sophia?
Yes, that is for Sophia.
Okay, what slot was she placed into on the deconvolution?
Contributor 1.
And what was the percentage of contribution there?
That was 95%.
Okay, and how about the likelihood ratio for her? What was that?
That was 876 tillion.
Okay, that's supporting inclusion?
Very strong support for inclusion.
Okay. And how about S83, the likelihood ratio report with regard to Paul Caneiro's comparison?
He was placed in contributor 2 spot, which is approximately 5%, and the statistic was 21,000, which is strong support for inclusion.
Okay. And S84, is that the likelihood ratio report of the two of them run together?
Yes.
And what was the outcome of that?
That it is possible that they are together.
State seeks to move S78, 79, 80, 81, 82, and 83, 84 into evidence. I'd like to turn your attention to sample E06B. Is that essentially labeled as the interior of that glove?
Yes.
And the exterior of that glove, just to clarify, was E06A that we just discussed.
Correct.
Okay, for E06B, what was your assigned number of contributors?
2.
Okay, and how about suitable for comparison?
Both of them were.
Were any of the reference samples able to be visually excluded?
Jennifer, Jesse, and Keith were all visually excluded.
Okay. For the 2 that could not be visually excluded, so for Sophia Caneiro and Paul Caneiro, did you run like comparisons for that?
Yes, I did.
And did those comparisons produce likelihood ratio reports?
Yes, I did.
Showing counsel what's been marked as S85, 86, and 87. You looked your ferrograms, S88, which is a deconvolution, and then S89, 90, and 91, which are the likelihood ratio reports. I'm going to show you what's been marked as S85, 86, and 87. Are those the 3 electrophorograms that relate to this sample?
Yes.
Which was the reported?
S86 was the reported, S87 was the star mix, and S85 was the non-reported load.
I'm going to show you what's been marked as S88. What is that?
That is the deconvolution report for E06B.
And then I'm showing you what's been marked as S89, S90, and S91. Are these essentially the 3 likelihood ratio reports with regard to the sample for comparisons?
Yes, it is.
With regard to that deconvolution report, so S88, what profiles were, what samples were deconvoluted out there?
Contributor 1 was estimated to be 58%, and contributor 2 was estimated to be 42%.
Can I ask you to take a look at S89?
Okay.
And is that a likelihood ratio report with regard to reference sample Paul Caneiro?
Yes, it is.
Okay, and what slot was he placed into?
Contributor 1.
Okay, and again, it's 58% of that mixture?
Correct.
Okay, and was there a likelihood ratio for him?
Yes, it was 49 billion, which is very strong support for inclusion.
Okay, I'm going to ask you to look at S90. Is that a likelihood ratio report for the comparisons for Sophia Caneiro?
Yes.
Okay, and what slot was she placed into?
Contributor 2.
And what was her percentage of estimated contribution?
42%.
And what is the likelihood ratio for her?
19 quadrillion, which is very strong support for inclusion.
Okay, and finally S91. Is that the likelihood ratio report running both Sophia and Paul Caneiro together?
Yes.
And what is the outcome of that?
It is possible for them to be there together.
Judge the state seeks to move S85, 86, 87, 88, 89, 90, and 91 into evidence.
Objection to evidence.
Let's turn to E07A. Right. That's a bigger one, fair to say, more documents. S7A, is that the exterior of a glove?
Yes, it is.
With regard to your assigned number or assumed number of contributors, what was that?
2.
Okay, and how about the ones that were suitable for comparison?
Both of them were.
Okay. Could any of the reference samples be visually excluded in this particular case?
No.
Okay, and so what did you do?
So I ran likelihood ratios for each of them.
Showing counsel what's been marked as S92, 93, and 94, and 95. Okay, I'm going to show you what's been marked as S92, 3, and 4. Generally speaking, are those the electrophorograms with regard to sample E07A?
Yes.
Okay, and if you could just state which one was the reported one?
The reported one is 93.
Okay, and which one was the one marked as star mix with the filters off?
94.
Okay, I'm going to show you what's been marked as S95. Do you recognize that?
That is the deconvolution report for E07A.
Okay. How many profiles were deconvoluted here?
2.
2, okay. And what was the percentages of each?
Contributor 1 was 62% and contributor 2 was 38%.
Now you indicated that because you could not exclude any of the reference samples that you ran them all through star mix for comparison?
Correct.
And likelihood ratio reports were generated for all of those? Did you also run Paul and Sophia together?
I also ran all of the combinations, all of them together.
Big file here, but this is basically all of the showing counsel.
It's 15, right?
I think so, yeah. Basically S96 through S110. Showing you S96 through S110. Okay. Or did they go just one by one? Okay. Let's look at S96. What is that?
S96 is the likelihood ratio report for Sophia.
Okay, and which contributor spot is she placed into?
She's placed in contributor 1 spot, which was 62%.
Okay, and what is the likelihood ratio there?
That is 48 billion, which is very strong support for inclusion.
Let's turn to S79.
97?
I'm sorry, 97, yes. S97, what are we looking at here?
That is the likelihood ratio report for Paul.
Okay, and what slot was he placed into?
He was placed into both, depending on the ethnicity group that was looked at.
Okay. And what was the likelihood ratio there?
The most conservative one was 1.9 thousand, which is moderate support for inclusion.
And that's the one that was reported?
Yes.
Okay. Let's look at S98.
Okay.
Is that the likelihood ratio report when you run Sophia and Paul Caneiro together?
Yes.
Okay, and what was the outcome of that?
That they could be there together.
Okay, and what slots were they placed in?
Sophia was placed in contributor 1 and Paul was placed in contributor 2.
Okay. Let's look at S99. Is that the likelihood ratio report that was run for Keith Caneiro?
Yes.
Okay. And what slot was he placed into?
He was placed in contributor 2.
Okay. And what is the likelihood ratio there?
9,000, which is moderate support for inclusion.
For that contributor 2 spot?
Yes.
Can we look at S100?
Yes.
Is that the likelihood ratio report for Jesse Caneiro?
Yes, it is.
And what slot was he placed into?
Number 2.
Okay, and what was the likelihood ratio?
85, which is limited support for inclusion.
Can we look at S101?
Yes.
Is that the likelihood ratio report for Jennifer Caneiro?
Yes, it is.
And what slot was she placed into?
Contributor 2.
Okay, and what was the likelihood ratio for that?
That was 2.6 thousand, which is moderate support for inclusion.
Okay. Now, when we get to S102 and beyond, did you essentially run multiple likelihood ratio reports or comparisons with the different reference samples together there?
Yes.
Okay, and why did you do that?
To see if it was possible for any of the combinations to be there together.
And was it?
No, it was only for Paul and Sophia. It was the only one that was possible.
Okay. So we have S102. Can you just identify what that is?
That's Keith and Jesse being there together.
Okay, and S103?
S103 is Jesse and Paul.
S104
is Jennifer and Sophia.
S105
is Jennifer and Keith.
S107
Keith and Paul.
S108
wait, I'm so sorry. Wait, I may have gotten off number.
Okay, let's move back to
sorry.
S107.
What was the last one we did?
You indicated, I asked what S107 was.
107 is Jennifer and Jesse.
Okay, S108
is Jennifer and Paul.
Okay, and what's S109?
Jesse and Sophia.
And S110
is Keith and Sophia.
Okay, can you explain to us how you're coming to the conclusion that none of them are there together except for Sophia and Paul?
So within the report, there will be certain, if you look at the report, the likelihood ratio will be reported as a 0. Basically meaning there's some combination of their genotypes that doesn't allow them to be there together.
And was the likelihood ratio 0 for each of those, 0 or below?
Yes.
Okay. Statements need to move S92, 93, 94, 95, 96 through 110. It's evidence.
Counsel.
Sorry, no objection.
You need evidence.
It's 3 more, Ms. Reed, right?
Yes.
I'd like you to turn to sample E09. Do you see that?
Yes.
Okay, now E09, was that essentially a swab?
Yes, it was.
Okay. With regard to E09A1, what was the assumed number of contributors that you assigned?
1.
Okay, and was it suitable for comparison?
Yes, it was.
Okay. Were any of the reference samples visually excluded?
All of them were excluded except for Jesse Caneiro.
Showing counsel S111 through S112 and S113, as well as S114 and S115. I'm going to show you first S111, 12, and 113. Are those essentially the electrophorograms for this case?
Yes.
Can you explain which one was the reported?
S112 is the reported, 113 is the StarMix, and 111 is the not-reported.
Okay. I'm going to show you S114. What is that?
The deconvolution report, E09.
How about S115? What is that?
This is the likelihood ratio report for Jesse Caneiro.
Okay, so Jesse Caneiro could not be visually excluded, is that right?
Correct.
And so you ran a comparison?
Yes.
And what does the likelihood ratio report indicate or reflect?
34 quintillion, which is very strong support for inclusion.
Okay, and I should ask, I guess, so there's only one contributor spot on there for the deconvolution report, right?
Correct.
And that would be Jesse at 100%?
Yes.
Okay. And I'm sorry, what was the likelihood ratio report for him?
It was 34 quintillion.
Okay. In support of what?
Inclusion.
Inclusion, okay. Judge, at this time, the state is seeking to move S111 through 115 into evidence.
No objection. No evidence.
Okay, turning to sample E10. Is that another swab?
Yes, it is.
Okay. With respect to E10, what was your assigned number of contributors?
2.
Okay, and which were suitable for comparison?
Both of them were.
Were any of the reference samples able to be visually excluded?
Jennifer, Keith, and Paul were excluded.
Okay, so Jesse and Sophia were not excluded?
Correct.
Okay, and did you run the reference samples through to make a comparison?
Yes, I did.
Showing counsel, it's been marked as S1, 16, 17, and 18, 119, 120, and 121, and 122. I'm going to show you S1, 16, 117, and 118. Are those essentially the electropharograms in this particular sample, E10A?
Yes.
Okay. And which is the reported?
Reported is E117, the star mix is 118, and the unreported is 116.
I'm showing you it's been marked as S119. Do you recognize that?
That is the deconvolution report for E10.
Okay. S120, what is that?
That is the likelihood ratio for report for Jesse.
How about S121?
The likelihood ratio for Sophia.
And how about S122?
The likelihood ratio for Jesse and Sophia being put together.
With regard to S119, the deconvolution report, what were the contributor percentages that were deconvoluted out there?
Contributor 1 was estimated to be 73%, and contributor 2 was 27%.
I'm going to ask you to take a look at S120, the likelihood ratio report for Jesse's comparison.
Yes.
Okay. What slot was he placed into?
Contributor 1.
Contributor 1, okay. And what was the likelihood ratio there?
That was 71 septillion, which is very strong support for inclusion.
Okay. I'm going to ask you to take a look at S121, the likelihood ratio report for Sophia. What slot was she placed into?
Contributor 2.
Okay, and what was the likelihood ratio there?
45 septillion, which is very strong support for inclusion.
Okay, and how about S122?
That was them together, and it was possible for them to be there together.
Okay. State seeks to move into evidence S116, 117, 118, 119, 120, 121, and 122.
Okay. In evidence.
Okay, in the 13th sample, Mr. Reed, I'd like you to turn to what would be E11A1.
Yes.
Okay, was that also a swab?
Yes, it was.
What was the assigned number of contributors there?
2.
Okay, and how about the ones that were suitable for comparison?
Contributor 1.
Okay, were any of the reference samples visually excluded from the deconvolution?
Jesse, Jennifer, Keith, and Paul.
And so with respect to Sophia Caneiro's reference sample, did you run a comparison for her?
Yes, I did.
Showing you, show counsel first, I'm sorry, what's been marked as S123, 24, and 25, and then S126 and S127. I'm going to show you S124, 25, I lost the last one. And I'm sorry, 123, 24, and 25. Are these essentially the three electropharograms for the sample?
Yes.
And which is the reported one?
The reported one is 124, star mix is 125, and the non-reported is 123.
Okay, and I'm showing you S126. What's that?
That is the deconvolution report for E11.
And what is S127?
The likelihood ratio report for Sophia for E11.
With respect to S126, the deconvolution report, was there essentially just the one profile that was deconvoluted there?
They were deconvoluted, but only contributor 1 was suitable, and that one was contributing 99%.
Okay, and the other was how much percent?
1%.
1%. with regard to S-127, the likelihood ratio report that was run for Sophia Caneiro?
She was placed in contributor 1 position and with a statistic of 990 sextillion, which is very strong support for inclusion.
And that was again for 99% was her percent contribution.
Correct.
The state seeks to move S-123, 124, 125, 126, and 127 to evidence. Ms. Reed, you have the allele chart for each of the reference samples attached to your report, is that right?
Yes.
And I believe that's on the last page. Is that page 9?
Yes.
During the course of your examination of this case, did you determine whether any of these reference samples had any mutations?
Yes.
Who was that?
Sophia appeared to have a mutation at BWA, which is the second location listed.
Okay. And when you talk about a mutation, what does that mean?
Basically, when your cells are dividing and when you're becoming an embryo, the very beginning, something happens and there's a slippage from one of the alleles that you inherit from your parent. So one of these, so her parents have a 14, they both have 14 and 18. So she could have inherited, she more than likely inherited the 18. Oh, I'm sorry, it doesn't matter. She inherited the 18 from one of them, and then the 17 that she inherited is actually just a mutation of the 18 from the other one.
When you received these reference samples, were you aware of any familial relationships between them?
Only because of their names.
Okay.
Yeah.
So is it fair to say you weren't sure if it was first degree, second degree, etc.?
I'd have to think if it was listed in the case submission information whether they were related, but usually we don't look at that automatically, but when we have a name that's the same, we kind of look and say, hey, are they related?
What's the difference between, for example, first degree and a second degree relation?
So a first degree is your parent-child relationship, and then first, like full siblings are considered to be first degree relatives, and then anything past that is a second degree, and then so it's like an uncle or a stepbrother or a half brother or like an aunt, uncle, that kind of grandparent.
Did you have any concerns in any of these samples with regard to the fact that you did have related contributors?
We definitely evaluated it for it when we saw that the names were the same, and our SOP requires us to look in to see if there is any conflict, or if we look at the profile, if there's any like weird allele sharing that makes the profile not look right, and there wasn't in this case.
Now, there's a standard operating procedure that speaks to comparisons with regard to first degree relatives. Is that right?
Yes.
Okay. So for the sample I believe it was E10, where you had Jesse and Sophia together. Did you have any concerns there?
When I looked at the profile, the peak height ratios and everything were lined up with that, what we would expect to have some sharing. But then you have that mutation, which helps because you can see that she is clearly different, and there are, even though siblings are first degree relatives, they can share anywhere between nothing and all of it. I mean, we haven't seen, I don't think if there's any case of seeing nothing, and other than identical twins, there hasn't been anyone there that we found that shares 100%.
Now, with respect to the samples where you were able to make a visual exclusion of certain family members and not of others, does that, I guess I should say, how did that affect your analysis of this case?
It gave me more confidence that I was right and assuming that the first degree relationship wasn't an issue.
Does anyone have one comment? Maybe nothing further.
Judge, would you be able to adjourn today given the fact that it's at 4 o'clock?
I'm just going to ask for you to step down. For me, you can't discuss this case. You have to be back here tomorrow right at 9 o'clock. We'll start right at 9 o'clock. And you'll be back under oath. You just can't speak to the prosecutor or any of the parties in the case. Okay? All right, thank you. So for my own edification, because like I said, this is some of this is new to me. The pair of jeans that we talked about in that first sample, where was that located?
Physically, the jeans, Judge, were found in the defendant's house in the basement with the gloves.
You say the gloves, so sample 2, 3, 4, 5, 6, and 7, everything that was testified to, those gloves were found in the defendant's basement?
Yes, Judge. They were in the same pile as the jeans.
About this knife, where was that located?
The knife was located, it was not tested, but that was located in a backpack that was in, I believe it was a car that the defendant's wife drove regularly in a backpack. We got a search warrant for the car and in the backpack as well.
In the defendant's wife's car?
Yes, the same car that they drove to the police department the morning of the fire at their house.
Okay. What about sample 9, the reddish stain from the south side of the kitchen island?
That was taken from the scene in Colts Neck. So the jeans and the gloves were found in the defendant's house in his basement in Ocean Township. The 3 swabs, 9, 10, and 11, were taken from the kitchen in the Colts Neck house where the victims resided, specifically the kitchen where Jesse Caneiro was found deceased.
So tomorrow morning, we'll start with the cross, and then we will continue on with one other witness. The one thing that I want to just point out to you is that Friday we'll probably stop at 4, just to give you a heads up. So if we don't finish, we'll just continue on with Dr. Buckleton, on Monday. If we're not done by 4 o'clock, okay?
Should be good. Thank you.
All right, no problem. All right, everybody have a good night. I'll see you tomorrow.
Yeah.
And Sheriff's, sorry. You want to go off?
No, I'd love to stay on the record.
All right, go ahead.
I understand this court issued a deadline for a brief with respect to the underlying data issue for 4 p.m. this Friday. Given the fact that this court has already said one earlier today that we don't have a jury, this court doesn't necessarily make that decision as quickly as it might if we were trying to figure out whether we were going to present something to a jury or not. I would ask that the brief deadline be extended to sometime early next week, just to give me the opportunity to work on it.
Okay. You can have it to me by 9 o'clock on Tuesday morning on the 19th.
Thank you.
Both sides, 9 o'clock. Does anybody have anything else they need to put on the record?
No, Your Honor.
Okay. Thank you. All right. Let's be ready tomorrow at 9 o'clock. Paul Caneiro. His indictment number 19020283. That's the case that involves the Dauber hearings. Now the appearances of counsel for the record.
Good morning, Your Honor. Assistant Prosecutor Nicole Roberts on behalf of the state.
Good morning, Judge Chris Decker, Assistant County Prosecutor.
Good morning, Your Honor. Michael Caneiro, Paul Caneiro.
Good morning, Your Honor. Victoria Howard, also on behalf of Mr. Caneiro.
Good morning, Your Honor. Christopher Governor on behalf of Mr. Caneiro, who is present in court tonight.
Tomorrow, Larry, also on behalf of Mr. Caneiro.
Good morning, everyone. All right, so we finished the day yesterday with an issue that was presented by the defense in relation to certain discovery, and also not just the discovery. Your witness is not there, correct? No, that's fine. I want to make sure she's not.
No, Judge.
Okay. So, from Bodie Technology and a certain letter that was dated April 26, 2024, that's been marked as S20 for identification. There was an objection to the letter based on some discovery that was not allegedly not turned over in a format so that the defense was able to see it immediately. They had to request for it to be put into a different format. I asked the state to go back to take a look at when this discovery was turned over, the issue that came up with it, and I'd like to get some information on that first. Mr. Decker, go ahead.
Good morning, Judge. So with respect to that April 26, 24 memo that was sent to me, specifically to Ms. Wallace, so prior to that, I would note for the record that on March 26, 2024, we forwarded to the state police the defense request for the New Jersey State Police data. So that's that. There was some negotiation, not negotiation, but there was some discussions regarding protective order that was required. Defense signed that, their experts signed it, and the agreements to be found, and ultimately that was turned over on May 3rd, 2024. That's the New Jersey State Police data. I gave that to Mr. Woodkey in person on Friday, May 3rd. Just to go back, that's to April 26th. That's when that memo was sent to the defense. May 8th, Mr. Godin sent a letter seeking the underlying Bodie data. I'm summarizing that. The letter, he could have asked for other things as well, but it was seeking the underlying data from the Bodie by validation, as well as also it was part of the letter was communications or emails between state police and the SR, which were ultimately provided as well. So on May 14th, Ms. Norton sent a folder containing instrument data, printed data, and the Star Mix report, along with sample preparation bench notes for each of the 3 samples that were discussed in that memo. So that was on May 14th. On May 22nd.
The April, when you say memo, you mean the April 26, 2024 letter?
Yes, sir.
Okay, go ahead.
So that letter, again, April 26th. Then on May 8th was Mr. Godin seeking underlying data.
Right.
On the 14th, Ms. Norton sent to us discovery relating to specifics of the memo. And then on May 22nd, 2024, Bodie provided to me, which was provided to the defense, a link to their FTP site with the login and the password.
That date is what?
That was May 22nd, 2024. On June 4th, as I indicated from looking back, I believe Mr. Godin and I and others spoke in court, and Mr. Godin indicated a reference to seeking it in a different format. Okay, so I said to Mr. Godin, I said, can you just send me an email clarifying exactly what you need or what you're looking for, and I'll forward it to Bodie. So on June 5th, I received an email from Mr. Godin. I believe everybody was CC'd on that. And he put that specific request in writing as I'd asked him to. That email, I believe that same day, I checked that. I'm pretty sure that same day I forwarded that email to Bodie and said, here's what the defense is seeking clarification on the request. There was some communication between myself and Bodie. They said they were looking into it. Need a little more time. And then ultimately on June 19th, which would have been 15 days after I sent the request from the defense, Bodie advised that it was on their FTP site, which was the same site that was used for the underlying data initially. On June 20th, the next day, I emailed Mr. Godin and others and provided that same link with the login and the password. So at that point in time, I'm sure shortly thereafter they downloaded that. I would also note that on June 25th, 2024, 5 days later, we were before Judge Coxon with respect to the status conference, and I believe in chambers, and I'm not sure if it was actually then put on the record or not, but that's when we were advised that Mr. Inman, Keith Caneiro, the defense expert, had been retained, or that's who was going to be involved in that part of the process. There may have been others. I know there was reference to Dr. Rabinowitz, but that's when we were advised of Mr. Inman, June 25th.
So that I understand, the original Bodie analysis that's done, when is that turned over?
Their initial casework?
All of their work in the beginning. Was that in 2022?
If I could have one moment, Judge, yes. The Bodie report, which I'm not sure it's been identified yet, it will be identified in this report. That was dated November 19th, 2021.
So November 19th, 2021, the state turns over the Bodie report. Any documents with the Bodie report?
So that's the date of the report. We would have received it shortly thereafter. We would have turned it over in discovery, and I believe there was a request to ensure that the defense had the entirety of the Bodie case file, but that would have been turned over shortly thereafter. I don't have that date in front of me.
So the reason why I'm asking that is that because the April 26, 2024 letter, is this relating to information that was turned over in 2021 or 2022?
No. So what was turned over was the entirety of the Bodie case file. We requested it as we would in any case. I'm not even sure if it was based upon a request. It was probably in the normal course where we requested the entirety of their case file. that data that's being referred to in that memo would be part of their underlying data, which had never been requested. Nor had until, I think, February of 2024, the state police underlying data. So that's not something that they provided to us in the normal course. That's the underlying data from their validation. It's not underlying data or reports from their casework in State versus Caneiro. Does that make sense?
So the data and the underlying validation is requested, Mr. Wicke, I'm going to ask you right now, is requested as a result of Judge Oxley deciding in May of 2022 that he will conduct a downward hearing on this case?
That's right, Your Honor.
Okay. All right. And I understand the source codes and the time that went into that. At the time that you request on behalf of your client a downward hearing, did you have experts in place? You don't have to tell me who they are. That's not my issue. I'm just asking you the simple question.
For the data, Your Honor, or for the rest of the case?
Well, for if you're saying that you're asking for a downward hearing, you're talking about the scientific reliability, as you know, because you wrote the brief. So I'm asking you when it was learned, or when did you get an expert knowing that you were going to be arguing that there is an issue with this StarMix software?
So should I stand?
Yes.
Sorry, Your Honor. So we, on April 26th, when we got the Bodie memo, that was when the issue of the underlying data for Bodie became apparent to us, because we had been relying on the summary that was apparently incomplete. So that is when I started looking for an expert, which was not an easy task. And then we moved to exclude the New Jersey State Police information originally in late February because of what we believe was delayed disclosure. Once that was denied at the end of February, it was early March where I asked for the underlying data because the validation summary was so conclusory, and started looking for an expert. And I was looking for two different experts because it was a lot of work to do the data.
So the defense is asking for a downward hearing in 2022, but it's not until 2024 that we're looking for an expert. Am I correct in what I'm saying?
Well, we had a DNA expert immediately and a software engineering expert.
Okay.
We started looking for a different kind of expert, statistician, criminalist, to look at the underlying data once it became clear to us that the validation summary didn't contain all of the data necessary to assess the validation study. We had assumed that the Bodie package was a complete package as demonstrated in the summary, but then this new data just arrived, and I said, well, then I need all of it. And if I need all of it, I need someone to analyze it, because I can't. Okay.
Just also one thing, Your Honor, I want to point out is that our argument, at least for 2022 until earlier this year, was that any samples that at or near the 25 picogram lower limit or the 5% minor contributor lower limit should not be given to the jury. That's the premise of our as-applied challenge, that they're going outside the bounds of the internal validation study. We did not think that we were going to need to look at the underlying data because we were taking Bodie at their word that they validated it down to 5% and 25 picograms. It wasn't until late April of this year when we got the memo that was then claiming actually we have validated it to lower than 5% and less than 25 picograms that we then said, fine, if you're going to cherry pick 3 data points from your internal validation study, you got to give us the rest. That's the problem here, is that the state went and tried to pull this data in March of this year to try to argue against our position that their internal validation study only warrants giving a jury samples that are larger than 25 picograms or with a minor contributor that is at least 5%. That's why we didn't ask for this data 2 years ago. It didn't become a relevant question until the state, for the first time in 2 years, earlier this year, started arguing that actually they validated StarMix for samples beneath those thresholds.
Mr. Decker, give me a chance to respond to that, what you just heard.
Yeah, I think I've always thought it was interesting that they asked for the underlying data from the state police prior to that of Bodie, given the arguments that they made. Mr. Bodie knows that a validation summary is just that. It's a summary. I would also note that my understanding, based upon prior conversations with the state police, prior to requesting the underlying data from the state of New Jersey, Monmouth County Prosecutor's Office, they actually attempted to Oprah data from the state police, which I was just advised of. I wasn't party to. I don't even know exactly the outcome. I assume it was denied for whatever basis. So the fact that data means something to these hearings from the defense perspective is clear based upon the fact that prior to requesting Bodie's, they requested the state police, who tested 2 samples which aren't even questionably outside the bounds of what they did in this case. The argument has always been made. We've been very aware of it. We have experts that have addressed it, one being Dr. Buckleton, one being Dr. Coble. We disagree with their argument, and we're not here to fight it now. We'll talk about it later. We understand the coverage to Ms. Naughton about the argument the defense was making, and I guess that's when it was brought up that there was data that expands the defense, replied to the defense argument. Ms. Wallace, and we discussed this in front of Judge Oxley ad nauseum, Ms. Wallace did exactly what she was supposed to do and said, hey, can you document that? Provide it to me. I got to give it to the defense. She got that memo, I think the same day. She provided that memo to the defense. So I have a hard time kind of listening to the argument that they didn't think the underlying data was necessary. We responded to the coverage argument before, and we'll respond to it in court. But, I just always thought it was interesting that the state police data was more important than the Bodie, and I just have always thought that that's because of the statewide implications with respect to the state police and not Bodie.
So here's what I'm going to do. I'm going to put a longer decision on the record. Yesterday, I decided when we had a sidebar on this issue where the defense had objected to the S-20, the April 26, 2024 letter, I had indicated that the defense had time, and I am of the opinion that the defense had time to show this to their experts, to take a look at it, and if they've had since 2022 to look at the overall analysis, and if they wanted to attack the underlying validity of any validation study or anything else that was done here, they've had the opportunity to do that. I'm going to put a longer decision on the record so that the record will be clear for whatever appellate review in the future. But this court is confident that the state has complied with all discovery rules on this issue. They've turned over the information. The defense had time to address this issue from April 26th or even as late as June 20th to this date, which is November the 11th, to move forward, November 12th yesterday, to move forward with it, some type of response. They did not do so. And the court is of the opinion that that is on them. It is not on the state, nor should the state be under the circumstance to argument being made by the defense. So again, I will put something on the record at a later point. I want to continue on with the testimony here today. If somebody wants to, Mr. Gold, you can sit down for a second, please. If there's something that you want to put in writing to me, you can. I'll give you the opportunity to do that. But we're going to continue on with this hearing right now. We have experts lined up every day, and I'm not going to slow the actual testimony down. It's not like this is in front of a jury right now. If there's some reason where I have to pivot, I would be able to do that. But this court's opinion right now is that the information can be testified to, it will be permitted, and I'm going to ask the state to bring your witness back in and we can start.
Am I being, can I put something on the record, Your Honor? Or?
Did you hear what I said?
Yes, I just wanted to make sure I'm requesting to put something on the record.
I'm saying that you can put whatever you want in writing to me, which would be a part of the record, and I'll allow you to do that. I'm saying that right now, between the hours of 9 and 4:30, that I'm going to take testimony in this case. If there's something that you need to put on the record that is so important, I'll give you the floor right now. But if it's something just to respond to something that you're not happy with what I'm saying, then I'm asking you to just document it, and then I will address it, like I said, not right this minute, but at some point in the near future.
There is one thing I want to
go ahead and do that.
And the only reason I didn't say this earlier because I didn't know Your Honor was going to go into the ruling right there. Just to be clear, it was not until August 5th of this year that we were given from Bodie the genotypes of the known non-contributors, right? And so when I spoke about yesterday, sort of the frustration that I had, where I asked for something very clearly and it's communicated to Bodie, and then Bodie partially responds to it, but in a way that's not particularly useful for us or makes it difficult or impossible for us to be able to do our jobs, Your Honor. That is the frustration that I'm trying to
And I respect that. I want you to understand that I'm going to give you the opportunity. You're going to have somebody on the stand. You want to ask questions about that and you want to explore it that may go outside the bounds of what this hearing is for purposes of your arguments that you want to make in front of me, that maybe at some point you want me to strike something from this record, I'll give you the opportunity to do that. I just don't have anything in front of me that's saying that right now that Bodie did anything wrong other than be responsive to whatever you requested from the state and the state told them that they wanted to do.
And just, for example, the Bodie internal validation study summary has many charts and many graphs, which presumably were made in Excel. Those were not given to us, right? Even when they did give us the underlying data, which they didn't actually give us the Excel spreadsheets that were used to generate those particular charts and graphs, which would have greatly reduced the amount of work that our expert would have had to do to go back and actually reanalyze it himself. That's fundamentally the issue here. Notwithstanding also the fact, like I said, that we get the data on June 20th, our expert is looking it over, we don't realize until the end of July, early August, that we don't have the actual genotypes of the known non-contributors, and we know that that file exists because it's 510simulated.csv, and it's in all of the
it goes a lot further than that. At the end of the day, you're right. Yeah. Okay. In May of 2022, when your office has made the decision that you are going to attack and or put into question the star mix, hear me before you start to respond in your head. At that point in time, you should have started with experts to figure out exactly what your decision was going to be moving forward. Hold on. Because we all know throughout the United States that cases were being decided, and the attacks and where the attacks were throughout the United States. You guys had the opportunity back in 2022 to make decisions. You were making decisions off of a summary. You then pivoted, which you have the right to do, and made the decision based upon this response that you wanted to do something else. That doesn't mean that I should strike the information from the state. This is what I'm saying. All we're doing right now is doing exactly what I said I don't want to do. I don't want to argue this. If there's something that you want to put in writing, I'm giving you the floor. You can write for as long as you want. I'm giving you the opportunity to expand it on the record so that you have the ability to ask these questions to find out, why didn't you turn over the charts? Why did you do when this request was turned over? I'll give you the opportunity to do all that. I'll give you the leeway, even though it's outside the scope of what I'm here to decide. I'll give you that. And then if there's something that comes up, maybe that would be more helpful to me than what I'm getting right now from you and I going back and forth with the colloquy.
I just really want one thing to be very clear, because something Your Honor just said made me concerned that it was not. The only reason that we asked for underlying data was because in March of 2024, the state told us that they actually had samples from the Bodie internal validation that went below 25 picograms and below 5%.
March of 2024 was the day that the hearing was already supposed to have occurred, but for the fact that somebody, and it was in the system years back, that the state police had also done an analysis using StarMix that nobody in your office realized that should have put it in writing to say, we want to add this to the Daubert hearing. That's the reason why the March happens. That's the reason why the April letter happens. Because guess what? Otherwise, we would have had the hearing back in February or early March. So I'm asking you nicely. It's clear. I understand what you're arguing. Put it in writing if you want to do that. I'm giving you every opportunity to be able to put this all on the record using the witness in front of you. But what we're doing right now is not helpful, and I'm not necessarily agreeing with where you are today. I may change my mind. You may show me something that happened that I don't know. You and I both know from the start of this case that I'm here to deal with this hearing. Judge Oxley heard a lot of the stuff. I've gone back, I've listened to everything that's been placed on the record to be prepared. This is what I have in front of me right now, and this is what we're going to move forward on.
Can I finish the point I was making, Your Honor, please? The point that I am making is that the same samples that were sent to us in April of this year in that memo, they existed in 2022 when we first filed the motion for a dog order, where we said they're going outside the bounds of their validation study. The state had every opportunity in 2022, if they wanted to say that actually that validation study went below 25 picograms or below 5%. In 2022, they could have spoken with people at Bodie, and in 2022, they could have provided us this memo, and then in 2022, we could have requested the rest of the underlying data. This didn't get found out until March of this year, and it was not through anything that the defense did. And that's the only point that I wanted to make.
Okay. Wonderful. Can we bring a witness in?
Yes, Judge.
Even though we did it yesterday, I'm going to do it again today just to make sure that we're on the same page. I'm just going to ask you to put your left hand on the Bible, raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Can you state your full name for the record and spell your last name, please?
Kristen Walton. Last name is spelled N-A-U-G-H-T-O-N.
Okay, be seated. For the record purposes, I had indicated to you last night that when you left that you weren't to speak to the state about anything about your testimony. The only thing that you could do was talk about logistics of showing up today. I assume that that's what you've done?
Correct. I did not say that.
Okay, great. All right. Ms. Wallace, go ahead.
Thank you, Your Honor. Ms. Naughton, we left off yesterday discussing S147, which is the internal validation of star mix, and specifically we left off on section D. Showing counsel what's been marked as S147. Judge, I believe Your Honor has a copy.
I do, thank you.
Ms. Naughton, I'm showing you what's been marked as S147. This is page 14 on section D. Specifically, we were talking about the sensitivity and specificity studies. Do you recall that?
Yes.
I'm showing counsel what's been marked as S20 and S155.
Your Honor, I believe Your Honor has copies as well of those.
S20 and S155? Yes, I do. Thank you.
Ms. Naughton, I'm showing you what's been marked as S20. Can you just remind us of what that is?
This is a memo I wrote looking at more in-depth data that was in our validation data binder to explain a few more samples that probably were not appropriately or not detailed in this summary.
Okay, and specifically on the first page of S20, there's a sample there that's a four-person mixture?
Correct.
And is the minor on that four-person mixture, what percentage is the minor there?
It's approximately 5%.
Okay, is that according to, what percentage does it say on here?
So the mixture proportion that Star Mix estimated is 3%.
3%, okay. I'm also showing you now what's been marked as S155. Do you recognize that?
Yes, that's the electrophoregram repeating profile from this particular Star Mix analysis.
Okay. Now on there are some, it looks like some alleles that are highlighted. Do you see that?
Yes.
Okay. Who made those highlights?
I did.
And why did you do that?
So That is based on the known contributor for that contributor 4 of this mixture. So we know all 4 contributor genotype profiles that are made of this mixture. So I was highlighting these to show how well represented in the DNA profile that this donor in particular is.
Okay, and how well represented is that minor donor?
You can see this donor in every testing location or locus tested in the global biochemistry SDR location tested, and specifically more at the locations that have a lot of peaks present. They are represented at unstacked or not stacked in other contributor position.
I'm going to grab this document back. Yeah. Thank you. So just to conclude with this particular section, Section D, based on the analysis that was conducted in this section, were you confident in StarMix's analysis, or ability rather, to operate effectively in deconvoluting mixtures typically seen in casework?
Yes, especially when you have stronger RFU template amounts. It's very specific to be able to discern true donors to the mixture and non-true donors to the mixture. And it's statistically accurately weighted a low statistical value when that ambiguity is in the mixture.
I'd like to turn to Section E. This is page 15 to 17 on S-147. What section does that cover?
So the title of the section is called Alternate Propositions. So this is where we would look at some different features in StarMix where we can condition sometimes on a relevant donor or contributor that we may know the DNA profile from. And it also looked at different ways you can compose the hypotheses that are consisting in the likelihood ratio.
The court has already heard testimony regarding conditioning, but can you explain conditioning as you understand it to be, given your training and experience in the course of your career as well as at Bodie?
Sure. So we have set rules in our standard operating procedure that if a contributor can be expected to be a part of the DNA profile or assumed to be part of the DNA profile, we can condition, which means we put their known profile into the interpretation portion of StarMix where we can provide that this is the known profile to a portion of that sample or that mixture. At Bodie, we define them a little bit slightly different. That expected means that it's an evidence of item that is taken either directly from the body, such as a body swab or a vaginal swab, or a piece of clothing that's come directly off of the body. And then we have assumed contributor where the case scenario can say that it's reasonable to assume that direct contact from this contributor was made with this item.
Are there certain standard operating procedures that you just discussed that govern when you kind of cannot condition?
Yes, those are the standard operating procedures that are all of our DNA analysts follow.
Okay, and again, what is the benefit to conditioning?
So it's most beneficial when you have a mixture that's not visually obvious which alleles belong to which contributor. So let's say in a very basic 2-person mixture, if you know one of those contributors, you can more easily deduce out which alleles belong to the other contributor, versus if you did not know that information, it would be a more ambiguous interpretation of which alleles belong to which contributor.
What kind of specific testing did you conduct under this subsection E?
So this was 16 samples running, again, 2, 3, and 4-person mixtures that vary in low level of that, vary in template amounts of that lowest level contributor, and testing what is the effect of conditioning as well as changing how the hypothesis for the statistic is calculated as well.
And so what was that effect? What are the conclusions that were drawn?
So when you conditioned, it really depended, again, on the type of mixture. So again, if it was a mixture where equal contribution to the mixture between contributors, it really did help StarMix have a more interpretable profile from the other contributors in the mixture. And that generally is represented in figure 7A as likelihood ratios that are higher than if you did not have that previous or prior knowledge to help guide the interpretation. And then also, so graph 7B also helped drive some of our standard operating procedures where Bodie performs the likelihood ratio statistical calculation, including one individual at a time, or comparison to one individual at a time to the mixture, and provides that statistic. And that's because if you have a two-person mixture and you have two profiles that explain the combination of alleles present there, the likelihood ratio for those contributors in the hypothesis 1 of the likelihood ratio greatly increases the likelihood ratio 2. But that can also be used to show that two people cannot be included in a mixture as well. So it works in both ways.
I'd like to turn to section F, pages 17 through 19, where it says assigning the number of contributors. Do you see that on page 17?
Yes.
What specifically was being tested here, and what data was used?
So this is, let's see, F. 21 samples from section D were chosen, again representing 2, 3, and 4 person mixtures, and again representing a variety of template amounts of that lowest contributor. So this is testing, since ground truth, we knew what the number of contributors was to the mixture. This was testing artificially saying, what if an analyst put in one contributor less or one contributor more?
And what would happen for each, if you could go over each scenario?
Sure. So when you put in less, what usually happened is the software said this is not plausible explanation and stopped running and did not give an interpretation because that happens when more alleles are present at a location than can be explained by two people. If it did run through where enough alleles were not present to stop the interpretation of the profile, if the profiles were of substantial or a strong template amount, or RFU as we're calling it from StarMix, then it did not have very much impact on that as well.
With the underlying validation, did Bodie run a test, something called N+1?
Yeah, so that's the other side of this scenario where we would have run an extra contributor compared to the known number of contributors. So the similar result happened that if the major contributors, the higher amount of contributors were unimpacted by the change in number of contributors, but the lower contributor, the likelihood ratio actually decreased because you're splitting the ambiguity of the lowest contributor alleles into trying to explain two different genotypes instead of one.
Okay, so specifically, were there any N+1 tests mixture that was at quote unquote 0%?
I believe there was.
I'm showing council what's been marked as S21. Runner handing down a copy of S21.
Thanks. You're on the approach.
I'm showing you what's been marked as S21. Do you recognize that?
So this is a StarMix deconvolution report from one of our validation samples.
Okay, and specifically, this is one of 662 pages. Is that correct?
Of the StarMix report, yeah. The StarMix report was 662 pages long.
And is this essentially, it's the first page of the deconvolution report, is that right?
Yeah, this is the summary page. That's the very first thing the DNA analysts would see when they get a final report out of StarMix.
Can you explain to us what we're looking at here in this deconvolution report as if it relates to the N+1 testing?
So in the information section where it starts with case number, that's where in the validation we're describing that it's a 3P or 3% mixture and the lowest contributor is 100 grams. The sample name is a 10-5-1, which tells me that this is a ratio of 10 to 5 to 1 contributors of those 3 contributors that we had made in the lab with the controlled amount. And then the comments are telling me that it's just run under the assumption that it's that number of contributors plus one. So up at the top right under run parameters, we see that the validation scientist has input that this DNA profile should be analyzed as a 4-contributor mixture.
And when we look at where it says summary of contributors, do you see that?
Yes.
And it has contributor 1, 2, 3, and 4. Do you see that?
Correct.
And then under that, it gives the estimate RFU of each contributor. Do you see that?
Yes.
And then the estimate mixture proportion of each contributor. Do you see that?
Yes.
And is contributor 4, that's essentially at 0%, is that right?
That's right.
Okay. And then you see where it says template RFU, where it says 28?
Yes.
Just curious, why if this person is at 0% in the mixture, why would there still be some template there?
So that's a very low amount. If you remember from our analytical threshold to detect allele peak is 125 RFU. So what this is most likely that because it's being informed that there's 4 contributors, it's looking for some sort of genetic information from that 4th contributor. The ratio it calculated is 0%, but it has potentially modeled a very, very low level of template amount to that contributor.
So is this essentially the equivalent of testing a minor contributor down to 0%?
Artificially, it can be considered that the software is just trying to look at a very low level and model of genetic contributor.
Thank you. I can take that back from there.
Add a little bit to the statement about some of the standard operating procedures that were derived from this section.
Yes.
So one of the procedures that we have is determining that a portion of the mixture is interpretable, and this is similar to how we perform manual calculations as well. So if we can look at a profile and determine there is a large amount of genetic information and then maybe just a few, one allele could be that drop-in that we talked about previously, we have a way to assess how much visually on the DNA profile of a contributor is there, and the analyst can decide what is an interpretable portion of the mixture versus what is not suitable for comparison.
Thank you. We could turn to section G now, drop-in, pages 19 to 20. Drop-in was discussed quite a bit, but I'm going to ask you if you could to tell us what specifically was done to test this particular phenomena here, and what samples and what data were used.
So this is looking at 3 samples where we artificially entered data that was not in the DNA profile, so that we could model, or so that we could see how StarMix would handle if there were extra peaks in the DNA profile. So what we expect based on our estimation of calibration, where we set up to 250 RFU could be considered drop-in. What we want to see is that StarMix did not call any of those allelic or weight any of those high as a probability for allelic. And what we see here is in table 7, those scenarios work no matter how many of those drop-in peaks were present or artificially put into that DNA profile before it was entered into StarMix, until it reached a point where it was above that 250 cap, and then it automatically stopped and said this number of contributors cannot explain this mixture because there is a mixture allele that's not explained by this. It was a single source sample, so if you put it in as a 1, the StarMix software stops saying it can't be explained by a single source.
Is that what you would have expected to see here?
Correct, based on the settings that we set at the 250 RFU cap.
I'd like to turn to section H.
Can I stop for a second? Do you have S147 in front of you?
147?
Do you have that in front of you?
Yes.
So let's go to table 7 for a second.
Okay.
For the court's edification, we have the 3 samples there. It says D1 underscore 0.05 NG.
Yes.
And then you have these different loci. and then you have D1 underscore 1.5 NG, and then D1 underscore 1 NG. I need you to walk me through that table in layman's terms as much as you possibly can.
Sure. So the donor 1.05 NG sample, that one is a single source sample that we created in the lab, and it is at 0.5 nanograms of template that we estimated to go into the amplification reaction. The alleles that you see and the loci that you see listed in the table for that sample, those are alleles that are not present off of the genetic analyzer because that was a single source sample. Those are alleles that we put into, artificially entered those numbers, the 10 for D8, the 10, and the 249. We artificially entered that into an Excel table that was then imported as data into StarMix. So StarMix doesn't see the electropharogram or the peak heights on the DNA profile. What gets exported from that is the numbers into an Excel or a text table, and that's imported into StarMix. So these numbers are, again, artificially added to the DNA profile Excel table to mimic what would happen if there were extra peaks in a profile. Does that help?
Yeah, go ahead.
No, and I'd like to look at section H if we could, pages 20 to 21, where it says forward and reverse stutter. Can you explain to us what was done here and what the purpose of this study was?
So this used 5 samples, single source again, ranging from different template amounts, from 2 nanograms down to 0.2 nanograms. And we discussed earlier that the initial analysis from our analysts is done with stutter filters on in that GMember IDF software. And then those stutter filters are turned off so that the stutter peaks are in that Excel table that we export as data and import into StarMix. So what this is doing is we want to make sure, again, kind of similar to drop-in, we want to make sure that StarMix is not artificially calling those allelic peaks when they are potentially the stutter artifact byproduct of the amplification process. So in this case, table 8 indicates that the 2 nanogram sample had 33 peaks in stutter position labeled, and 0 of those were interpreted as alleles in the deconvolution.
Okay, and that's on page 21, is that just for the record?
Page 21, table 8. Okay. And so on as you continue down, as the strength of the template amount or RFU of the true alleles decrease, so does the stutter ratio is just a portion of that peak, so then less and less alleles are observed above the amplification.
Again, is that something you would expect to see with this testing?
Yeah, this is showing that it modeled those correctly as stutter and not allelic.
We can look at section I. It's on pages 21 to 22, where it says intra-locus peak height variance. Do you see that?
Yes.
This was discussed a little bit yesterday, but can you explain again what that is?
Yes, so this is, again, kind of looking back at, we had modeled in the first part of the validation or that estimation of parameters, we modeled what we expected peak heights to look like and balance ratios within a locus to look like from the 2 alleles from the contributor. So this test is then testing that model. So we're inputting the data again to show what it looks like against the model that we had calibrated in the first part.
Why is that important to do that?
You want to show that StarMix has the model that you have, the biological model that you created in that first part is effectively analyzing now the samples and interpreting them.
So what, if any, conclusions were drawn with respect to section I?
So figure 10 shows that the majority of our interpretations done in StarMix in this section were accurately within or close to within the expected model. And that's showing on figure 10, again, kind of going across linearly, like as you have more and more average peak height or template RFU, the stochastic effects or the consistency of the genetic information is a lot tighter and more reproducible. And then as you have lower average peak heights, you have a lot of variation in what peak height you can observe.
And that's on page 22, table 10, or figure 10.
Page 22, figure 10, yes. Those red lines represent the model of that mechanism, and the black dots are what our interpretation is. And you want to see the dots or the samplings within those red lines to show the model is working.
You could turn to section J, 22 to 23, the interlocus peak height variance. What was tested here and what data was used?
So this is just showing one sample and showing it against the model that was made in that first section. So the model is the red line showing what that pristine.
This table, I'm sorry,
table, figure 11 on page 22. So the red line is the model, and the blue bars are how represented to that model, how close to that model our data came. It's important to note that the scales on these are different, so the heights don't matter, but what matters is the pattern. So if you look at the very far right, you'll see a kind of a W pattern in the red line, and we see that W pattern in the blue bars below.
Did the data indicate whether the modeling process was working correctly and as expected?
So yes, so we would call that as that sample was modeled within our model parameters.
You could turn to page 23, section K, which is challenge testing. Pages 23 to 24. Can you explain what challenge testing is?
Yeah, so that's part of developing some of the limitations to the software when the software not work. When we can artificially, again, challenge the software with different data to see how it would react or how it would perform compared to how we expect it to perform.
Specifically, there's a table on here that says table 9A on page 23. What are we looking at here? Can you explain this?
So series table 9 lists the 3 challenges that we gave the software and the description of what we did to each challenge and what the star mix result was and the reason behind that.
Okay, and what was that?
Would you like me to go through each one?
Yeah, sure.
So the first one, there was an artificial allele added at the D3 locus to a 2-person mixture. The allele added was a 19 at peak height 1,957, and that's noted as similar peak height to the 17 from the minor. So StarMix did include that as the genotype for that calculation for that D3 locus, and that's because even though we artificially added it, it appeared to be part of that contributor.
Is that what you would expect to see from
That's what I would expect to see.
And did that conclude the challenge testing in that section with regard to the summary?
That concludes that if there is a peak of similar height to other contributors, that it should be considered as allelic, and potentially to that contributor.
And you have on page, on page 24, there's another table, table 9B. It says challenge 2, effect of a drop in peak. Can you explain what we're looking at here in this table?
Yeah, so this is similar to that drop-in test we did. The allele that was added was only at 120 RFU, so as we described before, that could be modeled as possibly allelic, but also possibly a drop-in event. So ultimately there was no change in likelihood ratio at that locus, and that's because that allele that was artificially added was not considered was not considered a high likelihood ratio. Phrase that. Was not considered as part of contributing to that genotype for that contributor.
But finally, there's table 9C. Is that Can you just explain what this is? And it's part of that testing.
Yeah, so the same test of adding another allele, this one was at 4,024. This one again prevented StarMix from running because that extra allele prevented the scenario of running this as a one-person mixture was not an explainable result anymore based on that extra allele in the profile.
I'd like to turn to section L, mock evidence samples on page 24. Do you see that?
Yes.
Can you just explain to us what mock testing is with regard to DNA analysis?
Yeah, so this is a significant portion of every validation is you have a lot of control studies, but then you want to see maybe when you don't have so much control over how exactly the sample was prepared, how that performs. So we do that by comparing to what our visual or manual interpretation of the sample is. And so these were different training samples that went through that some of our either laboratory or DNA analyst training personnel had done as part of their training process, and we used those to compare to how they would, what the StarMix results would look like.
Okay, but I guess, can you explain what a mock sample even is? Like, how is that taken?
It varies. It could still be that we control, for example, for a sexual assault case scenario, we might mock where we put some blood and some semen spotted onto a swab for the analyst to take through the lab. It could be, depending on what you want to model, you could take, if we want to simulate a two-person mixture, we could swab the top of a water bottle from one person and another person with the same swab, intentionally creating that mixture. We don't know exactly what proportion of that mixture is going to be, but we're expecting to see those two known donors in the mixture.
And is the purpose of this type of testing essentially to more accurately model what you would see in the real world, for lack of a better term, in samples outside that include degradation and whatnot? Correct. I'm going to draw your attention to page 25, table 10. Do you see that?
Yes.
Right, and what are we looking at here? It goes over onto 26 as well.
So in total, there's 15 mock evidence samples that we looked at, ranging again from the number of contributors and the amount of genetic profile or template photography per contributor. We have how that sample was manually interpreted, what statistical calculation, if any, was done with the manual interpretation, and then compared that to the StarMix deconvolution or interpretation of the profile, as well as the StarMix likelihood ratio.
And how did those mock samples fare? What was the outcome of that testing? And if you have to go through each one to explain that it's easier.
I think overall I can explain that it was very close to the manual interpretation. There's a section after that table, table 11 on page 26, that kind of talks through some of the differences that were observed. And sometimes the manual interpretation generated or interpreted the mixture with a little bit more genetic information than StarMix, and sometimes StarMix generated an interpretation with a little more information than manual. So, but in general, they were very comparable to each other.
I'm going to draw your attention specifically on page 26 of table 10 to sample number 13, where it says TRN 1777-0961-EO2. Do you see that?
Yes.
Okay. Can you explain to us what we're looking at here with regard to each column?
So the manual interpretation called this a mixture of at least 3 individuals, and that's important to note that in manual interpretation, we do not distinguish a number of contributors of 3 or 4. We call anything with at least 3 and at least 3 mixture manually. The manual interpretation deduced the major component of that mixture, and the reference profile that was provided as that case scenario. I'm sorry, I should describe a major mixture. So in manual interpretation, again, we can determine that a portion of the mixture is suitable for interpretation. So in a major mixture, we would have had 2 contributors that we would have said is interpretable and 1 contributor that we would have not made conclusions on. So the major mixture is the 2 contributors, and the person of interest that was provided in the mock case scenario was included in the major mixture. So that would have been a CPI statistic.
What was that statistic?
1 and 1.1.
And was there a likelihood ratio that was run as well?
So in STAR mix, instead of CPI, the statistical calculation is the likelihood ratio. So when this was interpreted with STAR mix said there was a 69% and a 28% contributor, and that trace contributor that was seen in the manual interpretation was estimated at 4%. And the person of interest, the reference profile that was provided, generated a likelihood ratio number of 1.6 to 10 to the 23rd.
So just to be clear, this particular sample was ultimately run through STAR mix?
Yes.
And it deconvoluted out three contributors?
Correct. And we would have put in that we were estimating the number of contributors as 3.
Okay, and when it deconvoluted out, it gave the estimated percentages of each contributor. You see that?
The mixture proportion on the STAR mix report that we previously done.
Okay, and what is the percentage of the most minor contributor in this 3-person mixture here as estimated by STAR mix?
4%.
I'm going to draw your attention to number 15 now on that same page, same table, the last one where it says TRN 1777-0962-EO2. Do you see that?
Yes.
Okay. Can you explain to us specifically what was done here, what was deconvoluted out, etc.?
So the manual interpretation called this an at least 2, meaning there's indication of a possible third person there. They deduced, the manual interpretation could deduce the major component of that profile, but marked the minor or minors inconclusive for interpretation. In this particular case, the reference profile that was provided as part of the mock training exercise was excluded, visually excluded from that major contributor.
Was the sample also run through STAR mix?
Yes. So it was input as a 3-person number of contributors based on our evaluation of the profile and using our STAR mix knowledge to assign the assumption that it is a 3-person mixture.
Okay, and what specifically did the deconvolution show in regard to estimated percent of contribution for each contributor?
So that contributor 1 is consistent with a major contributor at 91% estimated in STAR mix. Contributor 2, 8%, and contributor 3, 1%.
What was your overall conclusion, with respect to this particular section in the mock testing?
So I think this models our visual interpretation that I talked about of what we go in with a visual interpretation, and we expect that STAR mix will be very close to that, and this would match what we expected, that we have a very, very low level third contributor. STAR mix is saying it's estimating that it's 1% of the mixture, and that's consistent with what I'm visually seeing on the electroparagram or DNA profile.
Thank you. There's one section left here, and that's section M on pages 28 to 30. Specifically, I'm going to draw your attention to where it says precision. What was tested here? Well, actually, I should first probably ask you to explain what is precision in DNA, forensic DNA analysis terms.
In this particular validation, precision is the ability to obtain the same result, basically, from the same DNA profile. So the same statistical conclusion, the same interpretation that you would get if you ran that sample multiple times, would you get the exact same answer?
You're talking about if you ran it multiple times through STAR mix?
Yes.
Okay. And what was done? How was this tested?
So this is one sample run through STAR mix 10 times to show the variability. There is variability in star mix and how it interprets. That's part of its biological model and mathematical models of how it performs. There's also sampling variability in various other places of calculating the likelihood ratio that contributes to this variation. But what you see is the variation is fairly minimal in terms of how it changes the statistical value or weight of the likelihood ratio.
Are you able to elaborate on that when you say it's very minimal? What do you mean by that?
So especially with the higher template amount RFU, it would not change your kind of statistical weight or verbal scale that you would provide to the court. The variability could more impact when you're at the lower average profile peak height. That variability could, or if you're at the border of one of those verbal scales, it could change which category the weight is in.
During this portion of your validation study, has this variability ever been so large that it has led from an exclusion to an inclusion?
So not observed during the validation, and in terms of the, like an exclusion, like it's never changed from this sample, or this profile could be visually excluded to it is not possible to be in the profile, or to be explained in the profile, but it can change. Again, the weight of the statistical calculation can change, and if you're on that border of where the verbal scale is, or if you're at the very low end and tending towards close to 1, it would be plausible that you potentially had a low level limited support just barely above 1 that could change to just barely below 1 with this variation.
Ms. Naughton, overall, based on your training and experience and your use of star mix and the validation itself, have you found it to be accurate, reliable, and well suited for its use in your lab?
I do.
And ultimately, did the validation study demonstrate that star mix is suitable for its intended use for the interpretation of single source and complex mixture DNA profiles, including profiles of complex and low-level mixtures?
I believe it does.
Could you have one moment? Nothing further.
Sure. Software engineer. Your background is in forensic DNA analysis?
Yes.
Just speak up. You were not involved in StarMix's development?
No.
You've never seen the StarMix source code?
No.
So you're not aware then of how the source code implements the StarMix model?
No.
You're also aware that when StarMix releases a new version, they will often change their model?
Yes.
They've over the years modified how allele variance is modeled?
We have not validated, or I have not been trained on additional versions yet, so I'm not familiar with the exact details of the changes.
Are you familiar with how 2511 models allele variance? Can you explain?
Within Model Maker, it's going to look at the data that we've imported as far as the data straight off of our genetic analyzers. And it's going to look at the peak heights and the peak heights at specific RFU per se, and it's going to determine, or it helps determine what that variance or balance should be both within that interlocus or within a locus, what balance you expect to see from a single contributor, and then also again across the whole profile, what trend and peak heights you expect to see across the profile.
What is the relationship between allele variance and RFU?
So as RFU increases, allele variance should be more minimal, like that you should have more balanced within the location. The two alleles from that contributor should be well represented at approximately the same peak height. Whereas if you have low average peak heights, you could, instead of having 80% balance per se, it could fall below 50%. So it models those potentials.
As peak heights get shorter, the variability increases?
Correct.
Is there any upper cap on that, or is it as the peak heights get lower, the variability always goes up?
There's no cap that up. As the variability gets, as the peak heights get shorter, the variability increases with no cap.
You're also aware over the years that the burn-in process has changed with StarMix, right?
I'm actually not aware.
Are you familiar with something called Smart Start?
No.
Can we agree that even if the model itself doesn't change, the way that the source code implements the model could change?
Yes.
And you were not involved in any of that? No. So you wouldn't be able to offer an opinion? Can we agree that you're also not a theoretical Bayesian statistician?
Yes.
You're aware that StarMix uses a Metropolis Hastings sampling algorithm?
Yes.
But that is not the only sampling algorithm that a Markov chain Monte Carlo algorithm can use, right?
I'm not sure.
You've never heard of the Hamiltonian Monte Carlo sampling algorithm?
I have not.
So you can't speak to the relative advantages or disadvantages of one over the other?
I cannot.
Would it be fair to say that before StarMix you didn't have much experience using Markov chain Monte Carlo algorithms?
That's correct.
Would it be fair to say you didn't have any experience using them before StarMix?
That's correct.
So prior to StarMix, you've never heard of the Gelman-Rubin diagnostic?
No.
You're aware that the Gelman-Rubin diagnostic is not the only way of measuring chain convergence, right?
I do not. I'm not trained in other methods.
So you wouldn't be able to speak to the relative advantages or disadvantages of one versus the other?
Right.
Do you know how the Gelman-Rubin diagnostic is calculated?
Not specifically, but I know that in our diagnostics, we want that value to be equal or less than 1.2 to show that all of the chains that were being interpreted at the same time came to that same sampling space of the genotype.
Why 1.2?
That is the value that we were given by the developmental evaluation.
So ESR gave you that value?
Correct.
Did ESR tell you where they got that value from?
Not that I can remember off the top of my head.
Do you have a sense of what the Gelman-Rubin diagnostic is representing, other than just it needs to be close to 1?
Yeah, like I said, there's during the interpretation process, there's 8 different chains that are kind of happening simultaneously. If those chains do not kind of end up in that same sampling space to explain the genotype, then that's when that value would be higher than 1.2.
I guess my question is, how do they know if the chains are close to each other?
That's again part of the mathematical equation to calculate that I am not familiar with.
You're not familiar with how it's calculated?
Correct, but I can.
You don't know what the inputs are?
I do not.
You don't know what parameters are being used to see if the chains are converging?
I do not.
You don't know if it's just one parameter or if it's multiple parameters?
I do not.
I want to talk about validation. Can we agree that there is a difference between a developmental validation and an internal validation?
Yes.
We agree that this is a distinction Swigdam makes as well?
Yes. And FBI quality assurance standards as well.
Whenever a new method of analysis is invented, it needs to be validated by the developers.
Correct.
This doesn't just apply to StarMix. This applies to everything, right?
Yes.
If Promega wants to sell a new amplification kit, they need to demonstrate its reliability with developmental validation.
Yes.
The same principle even applies to hardware.
You said hardware?
Yeah, if you want to buy a new CD instrument, right, that has to be developmentally validated before you're allowed to purchase it.
Yes.
What's the developmental
validation? To clarify that the laboratory itself can perform the developmental validations in some scenarios, but usually it is the manufacturer of the software or reagents or equipment.
Thank you. And it's only after there's been a developmental validation that labs, at least generally, will conduct an internal validation.
Correct.
And an internal validation is how you demonstrate that you can reliably apply the method in your lab.
Correct.
The internal validation is also supposed to help you figure out where the limits are of a given method.
Correct.
You're supposed to use an internal validation to figure out where the method performs well and where it performs less well.
Correct.
For that reason, you're supposed to use the internal validation to help define your standard operating procedures.
Yes.
The internal validation study is where you have data that you can use to figure out how to instruct your analysts to use a given method.
Yes.
Internal validation studies, in addition to being important, are also a requirement, aren't they?
Yes, by those FBI quality assurance standards.
If you violate those standards, you could lose your access to codes.
As a private laboratory, we do not have access to codes.
Bodie does not have access to codes?
Correct.
As a practical matter, though, you can't implement a method unless you've conducted an internal validation study.
Correct.
That's true even if other labs have successfully implemented the same method in their casework.
Correct.
Every lab is different. Sorry, I need a verbal answer.
Yes.
You can't substitute one lab's internal validation study for another.
No.
You would never do that.
No, we perform all of our internal validations.
And specifically, we can agree that the SWGDAM guidelines on probabilistic genotyping validation require labs to try to determine what the limits are of where a given method, the probabilistic genotyping method, can be used.
I would have to read the exact standard that you're referring to.
Sure. One moment. Can you please For the record, I am displaying S6. This is the SWGDAM guidelines for validation of probabilistic genotyping software. Can we agree that that's what we're looking at?
That's what the title of the document says. Yes.
Can we agree that the first sentence of that second paragraph says, depending on the features and capabilities of the probabilistic genotyping system, some DNA typing results may or may not be determined to be suitable for such an analysis?
Yes.
Can we agree that the next sentence says that to identify data features, e.g. minimum quality requirements, number of contributors, that render a profile appropriate or inappropriate for probabilistic genotyping, the laboratory should test data across a range of characteristics that are representative of those typically encountered in casework?
Can I answer with no and yes?
Sure.
So I would like to call out that that says minimum quality requirements, not minimum quantity requirements.
Can we agree that the next sentence after that says data should be selected to test the system's capabilities and to identify its limitations?
Yes.
Can we agree that the next sentence says, in particular, complex mixtures and low-level contributors should be evaluated thoroughly during internal validation, as the data from such samples generally help to define the software's limitations, as well as sample and or data types which may potentially not be suitable for computer analysis?
That is what it says.
We can agree that determining those limitations are important, right?
Yes.
You don't want to try to use a method on data that you haven't validated before.
Yes, but it is up to the lab to determine and evaluate what limitations they've observed in the internal validations to set those parameters.
So one of those, for example, limitations is the number of contributors.
Correct.
Your laboratory only tested up to 4 contributors in your internal validation study. And so as a result, your analysts are not permitted to analyze samples that have 5 or more contributors.
Correct.
That is a hard limit that was established by your internal validation study. Before we get too deep into the weeds here, I want to talk to you about mixture complexity. I know this is mentioned in the SWGDAM guidelines. Can we agree that mixture complexity is a catch-all term for how difficult it can be to analyze a DNA mixture?
I think that's a fair assessment.
For example, you have more contributors, that increases the mixture complexity.
Yes.
Degradation of one or more contributors can also increase complexity.
Yes.
Contributor ratios can also increase complexity.
Yes.
Sometimes extreme ratios can increase complexity, right?
To some degree, to another degree, extreme ratios could be much more easy to interpret, maybe that larger percentage of the mixture.
However, if the mixtures are so extreme that one of your contributors is giving alleles, or at least a potential contributor is giving alleles that is in a stutter position of one of the major contributors, that can make things complicated.
It can reduce the weight of that evidence for that contributor.
Because it's difficult to tell whether you're looking at an allele or a stutter from the major contributor.
Correct.
There are also times when mixture ratios that are roughly even can also be complicated.
Yes.
And that's because at that point you see a bunch of peaks that are all roughly the same height. And it's possible to assign them to one versus another person.
Yes.
Another source of complexity is the total template amount that's input. We can agree that low template samples are more complicated to analyze than high template samples.
Yes.
Because you have more dropout.
Dropout, you have that more allele variance and stuff that we help establish.
Can we agree that allele sharing is another example of complexity?
It can be, yes.
So if you have multiple contributors that share alleles with each other, that is a more complicated mixture to try to analyze than if your potential contributors do not share alleles.
Yes.
And when contributors do share alleles with each other, you have an increased risk of false inclusions. If your person of interest shares alleles with the actual contributor, it can appear as though they are in the mixture, even if that is not actually their DNA.
It depends on the amount of the genetic contribution in that mixture. So if there is a lot of genetic information from that contributor in the mixture and there aren't any alleles difference, then it is possible to distinguish between that. And that resolution gets, as your peak heights get less, that resolution does.
All of the things being equal,
yes.
If your potential contributors share alleles with each other, that's going to be a more complicated mixture to analyze than if they don't.
Yes.
We can agree that related individuals share a lot of alleles.
That depends on the scenario.
It depends on the type of relationship, right?
Correct.
But siblings share more alleles with each other than they do with the general public, correct?
Correct.
They have the same two parents. They may not have exactly the same alleles.
Correct.
But they're going to share more alleles than people that are not siblings.
Sometimes. Sometimes they do not.
Sometimes they do not.
Sometimes their profiles, different profiles, can be potentially as discrete as two unrelated individuals.
But again, all things being equal, people that are related to each other share more alleles than people that are not related to each other. I understand there are exceptions, but I am asking as a general rule.
There is relatedness and allele sharing between individuals, and that allele sharing varies depending on the relationship and the chance of inheritance of those genetic alleles.
Relatedness, therefore, is another source of complexity. Mixtures with related contributors are more complex than mixtures that don't have related contributors.
It could be.
And can we agree that all of the factors that we just discussed with each other can combine with each other?
Certainly, sure.
So you could have a low template sample with a lot of degradation and related contributors?
There's scenarios that may be that way.
That may be. Can we also agree that determining the number of contributors to a sample is more difficult when the contributors are possibly related?
Again, that depends on...
As a general rule, is it more likely to be difficult to determine the number of contributors?
That's a blanket statement that I can't answer with a yes or no.
So
there's...
Counsel, you gotta let her answer your question.
The relationship could vary. Like if you have a parent-child, you might only show 50%. That's going to be very discreetly a two-person mixture, or siblings possibly might only show 25% of the same alleles. So it depends on the mixture. It depends on how many of the relatives are in the mixture to determine the complexity.
When you say it depends on how many, what do you mean?
So there are published papers that talk about So let's say you have both parents and a child, then those can be complex to interpret because the child is going to have be buried in the same alleles of the two contributing parents. That's one scenario. If you have 3 siblings, they possibly will all share and bury each other's alleles. But a 2-person mixture between siblings or a 2-person mixture between parent and child, that is generally not considered a complex mixture.
But if you had a 3-person mixture with 3 related people, you may underestimate the number of contributors because the alleles may mask each other.
That is a potential.
And as a result, your laboratory SOPs say that if you believe that contributors may be related to each other, it may not be suitable for analysis.
I would have to read the exact, again, I don't want to misstate the exact line in our SOP, but we do give guidance to our DNA analysts to evaluate the profile and the profile complexity and the case scenario to determine if relatedness could be affecting the interpretation. If it is not affecting the interpretation, even if it is a first-degree relationship, they are permitted to interpret that profile.
I do want to talk about ESR's involvement in your internal validation study. You said yesterday on direct that they gave you technical support.
Yeah, so as we are learning the software, we obviously have a lot of questions about how it works, and we're learning as well. So anytime that we had a result that we wanted to ask more about, they were available for us to ask those questions.
How often did you speak with them?
Our director of applied research would have been the one that was in direct contact. I don't have a sense of how much. I know in the first estimation of parameters, we wanted them to look at the variance of signal across all 5 of our genetic analyzers for how that model was created, so to get their input on that. Past that, I'm not sure of the extent of how many questions we asked ESR.
You spoke about this yesterday, I believe, but there are really 2 halves to the internal validation study, at least for STARMIX.
Yes.
The first half of the internal validation is the parameter study.
Parameter studies.
And that's where you use data, or rather STARMIX uses data, to help determine your laboratory-specific parameters.
Yes.
These are the allele variances, the stutter variances, the locus-specific amplification efficiency variances.
Yes.
And these parameters are impacted by a number of factors. Some kits have more variance than others.
Did you say kits?
So, yes, kits.
Like chemistries for the amplification?
Yes. Or different CE instruments can also have a higher variance than others.
I would not. If you're talking about different CE platforms versus all 5 of our genetic analyzers, we did not see a difference in variance across 5 genetic analyzers.
All of the same model.
Yes.
If you have different models, though, those can be different.
I'm not familiar with other models.
Understood. However, the data that is used to determine the variance parameters needs to be representative of what you'd expect to find in casework.
I'm sorry, could you repeat that one?
The data that you're using to determine these variance parameters needs to be representative of what you would expect to find in casework.
In this particular case, they need to be run in our internal lab through our lab process on our genetic analyzers. These are not to create this what normal DNA profiles look like from our lab. These are not the casework type samples that we talked about in the second one. These are controlled known template amounts that were used to create what a model of a pristine sample would look like.
So it's your testimony that the data that you use for the parameter study does not need to be representative of the kind of data you would see in casework?
The kind of data we would see in casework, in the fact that it is generated using the amplification chemistry that we use in the lab and on our genetic analyzers. All of that study was done, and I think I testified to this, was done on single source samples. So there are other types of casework samples that are tested later against that model.
So the answer to my question was no, you do not believe that it needs to be representative of the kind of data that you would see in casework?
I believe it is, yes. The data that we run in our laboratory is representative of the data that we would see in casework. It's just not, we haven't tested the range of data that we would see, or the range of types of mixtures, and the range that we have tested against the model in the second part of the internal validation.
I want to talk now a little bit about the memo that you wrote earlier this year that you spoke about on direct.
Yes.
And can we agree that this is that memo right here? And this would be S20? And so we're looking here at the first of the mixtures, right?
Yes.
And that's a 10 to 5 to 2 to 1 ratio.
Correct.
Now, this is where you said, I believe, the theoretical contributor amount for contributor 4 should be just over 5%?
I believe so. So the way you do the math is each of these contributor ratios are part of the mixture. So you would add up 10 plus 5 plus 2 plus 1 for 18. And then one component would be 1/18th of that mixture, which I believe is just over 5%.
Which, this is, Star Mix is recommending 3%, right?
StarMix is estimating that it says 3% based on the genetic profiling through the biological process.
I want to talk about the other two contributors to this mixture. Now, this was a 10 to 5 to 2 to 1, so the ratio of the middle two is 5 to 2.
Yes.
So the second contributor should be, roughly speaking, 2.5 times as large as the third.
I would have to, calculate probably to convert these into percentages for
I can get you calculators
to process.
Sure. Let the record reflect, Your Honor, that I am approaching the witness with actually being able to just give you amounts.
Or you can just type in 5 divided by 18 for the side and see the percent. So that 5 number is the theoretical composition to that mixture is approximately 28%.
And can we just go back while we have this here and look at what the percent Star Mix estimated was?
Sure. It's contributor 2, I think it went to 5, right? So contributor 2 says 16%.
It should be 28%, but here it's 16?
Correct.
And can we go back then and calculate what we would expect the third contributor to be?
That one should be approximately 11% theoretical.
Okay. I would like now to show you a couple of other samples from your internal validation study. Is that all right?
Sure.
The state may want to come over here. I just saved these during the direct. For the record, I am displaying on the screen what has been marked as D69. Are we looking at one of the samples from the internal validation study?
Yes.
Can you tell us what the mixture ratios here are supposed to be?
So based on the sample name, it's a 2-person mixture with a theoretical contribution of a 10 to 1.
And what percent would that work out? Roughly. Okay, no, that's all right.
So that's approximately 91% for that.
Should be 91%.
Major contributor.
And so then the minor contributor should be about what percent?
If it's represented,
It's a 2-person mixture.
then 10%.
Or 9% maybe. Can you tell us what the mixture proportions here are?
It says 62% and 38%.
And again, the 38% is supposed to be 9% of the mixture?
The theoretical input for that is yes.
Well, your lab mixed these samples, right?
That's true that they went through a biological process. This is each contributor here. If we go to the, can you scroll just a little bit? Sure. Each contributor here, or the lowest contributor is 25 picograms, so that's where that variance in peak height is going to come into effect.
So you're saying that your lab properly mixed a 10-to-1 sample, but that star mix, because of the amplification process, believed that it was a 60-to-40 sample?
So I can't make any conclusions on this without seeing the actual data that came off the 3500 to determine what the data looks like and how star mix interpreted it. So if you have the electrophoregram or the DNA profile.
Unfortunately, I don't. Can we agree that this again here is another 10-to-1 sample?
Yeah, it looks like the replicate of that same other sample. So that would have been the same mixture of that same tube put into a second amplification.
Can you explain to us how this replicate was prepared? I just want the record to be clear on this.
Hold on for a second, just so I'm clear. Is this the same document, D69, that we're looking at?
My apologies, Your Honor. We're now looking at what has been marked as D70. Thank you.
D70.
So I did not perform the lab work, so I can't 100% attest to exactly how the laboratory personnel meet the mixture or prepared the amplification.
But just to be clear, this isn't going back and re-amplifying the same sample that had been amplified previously, right?
It is.
So you went through and amplified it a second time?
Correct.
Or did you take it and you divided it up into multiple parts and amplified those two things separately?
I don't understand the distinction. I'm sorry, not understanding the distinction between what you're just
I guess I'm trying to figure out mechanically what happened here, and you're telling me that you either can or can't. Do you know how this was prepared?
Off the cuff, I would need to look at the laboratory notes, which are in the data validation binder, and confirm that my interpretation of what this replicate means is that it is a separate, based on the name, I think it is probably the second amplification of this sample, a separate amplification reaction that happened from this mixture sample.
So they made a mixture and they divided it up into two parts?
Yes.
And then amplified those two parts separately?
If they made the mixture twice or made an aliquot of that mixture, I am not familiar with that exact detail.
But again, this is a 10-to-1 mixture?
Yes.
And again, that means that we should be looking at a major contributor with 91%?
That's the same math as before, yes.
And a minor contributor with about 9%?
Yes.
And can you tell us what the mixture proportions are here?
67% and 33%, but again, this is based off of the DNA profile results that are off of the genetic analyzer that you've not shown me. So this could be the same as what I manually interpret this profile as well, despite the theoretical value.
When you say the theoretical value, you're referring to now the star mix prediction or what?
Theoretical calculation of the 10-to-1. We need to see what that genetic data looks like as an electrophoregram in the DNA profile, and how I would be able to interpret that for me to give any weight to how star mix interpreted it.
For the record, I'm now moving on to D71. Now this is a different sample. Can we see that it's a 20-to-1 mixture?
Yes, based on the sample name, I believe this is a 20-to-1 mixture with the lowest contributor of 25 picograms.
And again, your laboratory mixed this sample itself.
Correct.
You're supposed to know the ground truth.
Correct.
What percentage of the overall mixture would we anticipate the minor contributor would give here?
If the minor contributor is actually represented in the DNA profile adequately, that's the one that was just below 5%, I believe, the 4.7%.
And can we agree that this mixture proportion here is 70 to 30?
That is what star mix is showing, but again, I would need to look at the data. It's possible that this electrophoregram is actually only containing genetic information from a single donor, and it was forced into star mix as a tube based on the theoretical composition of it.
But you only know that because you know the ground truth here.
I know that because I know how to analyze and interpret a DNA profile off of the genetic analyzer in GMember index.
But you know the genotypes of the two contributors that were put into star mix.
Not by memory, and not when I'm analyzing a sample for determining if there's one or two contributors to the sample on the electrophoregram.
In your internal validation study, you mixed these samples together.
I personally did not mix these.
Your lab did.
My lab did.
And your lab knew the genotypes of all of the donors that were mixed into these samples.
Correct.
So when you're saying that you needed to go back and look at the electropherogram, the reason why you're able to know that that minor contributor either does or does not have any alleles present is because you already know the minor contributor's genotype.
That's not correct.
Can you explain why it's not correct?
Because I can look at a DNA profile and determine the number of contributors before I even try to assess, even if I didn't know that sample name, I can look at a DNA profile and determine if I think there's one DNA profile contributing to that sample, 2, 3. So at 25 picograms, that is where our stochastic effects, again, greater allele variance, you have a high chance of more genetic profile. And it's all about that template amount is calculated from an estimate from quantification as well. So there's estimates there in terms of how much was put into the reaction.
Can you
so
explain what that is?
The process that goes through, it could be on the actual data that this was interpreted from, it could be truly only one donor is represented on that electropherogram.
How would you know that there was only one donor represented on that electropherogram?
As a trained DNA analyst, I know what to look for a single, to determine number of contributors, and I can do that without knowing the genotypes of the particular contributors.
How would you know that you were looking at an electropherogram that only had one contributor on it?
It would have no more than 2 allele peaks above analytical threshold at each testing location.
Can we agree that it's impossible to know in practice, in casework, what the actual number of contributors to a mixture is?
Yes.
Can we agree that, again, when you have lower template samples, an analyst may underestimate the number of contributors?
That's possible.
Can we agree that when you, again, have related contributors, an analyst may underestimate the number of contributors?
That scenario is possible.
And you're telling me that if you were to go back and check this right now, you would not look at the reference profiles for the 2 known contributors?
Correct. The first thing I would do is look at just the DNA profile itself, come up with my manual or visual interpretation of that profile. If I'm visually also interpreting that as possibly this 70-30-ish percentage, then StarMix is not inaccurately interpreting that profile as it's presented to the software.
But just to be clear, your lab mixed together, or at least attempted to mix together, a 10-to-1 mixture, or a 20-to-1 mixture.
Correct, and a lot of these mixtures, when we were pushing that boundary of the lower limit, it's not necessarily the lower limit of StarMix, but it's the lower limit of what our genetic analyzers and our GMAP or IDX software can detect.
What is that lower limit that your laboratory set?
So alleles can only be called at analytical threshold, which is 125 RFU. We can amplify any amount, and we evaluate the DNA profile for suitability. In our standard operating procedure, we just established a limitation that you have to have genetic representation at least 3 testing locations or loci in order to deem that component of the mixture interpretable. So that is how we set our limit of where we deem a component of the mixture is interpretable.
Your limit is not then set by input template amount?
It's not set by a binary input template amount.
It's not set by mixture proportions either?
No, as shown earlier, mixture proportion alone can vary greatly depending on, there's a combination of effects, just like you said, a combination of effects that if degradation is happening, if one contributor is outperforming the other, the complexity of the mixture. Again, so we set the limitation based on visually what we can see in the DNA profile.
I just want to be clear that the answer to my question then is no. There is no mixture proportion limit that your lab uses to determine whether or not a sample is suitable for analysis for StarMix.
No, we do not know the known mixture proportion in casework before we amplify and run that result.
There is no lower mixture proportion limit that StarMix can give you that will cause your analysts not to report a given result. If StarMix says that there's a 1% minor contributor, your lab will still report that.
Not necessarily.
But it could.
It could, depending on the amount of genetic information from that profile.
I would like to also go back now to the parameter study. This is S19. Specifically, we are at page 22. Can you tell us what we're looking at here?
That is the results for our sensitivity study that was in this section across the different donors.
So I'm going to zoom. I'm going to zoom into the top right here, just so that we can all see it a little bit better. Can we agree that this is showing a couple of different things? First, it's showing, for example, that some of your CE instruments are more sensitive than others.
I don't think that's necessarily what it's showing.
Can we agree that what this is showing is what the average peak heights were for a given donor for a given input template amount?
Yes, it is showing that.
And so can we agree that, for example, donor 6 on one of your CE instruments is giving an RFU that is a little over, what's that, 10,000?
Which
Donor 6 is the purple one, the lowest one.
donor 6, the purple, is 10,000, correct?
And can we agree that the highest RFU that donor had for the same input template amount was around 22,000?
Correct.
And can we agree that we see that happening across other profiles as well?
Yes.
So again, the same donor giving the same input template amount is going to give you a different RFU peak height depending on which instrument is measuring.
What's not shown on this graph is that same result can happen even if you inject the same sample on the same instrument. There is injection-to-injection variability in our genetic analyzer that we measure in our lab as well as across instruments, and this is within the variation that even injection-to-injection on the same instrument would create.
But just to be clear, the answer then to my question is yes, this is showing that the same input DNA from the same contributor measured by different CE instruments could give you a range of RFUs?
Yes.
Specifically some that are twice as high in some instruments as others?
In this particular D6, that is true.
Can we also agree that if we look across different template amounts, I want to look on D7. Now, can we agree that looking at, again, the 2 nanogram input template amount and the 1 nanogram input template amount, for some reason D7 is giving smaller peak heights than the other samples?
Yes.
Can we agree that that's also happening when we look at 0.5 nanograms?
In some scenarios, yes.
Can we see that that's also happening, roughly speaking, when we're looking at 0.1 nanograms?
Sure, it seems to be the lowest of all of the donors.
Consistently, D7 appears with the same input template DNA to give you an RFU that is half as high as the highest one.
So this goes back to there is variability in the quantification estimate of how we quantify human DNA. That is a known variability in our validation studies of the quantification chemistry.
Can you explain to us how that process works, the quantitation?
I absolutely can. So when we have a DNA extract, we will take just a small portion of 2 microliters, which is a very minimal portion of that DNA extract, into the quantification reaction. So there is sampling variability there of how many cells per se went into, or how many DNA molecules went into the quantification, and it's considered an estimate. So that estimates how much human DNA quantity we have. From that value, we can then dilute. We expect, honestly, this would be within my expectations of how much variability if we had 10 different samples, an estimate of quant, and then try to target 1 nanogram per se, we see variability even more than 2-fold sometimes within the RFU.
So you're saying then that as you're trying to create these mixtures that your method that you use to measure the amount of DNA has variability?
It has variability.
That can lead ultimately to a difference on a factor of 2 to 3?
Correct.
So you're saying that there's a possible error in terms of the input template amount that could be a factor of 2 or 3?
So that's why we're calling the theoretical values, the theoretical, and then what we want to do is look at the data profile to see what then the data profile is showing.
So you're telling us you can't be sure if you've actually mixed a 10-to-1 mixture.
There are other factors also involved in terms of how well each DNA extraction performs in an amplification procedure that, again, contributes to variability that is modeled, or that is expected within our field of how we know the final DNA profile is what and the DNA analyst will use to interpret what portion of the mixture is observed from each genetic contributor.
I'm going to ask the question again. Can we agree that when you try to make a 10-to-1 mixture, you can't actually be sure if you put a mixture in a ratio of 10-to-1?
It is most likely not going to be at exactly 10-to-1.
Apparently here it could be off by a factor of 2 to 3?
Based on RFUs, yes.
I know that we spoke about determining the number of contributors a few minutes ago. I am going to pull up what has been pre-marked as D60. D62. Can you tell us what we're looking at right now?
This appears to be one of our standard operating procedures at Bodie called BTF 00278. Statistical interpretation star mix, and this particular version is revision number 7 that was effective since March 18th, 2021.
So we are going to go down to page 12. Now, this is on the x-axis here, the number of alleles that were observed in a given mixture.
These are simulated mixtures to help an analyst determine how often number of alleles in different types of genetic contribution mixtures there are.
And the way that they did this was they would make a 2-person mixture, a 3-person mixture, and a 4-person mixture.
Correct.
And they would analyze them.
Well, then we would count the total number of alleles expected to be from those contributors.
You would count the total number of alleles that you saw on the electrophoregram.
This is not electrophoregram data. This is simulated profiles of complete profiles.
Simulated in what?
Simulated from statistically sampling from the allele frequencies table to mock generate theoretical DNA profiles. So these are not profiles that were run in our laboratory.
Can we agree that the overlap there is an example of a mixture that is ambiguous? For example, if you have 89 alleles, it could be a 3-person mixture or a 4-person mixture?
So this particular graph is just one tool that we use to help determine number of contributors. So total number of alleles, yes, ranges, and there is some ambiguity between different types of mixtures. There is some overlap, but what also is used is evaluation of number of alleles at one particular location. Max alleles at one count at one particular location can also be helped to inform the DNA analyst as well as peak heights.
So can we agree then that the answer to my question is yes, there's overlap here between the 3 and the 4-person mixtures?
Yeah, in this graph,
can we agree that when you had 89 alleles, that could be a 3-person mixture or a 4-person mixture by looking at this graph?
If you're looking at total...
Only this graph?
Yes, if you're looking at total allele count only, that's in the mixture profile. If it had 89, there were simulated profiles that were both a 3 and a 4-person mixture.
Can we agree that there's more overlap between 3 and 4-person mixtures than there are between 2 and 3-person mixtures?
Yes.
Can we agree that it's probably likely then that there would be more overlap between 4 and 5-person mixtures than there are between 3 and 4-person mixtures?
Yeah, that has been presented and published.
Can we agree that this chart does not show what the overlap would be for a 5-person mixture?
Yes.
Can we agree that your analysts routinely have to distinguish between 4 and 5-person mixtures?
Yes. Or 4 and more than 4 is our distinction.
Okay, we're going to take our mid-morning break now. We will start back up at 11:50.
All right, here's the bad news is I don't have the afternoon session. So that's from November of 2024. My next video is from August of 2023. So sorry, guys. We don't get to hear the rest of that exchange. All right, well, let's go to August. That's the best I can do. Plus the audio was off with the video, so we'll just move forward. All right, let's go to August 17th hearing. All right, so this is an August 17th hearing. Hearing from August 17th, 2025. All right. I do know what happened though with his, let's see. So March, okay, so we're going to August 17th. So I do know from March 11th, judge allows powerful DNA tool. So New Jersey judge ruled that prosecutors can use evidence from a powerful and increasingly common DNA tool in the upcoming trial. Judge Mark Lemieux agreed with prosecutors that STR mix or star mix, which allows forensic analysis to test tiny, complex DNA samples that likely would have been considered unusable a decade ago, had withstood repeated testing and were found reliable. Star mix works and it appears to work very well, he wrote in a 212-page ruling last week. So that was in beginning of March of this year. So the DNA is coming in. After all of that, the DNA is going to come in. All right, so this is from, we're getting near the end. This is an hour and 47 minutes. Then we have one more hearing from September, which is 21 minutes. So we have like 2 more hours or so to go, a little bit over 2 hours. So if you guys are figuring out your schedule, that's where we stand. So the Judge Lemieux said that star mix is coming in. All right, let's continue on. Let's see what this one's about. Okay.
For the record.
Good morning, Your Honor. Assistant Prosecutor Nicole Wallace on behalf of the state.
Morning, Judge Chris Decker, Assistant Monmouth County Prosecutor.
Good morning, Your Honor. Monica Mastellon on behalf of Mr. Paul Caneiro, who's present in court.
Good morning, Judge Andy Murray for Mr. Caneiro. All right, good morning, everyone. Good morning, Mr. Caneiro. All right, so we're here this morning for several reasons. We've already had the pretrial conference back about a week or so ago, but we're back here today because since the last time it's actually a couple weeks ago, but since that last time, the court has rendered the last 2 decisions that were outstanding, dealing with the state's motion for certain intrinsic evidence to be admitted into court. The court's made that determination. The court has also ruled on the ballistics testimony in this case, indicating that it would allow that testimony at the time of trial. In saying that, the court at the last date also gave both sides the opportunity to file any in limine or evidentiary hearing motions that were due by last Friday, August the 8th by noon. I did receive several in limine motions by the defense, so those will be discussed today as a part of the overall conference that we're going to have this morning. We're also going to discuss some of the other outstanding issues that we still needed to discuss from the pretrial conference. So let me start with this. We have gone back and forth with the verdict sheet. It was supplied to me by both counsel. I had an opportunity to review it. I made some corrections or some stylistic changes and one correction to it and sent it back to the parties. At this point in time, are we all in agreement as to the verdict sheet as it's been presented and we've all reviewed.
The state is okay with the judge based upon the revisions that the court made.
Okay.
The defense agrees, Judge.
Okay, great. All right, so that one is taken care of. The second issue that we discussed at the last conference that I want to bring up again here today is the issue of note-taking. This trial, as it's presently scheduled for, is scheduled for September the 8th, and we're going to tell the jurors that the trial could potentially go to the third week in November. Because of that extended period of time, the court requested the positions of both counsel as it relates to note-taking in this case. On a normal case, you don't really need to have note-taking because the jurors could watch, they can remember. But because this trial is going to be so prolonged, I have brought up the issue for the both counsel to consider. While I have received some preliminary thoughts from both counsel as it relates to note-taking, I wanted to put it on the record here today because I do have some concerns that if we don't allow for some form of note-taking, that it would potentially create a significant number of readbacks later on when the jurors are deliberating. I should give you so that you have some understanding about what I mean by note-taking. So the way it would be set up is that each juror for each one of their chairs would have an assigned notepad. It would have the number on the back of the actual cardboard that would say juror number 1, juror number 2, all the way down to juror number 16. Those pads would be placed on their chair each and every morning by my court staff. The jurors would be able to write on them throughout the course of the day. On breaks, they would leave them actually physically on their chair. They wouldn't be able to take them with them. They would have to leave them right here. At the end of each day and at lunchtime, my staff would actually take those notepads, keep them. They would be kept in my chambers during the course of overnights and for during the lunch hours so that no one would be able to have access to them and or be able to read them for any notes that they may have. And then they would be put back on their chair for the next day. As the trial goes on, if they have more than one notebook, we would give them additional notebooks as they requested it. And then they would be given the opportunity to use as many as they need. I would suggest that what we would do is, because they don't need to go back and refer to their notes during the course of the trial, once they were done with notepad number 1, they wouldn't see that notepad again until they were done, and they can have that in the jury room as part of their deliberations. So that's kind of what the way that I envision it. However, I'm open to suggestions from both sides. And or if your position is that you don't think note-taking is necessary for this case. With that being said, I'll start with the state and your position as it relates to note-taking.
Yeah, Judge, obviously I understand the court's concern, and the last thing that anybody wants is a situation which seems to be far too common about readbacks and more readbacks and things like that. I'm just not so sure that the goal that we're trying to achieve is necessarily going to be assisted by the note-taking, especially when the court's talking about how, if they finish one notebook, then they get another notebook. I'm concerned that it's going to become a situation, which is, I think, why jurors don't generally take notes, at least in this county, for the last several years. It's because it does breed somewhat of a less paying attention as opposed to, hearing and writing. And I think just the jurors paying attention is the best thing for everyone, in my humble opinion. That being said, I think if the court was going to kind of decide on its own that note-taking is the best scenario, which the court can do, and it's not an issue that is going to leave me, crying at home tonight if the court went the other way. I do think, though, that the court should give that logical instruction that, hey, you don't have to write down every single thing. Like, this is just the only reason we're giving you the notepad is because it's going to be somewhat of a long trial, and we want to ensure that, your recollection is recorded in some way at the times when it needs to be. You know, I don't know, I just don't know. And I know that I Googled it very quickly after we spoke yesterday, and I forgot to go back and do it. I know there's a civil note-taking jury charge. I believe there's a criminal note-taking jury charge, based upon my recollection. And I know it's probably like a 2-page thing, and it may include some of that stuff. I will take a look at it. But I do think I worry that by trying to alleviate readbacks, we're now having a bunch of jurors that are going to be in a room for 3 weeks comparing notes during deliberations. And that's really what I worry about. I just think paying attention is the best way, despite having never been a juror to be a juror.
All right. On the defense?
Judge, so with the understanding that the court this is an issue that's within the court's discretion, I recognize that, and I know it's guided by Rule 1:8-8B. With that said, though, the defense would object to note-taking in this particular case, and here's why. So I learned this fun fact about multitasking a long time ago, that we think that we can multitask. We can do multiple things at once, such as listening and taking notes, but actually what our brains are doing is just very quickly going back and forth from one task to another task. So we perceive it as multitasking, but our brains are actually just very quick at changing function, and we're not actually doing two things simultaneously. So with that said, Judge, I think our justice system and our New Jersey case law has recognized the concerns. In State versus Jump 261 NJ Super 514 at 525, quoting another New Jersey case, Wigler versus Newark 125 NJ Super 179 at 182 to 183, they just expressed that the appellate division expresses some of the general concerns. And they state the reasons advanced against this practice, meaning note-taking by jurors, include the contention that the taking of notes by a juror may tend to distract his mind from the evidence which is being presented while he is taking notes, may distract the attention of other jurors from consideration of the evidence being presented, may tend to overemphasize either to himself or to other jurors the evidence on which he is taking notes. Further, that the taking of notes might tend to be a confusing element for those jurors not trained or skilled in the note-taking process. And I think we have to keep that in mind, Judge, that these jurors are normal people like us. They're not trained stenographers. And so I do think that the process of taking notes will distract from their ability to pay attention to the evidence. And more specifically, Judge, my concern is that, you know, we all know the case, right? Because we're the lawyers and Your Honor has presided over the matter. So if a witness is on the stand, we generally know what to take down, right? Because we know like what points we want to make sure to get to the jury. We want to make sure we know certain things that the witness is saying that we want to address perhaps. But the jurors are coming into this as they're supposed to be blank slates for the most part. So my concern is that they will not know what is important. We're just throwing a massive information at them. And I think unless and until you take a step back after hearing all the testimony, that's when you can start to kind of piece it all together and say, well, I think this is important. I think this is important, especially when you have it presented to them the way it is, which is by witness. So it is kind of piecemeal. So my concern is that you have a witness on the stand and they're talking about, you know, like maybe just describing generalities of the crime scene. And they're noting down all of these things that maybe aren't actually relevant, maybe not something in dispute by the parties. And then the witness says something important and they miss it because they're too busy taking notes about things that really they probably didn't need to take notes about. So I think my concern is that if we allow them to take notes, it's going to distract from their ability to actually to ensure that they are paying attention to what is important, to everything that's being said on the witness stand. And Judge, also, you know, I think that it would be an easy mistake to make given the complexity of the case and the multiple moving parts. So and if we have a DNA analyst on the stand and they're talking about probabilistic genotyping, again, my concern is like they're going to be writing down maybe the basics of DNA and miss an important point about a more complex issue. I think also, Judge, the problem with note-taking is that you're looking down a lot, right? I mean, we can type without looking down, but we typically can't write without looking down. So I think it's really important for each and every question that is asked of this witness and each and every answer that the witness is giving, whether on direct or on cross, that the witnesses have the opportunity to have their undivided attention on that witness so that they can observe body language and they can observe eye contact and they can observe the characteristics that Your Honor instructs them on in the beginning or at the end and says, when we talk about credibility of a witness, you can take into consideration all of your observations about that witness. And that could be missed if they're looking down while they're writing. In addition, Judge, the jurors should be looking at the actual evidence that's displayed to them. So they might miss, like, if, you know, if the state has a detective on the stand, the detective is showing crime scene evidence. They might miss a detail if they're looking down. I also agree with the state that it will cause the jurors to rely on those notes rather than their own memories. And because they're not trained stenographers and they can't shorthand every single thing that's being said, they could make mistakes in their notes. They could mishear something and now it's memorialized. And now the jurors are inclined to rely on that as opposed to what their independent recollection is. It's easy to mishear testimony or mistake it and write it down and then later inappropriately rely on that. And again, when we're dealing with more complex forensic sciences, that is I think a higher risk that could occur here. The notes could be partial or incomplete and later misinterpreted by the jurors. It also lends to a possibility where jurors are, certain jurors who have better notes, so to speak, or more thorough notes, so to speak, might kind of take on a more leadership role in the deliberations as opposed to, I think, the ideal dynamic, which is that each individual plays an equal part in the discussions. You know, even just...
You don't have to keep going. I'm going to agree with you. If you want to keep going, though, you can.
Meaning Your Honor is not going to order note taking? Okay. Thank you, Judge. With that, I'll submit.
Okay. The thought behind it was exactly what I said. Based upon the positions of both parties, I will not order note taking under the circumstances of this case, and we'll go forward and see how it goes. All right. Next is the issue of we have discussed the statement of the case. Obviously, the statement of the case will be provided to our prospective jurors to make sure, just based upon the limited information that we give them, whether they're going to be able to be fair and impartial or not. Both sides have had an opportunity to look at that. I'm just confirming that we are good on the statement of the case, correct?
That's correct.
That's right, Judge.
All right. Next is the preliminary model charge that I gave to the jurors, or excuse me, that I gave to the counsel, that I would read to the jurors after we go through the initial screening process to get jurors that would be able to sit for the period of time for this trial. Did everybody have an opportunity to look at that preliminary model charge, and is everybody okay with that?
We are, yeah.
Judge, I did have an opportunity to look at it, and I appreciate that the court incorporated many of those questions for the searching voir dire. If that's what Your Honor...
Not there yet. I'm only on the preliminary model charge.
Oh, yes, Judge, that's fine. Thank you.
Okay, all right. I'm going to get to that, I promise. All right, so let's talk about now the voir dire question. So for the record, the court put together a list of voir dire questions, which includes a lot of the searching voir dire questions that the defense was concerned about. Normally there's 28 or 29 questions. We now have 39 questions to make sure that we address these issues. And I want to be abundantly clear, if there are any questions that I find that a prospective juror is waffling on, I will dive in and make sure that I ask a significant number of questions to make sure that we get a fair and impartial jury in this case. But I did try to address all questions that the defense were looking for as it relates just to the yes and no questions. We'll get to the open-ended in a second. But In saying that, does anybody have any issues now with those questions, the 39 questions that we have?
The state does not, Judge.
Okay.
I think it's 38, Judge, because we took out that 33 and replaced it.
But you're correct. We did. We moved that. We were going to make that in the open-ended question. So there's 38 now, but you're correct. So from the 38, any issues with that?
I don't have any issues, Judge. I just wanted to ask for a quick clarification.
Of course, go ahead.
Which is simply that when I originally submitted my proposed change of venue related searching voir dire questions to the court, they were obviously open-ended and the court converted them to yes or no's.
Right.
So I just want to confirm we're doing this in the traditional sense that when the jurors have yes answers, we'll call them to sidebar and discuss them. So there may be some follow-up at sidebar.
Yes, 100%. So what will happen is that after we have a large group of qualifying jurors, we will then bring up somewhere between 50 to 100 in this courtroom. We'll put our first 16 in the box, but I'll ask the entire group all of these questions. They'll have a check off sheet that will have just each number where they can check off all their yes answers. I will then start with juror number 1 and ask them, do you have any yes answers? If they do, I will go through each one of them with them. I will probably do that, a majority of that, at sidebar. To be clear, we're going to do sidebar right in front of here. We're not going to do it on the side. So you'll come up with your notepad. We'll make sure that if you want, for Mr. Caneiro's purposes, that if he wants to have headphones so that he can hear what's going on up here, he'd have the opportunity to do that. Unless you want to do the shuffle method, that's up to you. And then I'll question that individual juror. Once I know that they're qualified or not, and with those answers, I would put them back. Once I get through the 16, then I'll come back. We'll do the open-ended questions together with everybody, and the biographical questions with everybody. If that answers you.
It does. Can I make a suggestion, Judge?
Sure.
/ maybe an objection. I would just ask that the open-ended be asked at sidebar as well. I think particularly in a case like this where we're talking about people's opinions about, firearms and things of that nature, I would prefer to have people feel like it's more of a confidential conversation than have other jurors hear their responses and perhaps tailor their responses or be not as forthright with their answers if they're strongly opinionated people. So I would just, I have had, judges suggest doing open-ended questions out in the open, but I've always successfully convinced them. So I'm hoping I can successfully convince Your Honor that we do it at sidebar. That's how I've always ended up doing it. And I think it just, it preserves the integrity of the open-ended question process.
Mr. Decker.
I essentially defer to the court. The court obviously has conducted substantial numbers of voir dires in the past. The one thing that we have to be concerned about is this not taking forever. And that I think is a primary concern. We want to get a fair and impartial jury, but we don't want it to take forever. And I don't personally think that it really should take forever.
And look, we're in a situation now where New Jersey, we are also looking at, in certain cases, not in this case, but in certain cases, doing attorney-conducted voir dire where we have people's opinions are being addressed by everyone. And to the extent that a sentence that may be said by juror number 1 has an impact on juror number 6, that they feel differently or triggers them to remember something that they want to say, I don't see the need to do open-ended questions here at sidebar. I like the idea of having communication with them so that they feel a little bit more comfortable in here. So your objection is noted for the record, but I'm going to do the open-ended questions from the from the jury box. I know you wanted to say something, so go ahead, feel free.
I was just gonna say, Judge, I think it actually tends to be more efficient if we do it after the way that I've always done it is they finish all the yes and the no's, and then if we make it through that without them being excused, then we just say, okay, and we just have 3 more questions, and then you ask the open-ended, and again, it's more of a private situation. I agree with Your Honor, obviously, New Jersey's transitioning to ACBD, but that's not this case, and unfortunately, what we're unable to do here is ask the jurors, like, well, so how do you feel about the answer of juror number 2, juror number 14? We can't do that. So that's my concern is like, we're asking jurors to express intimate opinions that maybe they don't feel comfortable expressing in front of others, and we may be deprived of knowing their true feelings. So if juror number 2 says, I hate guns, I hate everyone that owns guns, and I think that they're all bad people, then juror number 3 might not disclose, well, I think guns are great and I own 6 of them. Like, that's my concern, because it's easy to avoid.
It may do that anyway. I mean, you're assuming that certain answers will be curtailed just by that. People curtail their answers just because they're sitting in a courtroom. Look, I hear what you're saying. The reality is this: you have one experience. This court has an experience that I feel extremely comfortable with the fact that we're going to do open-ended questions in an open forum. So I appreciate it. Your objection, though, is noted for the record. As it relates to the open-ended questions, now that one of the eliminate motions here today was to include a 4th open-ended question. The court, after receiving that eliminate motion from the defense for that open-ended question, as a result of the court's opinion as it relates to certain items of evidence that the state was going to produce, where the defense has objected to it, the court has made a ruling that it would allow that evidence in, that the defense had requested a specific question as it relates to gun possession. I had indicated that I would do that as a supplement, as a question, part of the yes or no questions. It was going to be number 33. However, after a conference yesterday, I believe it was agreed to that we would take out the proposed question number 2, open-ended question number 2, that everyone had agreed to, and now we're actually just going to take that question that dealing with guns. We're going to keep that as an open-ended question. We're going to make that question number 2. So we have 3 open-ended questions, and we have the 38 voir dire questions. Does anyone disagree? Did I say anything that was incorrect that we've all discussed?
Judge, we completely agree.
Okay.
Agree, Judge.
Okay, so that takes care of that for now. For my own edification, it applies to both sides. I don't know if the defense, this is even something that you would have to consider. Are there any witnesses in this case that are under the age of 18?
Judge, no, I do not believe there are any witnesses under the age of 18.
Okay.
Unless I'm forgetting something, but I don't believe so.
Okay. If there is, for some reason, I need to be notified sooner rather than later. And don't call anybody in here without.
I'm largely confident that there's not.
Okay.
None from the defense.
Okay, great. All right. So as a reminder, the trial, as I said, will be from September 8th. We're planning until November 26th, which is the day before Thanksgiving. We're going to hope to get that done prior to that day. But we'll see how it goes and how each and every day goes. But I want to tell you the schedule so that we have it for the record one more time. The courtroom will be open at 8 a.m. Every morning so that the attorneys can get in, they can get set up, whatever that they need to do. The defendant will be seated and ready to go by 8:20 in the morning. And assuming that as soon as he's seated, the courtroom then will be open to the public as soon thereafter. So by 8:22, 8:23, so that anybody that wants to come to watch the actual trial, they'll be able to get in around that time. The way that the seating will be set up is there will be 2 rows that will be set up in the back for the media, for any media that wants to attend. There are also this first row here right next to the jurors. That row will be only for people from the courthouse. We won't allow anyone that has an emotional attachment to the case to be seated right by the jurors, so that there will be no issue with that. We will inform any staff member that's seated there in that first row that they're not allowed to have any communications talking about the case or anything else. If they want to come and watch the case, they can. However, that they're not allowed to have any interactions at all with the jurors during the course of the testimony. We will have, for purposes of family members, we will have a court staff, someone from our court staff here to help escort them in so they have a place to sit, both for the defense side of the case and for the state side. So you can inform the people that are coming to just let the person know at the door, I'm here on behalf of Mr. Caneiro, I'm out here on behalf of the victims in the case, and we'll have them a row set up for that. Otherwise, it's first come, first serve. Whoever's here, they get a seat. So that everyone is aware, there's a conference room right outside the courtroom door that will be set up with media in there. So that conference room will not be available for the attorneys, just in case you needed conference room for some reason. And then the courtroom right next to mine, that courtroom's going to remain open for overflow for people that want to come to the case and they'll be able to sit in there, they'll be able to watch it on a TV. Or if media wants to be in there, they'll also be able to be in there also. So just to give you an idea, we will have this courtroom, we will have the one next door, there will be a conference room. The attorneys should be cognizant of the fact that there is media that's going to be a part of this case, that you should be careful at both counsel table and outside of whomever that you may be talking to, or that things that could be overheard. So you just want to be smart in those conversations. You all experienced lawyers here. I don't need to tell you. I just want to make sure that you're at least informed of what's going on. As I indicated, the testimony will start at 8:45 every day. I do not want people to be late. Everybody in here knows me now. They've watched me through many testimonial hearings. I will be sitting on this bench at 8:44 and 59 seconds. So we should all be ready to go. Don't show up late, because then that will be something the court will address. We're going to end at 5 o'clock each day. However, if there's a reason why that we're very close to finishing a witness and either side says to me, can we just hold on and keep going? I will. All you have to do is tell me. If you don't tell me, I'm going to assume that we're not close and we're going to keep going at 5 o'clock. Or excuse me, we're going to stop right at 5 o'clock and no later. As of right now, we will be going 5 days a week unless noted by the court. We've had some preliminary discussions behind the scenes as to maybe some potential days off. We'll discuss those more once we have a jury and we know exactly what we're doing. But you should be prepared right now that you're here with any of your cases or anything that you have else. You may have other responsibilities going on. You'll be here every day. Like I said, this case will be live streamed. Be careful with the mics, counsel table, and sidebar, things that you may or may not say. We discussed this in conference before we started here this morning, any potential stipulations or consent orders. I'm not going to get into specifics of that, but if there are some that are, there is going to be certain stipulations. Here's the court's order as it relates to them. If there's an agreement, the two sides will actually write it up as to what the stipulation is or a consent order that you've agreed upon. That stipulation, you're going to tell me if it's you want me to read it, if it's a witness, if it's the prosecutor is just going to read it, or if it's a defense witness and you're going to read it. I don't care who reads it. That's up to you all. But just know that I need to see it beforehand. The stipulations will be signed by the attorneys. It'll be signed by the prosecutor's office, by the defense, and by Mr. Caneiro. You need to understand, any stipulations, I will question Mr. Caneiro outside the presence of the jury with the stipulation to make sure that he has seen it, he agrees with it, he has signed off on it, and that we're all ready to go. So just make sure that we've covered that. And then have two copies. We're going to have one that's signed, which will be for the court, and then one, just remember, a stipulation would go into the jury room for deliberations. So that one will not be signed by everybody. I don't want that to be, that's not necessary for the jurors to see. I'll explain it in a jury charge. So, but they sign one, so we'll have two copies. Sign one for me, one that'll go in for the jury. Any questions on the consent orders or stipulations that we need to discuss? State?
No, Judge.
Okay, defense?
No, Judge, I mean, I understand the court's indicating the court would like the Mr. Caneiro, the defendant, to sign the stipulation, meaning that he has no objection to it.
Yeah, that's all he's saying. He's not agreeing to he's not doing anything other than saying that basically that he's in agreement that we're stipulating to this.
Stipulated at the trial by the parties.
That's it. Okay, we discussed this before, without getting into specifics, transcripts. All transcripts, we ruled on certain transcripts as it relates to coming out of certain facilities. And I had indicated if there was something that becomes relevant during the course of the trial that I would not foreclose the state. However, are all other transcripts, have they been turned over?
Judge, they have, yes.
Okay, and if Ms. Massalone, have you had the opportunity to review them? And are we in agreement as to whatever they say for each one of those particular calls or whatever else that's being transcribed?
We're talking about the transcripts of the body worn camera.
Well, not just the body worn camera, the other transcripts also.
I haven't received yet the transcripts for the jail calls that the state was intending to use. I thought they were gonna narrow it down.
I thought that was done as of July 31st and that
the transcripts have all been turned over.
Right, of the 200 jail calls, but then we had discussed that the state was gonna at least narrow down which calls they were gonna use, so I could supply, my proposed redactions and objections. So I followed up about that, but I don't have that yet.
Mr. Decker, before I respond to this, go ahead.
I don't recall the court imposing an absolute deadline on where, I could be wrong, on which calls we were going to use. We are still working.
Not on the calls. Well, here's what I said. I said that jail calls that will be used must be identified by July 31st. All transcripts for those calls by July 31st. I said any objections to those calls would be by August the 8th by noon. And then I said the state will be allowed to use other potential jail calls if they become relevant based upon testimony during the trial, or if the defendant indicates something that would be inconsistent with a jail call, that would be something that could be considered if he decides to take the stand. That's what I've said at the last time that we were here. So to go back, whatever calls that you're going to use, have you indicated to the defense, these are the ones, and you've provided transcripts?
Can you ask that question again, Judge?
Sure. The jail calls that will be used during the course of the trial, have they been identified and told to the defense?
They have not been identified. The transcripts have been provided, but they have not been specifically identified.
Okay. All right. Because there were so many, what I had indicated is that I would not bar you from using as many as you need if they become relevant later, but out of fairness, if there were certain ones that that you were using, I suggested that you turn those over so that the defense could look at those transcripts so that we're not in the middle of this trial and we're fighting over what a word says in a particular transcript.
I know that I recall the specific discussions about taking out the global tel link. This is a call from inmate Paul Caneiro, et cetera. I did not recall having to specifically, I'm not saying that I'm right. I'm just saying that's just my recollection. Mm-hmm. That being said, we're aware of what the court said. If move for reconsideration by providing a small number of phone calls that we intended to use without consideration of others that would
how much time do you need to turn it over? The numbers that you're going to call?
By Friday.
Done. So by Friday, which is August 15th, by noon, that they should be turned over. Any objections should be responded to by August 22nd, 1 week later by noon. If there's anything that needs to be addressed by the court, notify the court by August 25th at noon. And then I'll figure out a return date if I need to.
Yes, and
Hopefully we don't need that.
yeah, and Judge, it's not a lot. It's not going to be a lot.
Okay. All right. As it relates to, now we'll go into the other ones. Body worn cameras, all that, we're all good with?
Yes, I just wanted to confirm, just from my recollection, I know that Ms. Mastalone had sent over certain changes that she wanted to make, which we agreed with. And I know that we put in place having them made. I believe they've been provided, but I just wanted to confirm that.
Yes, they have. Those transcripts were provided. The state did indicate previously that it had agreed with all of the defense's proposed changes. In all candidness, Judge, I haven't reviewed those line by line. I'm trusting that they incorporated them, but I will do so, before in the near future just to be sure.
Okay. Are there any other transcripts or anything else that I haven't mentioned? Because I don't want any issues coming up.
No, there's not. Nothing that hasn't been discussed previously. Everything's been turned on.
Ms. Massalone's about to stand up, so maybe.
No, Judge, I was just going to also note we did also receive redacted body worn camera transcripts as well.
Okay.
Those were also provided.
And were you comfortable with those?
We're still reviewing those, Judge.
Same timeline if there's an issue.
No problem.
Bless you. Yeah. All right. Okay, I did receive the proposed witness list, which is approximately 8 pages long of witnesses. This includes all witnesses, correct? Both the state and the defense?
Yes, Judge, with the only caveat being that if we discover along the way that there's one person we inadvertently missed, we are going to bring that to the court's attention as soon as possible. But yes, I did add the defense witnesses. I didn't delineate state from defense. So that's that.
Here's the thing. I understand with the amount of the complexity of this case that you maybe have missed someone. But by September 8th, when that rolls around, you got whatever it is, whoever's on this list, that's it.
That's more than fair, Judge. And I don't expect that to become some sort of issue. I just wanted to kind of protect myself.
I understand.
In advance. And I also do expect that by September 8th or before, I may be able to give you a more manageable list that you can slide into that jury booklet.
Right.
I don't.
Which we do need. Yeah.
I understand. I'm just, we're still working through some of this stuff. And also there's names on there that just maybe heard. So I think it's appropriate. We've discussed this previously on the record. So sure.
Mastalone, do you disagree with anything that was said, or is there anything about the witness list that the defense objects to?
No, Judge, no.
All right. This will be the witness list to the state. Thank you for the other list that I had asked for. So I have a basic understanding just in going through voir dire. All issues for the defendant's clothing, has that been settled and taken care of? Is there any issues that I need to know about or get involved in?
Not at this time, Judge. We've been in contact with Lieutenant Hansen. He was on vacation last week, so now that I think he came back yesterday, so we're in the process of coordinating with him.
Okay. Any issues, please supply them to me immediately so I can get assistance to you in any way that you need it. Any other security concerns that I need to know about? I know I addressed this before and everyone said no. Just want to give everyone another opportunity. Is there anything that the court should be aware of that I'm not aware of right now as it relates to informing the Sheriff's Department?
Not that the state could think of, Judge.
Okay.
No, Judge, I was going to ask at some point if we could reserve this front row for family members. Just, I don't know, something for the court to think about.
It's going to be that side.
Okay, yeah, that's perfectly fine, Judge. I was just hoping that if we knew the designated area ahead of time, we could work that out.
Yeah. You mean who gets the first row and who gets the second row when I reserve it?
Either way is fine, Judge.
Yeah, I'll let you know. Yep, no problem. Other than that, I've indicated that when we got to today, all discovery has ended. I'm confirming there's no other discovery related issues that are outstanding. We're not going to have any more discovery except for if a witness that you're prepping that may say something that you have the continuing obligation to turn over. But other than that, everything that you have has been turned over and we don't have any issues.
Yeah, Judge, I don't foresee any issues, Judge. I mean, we've been providing discovery for years now. And the majority of that which has been turned over more recently is as a result of further inquiries and, things that maybe they pointed out that we didn't realize weren't provided. We've tried to do our due diligence. We've assisted the defense as best we can. We've also, I know it's a little bit of a different issue. We've already met twice in our evidence vault with the defense. We're meeting with them again today. So we're doing everything we can to work professionally with counsel to make sure that, anything they need and vice versa.
Okay. From the defense?
I agree with that, Judge. We've met numerous times and had the opportunity to review evidence in this case. The state's been very accommodating in that regard. I do appreciate the court's directive that no additional discovery be provided at this time. As the court knows, with respect to the preclusion of the media or the electronic communications motion, that was a little bit of a hassle, but it's been worked out. So I would just, again, ask that this be it.
And there's no requests outstanding? Any discovery requests that you haven't received the answer of? We don't have it, it doesn't exist, or we've already turned over. Is there anything else out there that I need to know about?
There's nothing outstanding. And the defense is meeting with the state one last time today to continue reviewing the evidence.
The physical evidence?
Correct.
Okay.
And there's been photographs that have been taken, and those will be supplied to the state. Like, they haven't been taken yet, the ones from today. Those are just photos of the evidence that we're looking at. And then there's a couple other photos. But other than that, Judge, yes, discovery is complete.
Okay. Speaking of photos, let's just do that now so we don't have to come back to it. Mr. Decker, I assume that the state will have some form of a photo book in this case of what you're going to be using. Do you have a timeline of when you're going to turn that over to the defense and to the court so that if there are any issues or if Ms. Mastalone wants to add some photos to it, we can kind of do it all at once before the trial starts? Have you thought about that at all or not yet?
I've certainly thought about the photo book, Judge. It will be marked S1. The only thing that I'm working on is obviously putting it together. I have different portions of it put together. For instance, autopsy photos. For instance, photos from 27 Tilton. We have the arson photos that have already been used, some of the Watson stuff. So I'm just deciding whether or not it's going to be set up from 27 Tilton, photos 1 through 50, 15 Willowbrook, 51 through 80 or 1 through 30, depending on just trying to finalize that. But we are still trying to finalize certain pictures. That being said, my intention would normally have been to provide it prior to jury selection to the court and to the defense.
That's fine. What we'll do is that if you can supply it to the court and to the defense, if you have it by September 5th, which is the Friday before, I would appreciate that. What I would do is, Ms. Mastalone, is then that following Friday, because no photos would be going up on the screen in that first week, because we're going to be picking a jury anyway, that if you had any issues with particular photos, you can let me know, and then I'll address them on the record, and we can go from there. I would also suggest, and tell me, Mr. Decker, if you're doing it a different way, that if you have certain photos, instead of having to go and try to upload them or try to get them on a computer or whatever it is, if you want to add those photos into the overall PowerPoint, you can do that. Now, I have experience in the past where attorneys say, well, I don't want to give it to them yet because I don't want them to know what I'm going to ask questions about. That could be your way of handling things. I really don't care. Whatever you want to do is fine. But I'm just giving you that option. I'm sure Mr. Decker would accommodate that request so that things would run a little bit more smoothly. All right.
Thank you,
We would.
Judge. One other thing that does remind me that I haven't received it from the state, and vice versa. We've sort of talked about it, is just, I know both parties might intend to use some like Google Maps photos with certain witnesses, maybe just to show like your house is located here and this is where 15 Willowbrook is, or this is, so I don't have any issue with the state using the Google Map photos. And so I don't need them super ahead of time. And I would just ask that the state accommodate the same. I don't have all of my Google Map photos just yet.
Okay.
Yeah, that's fine.
All right, that's fine.
We did talk about that, Judge.
I know we have used a couple during the Watson hearing, I believe. Yeah. But yeah, I mean, I would probably use fresh ones or that sort of.
Are you going to be, just so that I know, are you going to be using Google Maps from a 2018 version? So it looks like it did then, or is it whatever it is now that you'll be using? I don't really care. I just want to, just so that I know that if I have anything I got to deal with.
It's a fair question. I will give it some thought and let the court know it's fair. It's fair. I mean, I think certain places, depending on what they are, they look the same.
Right.
Certain places, they're obviously different. I mean, if we were to show an overhead map of 15 Willowbrook right now, there's not a house there.
Right.
So, I mean, yeah, but it's a fair question.
Okay.
And the ones I anticipate, Judge, I can let the court know, the ones I have, like when you go to, Google Maps or satellite, Google Earth, you can change the date. And I think the closest to November 2018 was, it's either June or September 2018. It's very close. So I think some of mine are going to be that. I have no objection to the state using ones that are updated if the foundation is laid, like this was taken later and this is changed or something.
Okay. All right. Perfect. All right. All right, so the photo book 9/5 by noon. Okay. All right, now let's talk about the issue of the in limine submissions that were submitted by the defense on August the 8th. The first issue that I'll discuss is one that we've already, I think is already taken care of, is the request for voir dire dealing with the gun issue. Do we all agree that that request has been addressed? There's nothing further that needs to be done based upon the additional open-ended question?
We agree with that. It's been addressed.
Okay.
I would just renew the objection that I would ask that it be asked at sidebar, but that's all.
Okay. All right. And that's noted. All right. So that one is taken care of. Then the next one we'll talk about is to preclude electronic communications. So when the court made a ruling on, I believe it was August the 5th, as it relates to certain states' evidence, that it was going to be relying upon communications between the defendant and the victim, Keith Caneiro, the court made a finding that conversations that occurred on April the 10th and April the 11th, those conversations would, 2018, they would be admitted. And then also dates in September, dates in November, and then the night before this actual incident. The court also had made a finding earlier back in the early part of July. It was around July 10th. I don't have the exact date in front of me. It was a motion by the defense to bar certain evidence from being admitted. It's a suppression motion based upon State versus Missick. The court agreed with the defense that the information that was taken from the defendant's phone should be limited only to the dates surrounding the actual offense based upon the affidavits that were supplied to the reviewing court at the time, which was November 19th and November 20th, 2018. In that decision, I had indicated that the state would not be able to use evidence outside of those two dates from Mr. Caneiro's phone, that they would have to find those communications that they wanted to rely upon based upon another independent source. The state has, when the court made this ruling on August the 5th, the defense had brought up the issue that some of the communications that were relied upon by the state in that motion that they're not located in any other area in the discovery. I had informed the state that they were to find that information, or if they could not find that information, that the court's decision obviously would have to be altered as it relates to these items of evidence. We had a conference this morning. It is my understanding now that there are certain communications that were not present in any other area of the discovery, and I'll allow the state to put that on the record so that we can flesh it out and make sure that the record is clear, and then we're going to come up with a resolution on how that will be documented. The court had talked about a consent order that both sides agree of what you could use, but I'll allow Ms. Wallace to explain this, and then we'll come up with that conclusion. Go ahead, Ms. Wallace.
Thank you, Your Honor. That's correct. There were text message communications on April 10th and the 11th, and then September 6th that were not located anywhere except on the suppressed phone. So the state will not be using those, and I can submit to the court. I think Your Honor wanted the specifics of what they were.
Yeah.
I can submit that.
Okay. So anything that is not within your brief, or that was in your brief that's not within that discovery, that should be precluded and from any testimony in this particular case because you don't have an independent source. Ms. Messalone, you want to address any of that other than what I just said?
Judge, I would just agree with that. I think we can accomplish it by way of a consent order that just, the April 10th, we could say, for example, the parties agree that the text messages that the state discusses that occurred on April 10th, 11th, and September 6th outlined on the respective pages in their June 13th brief are precluded from use or admission at trial. And then the parties agree that the remaining 3 conversations that are listed in the defense's original certification and updated letter, which is September 13th, September 17th, and November 5th, that those are admissible. The concern that I have, Judge, is
some of the April is there, correct?
not the text messages.
Not the text messages,
I think
but
the
other
state referenced an email.
Yeah.
Right, but the defense is never challenging the emails. The defense is only challenging the presence of text and electronic communications.
Okay.
Not email, because we were able to discern the emails from the data that we originally had.
Okay.
I understand that the state is indicating, like, for example, I think we discussed in chambers, there might be something over the summer, and it was sort of summarized as facts. It wasn't clear, like, exactly, at least not to the defense, exactly how they were intending to get that in. So if those are specific text communications, I would just ask that the state, identify them or at the very least, double check that they're there and provide a certification that they're there. Because it's very tedious for the defense to have now been presented. Now we have access to this program that the state gave us yesterday, which now we can pull up these conversations and we have to go through them. And I want to just, for the court's edification, put a footnote in my letter, like, it's not like when you go through a phone extraction and you see a whole conversation back and forth. It's not like you're reading it in the little speech bubbles, how we've seen. This is more unique. And what it is the state provided us with a program yesterday where it filters the data, and it kind of looks like how Outlook looks like, how an email an email platform. And so each text message appears as if it's like its own email, right? And so it's not a back and forth. And the problem, Judge, is like also the text messages don't say to whom they are being sent. There's no identifier. It just says Keith is who it's from, and then like the message itself. So what the state demonstrated to us and what they told us and what we were able to discern yesterday evening is that what you can see is that there's messages from Keith to an unknown, but then there's messages received by Keith from, for example, the phone number assigned to Mr. Caneiro, right? So in context, it's like a message from Keith to an unknown that says, just as an example, like, what time are we having lunch, right? And then the response from Mr. Caneiro would be, how's noon, right? So like if you read them back and forth and they're actually in consecutive order, it's like clear, it's Keith, it's Paul, it's Keith, it's Paul. We can discern that information. My concern comes into play with, there are other areas where Keith's texting multiple people at once. So you can't actually fully tell, who the messages are to if it's like kind of out of context. So, with, for example, these over the summer messages, I don't know if it's as clear as the ones that we're conceding you can put into context. Like, are these conversations continuous, or is Keith texting 5 people at once and every 5th message is to Paul? That's what we're surmising. So that's why I think it's a little bit more involved. And I think if the state can provide it ahead of time, at least we'd have the ability to double check ourselves, or if they accompany it with a certification, we could feel comfortable, like we don't need to double check it. They're saying it's there and that it's discernible.
Okay. Ms. Wallace?
Judge, the state will provide the order requested. We'll come up with a consent order like we discussed. I think it's my understanding that what's being objected to and what the state is agreeing we are not going to use are those April 10th, 11th, and the 6th communications.
September 6th.
I'm sorry, September 6th communications. As far as things over the summer, I don't even anticipate really using any of that. I included that in the brief, but I don't foresee that. It's really...
Well, I ruled on a part of it, so if you decide not to use it, that's fine. Whatever you want to do, it's your case. Just inform the defense that you're not going to use it. So then at least the record will be clear as to the fact that I've permitted you to use something and then you decided not to use it. That's fine.
Okay. But we'll come up with that consent order. We have to meet on other things like we discussed today anyway. And as far as the layout of that council was discussing of the actual, what the screen would look like, it's my understanding that with respect to what I memorialized in my brief, that what is there is not being objected to based on content, but the defense might request to have maybe like the full conversation in which the state would not object to.
Okay. So
just to the record's clear, we did object, but Your Honor ruled that it's admissible. They filed the motion to admit under 4.4b and intrinsic. We opposed it. The court ruled that they're admissible. So we're
well aware of 68 pages of an opinion. I got it. Nice. So the court's not going to issue an order one way or another on this in limine motion. It's going to wait to get a consent order from you. That consent order should have in it, Ms. Wallace, please, discussing this in limine motion. As a result of the in limine motion, we have consented and whatever it's going to be. Okay. I will do an order for the voir dire of the gun so that you have an order as it relates to that in limine motion of how I addressed it. Okay?
If Your Honor, thank you. That's fine.
Yeah. All right. So the next issue, next in limine motion, was to preclude autopsy and graphic photos. This morning, the state provided the court with its photos. We've had an opportunity to discuss it briefly. We're not going to do these graphic photos in open court at this point in time. What I have asked counsel to do is to review these together. They're going to be together all day today. And they are to see if they can come up with some agreement. I've already given some preliminary thoughts on certain photos that I would have concerns with, and also understanding that the state may need certain photos for purposes of proving its case for each one of the victims that I would be inclined to allow. However, the defense has spoken about the potential of maybe stipulating to certain things, and if that's the case, what I'm asking the parties to do is to come up with a stipulation that both sides agree to as it relates to these photos. I don't care who reads it one way or another. But again, there will be 2 copies of the stipulation, one that will be signed by all parties and the defendant, and one that would just be marked and sent into the jury room after the case went to the jury. But I'm going to allow counsel, both sides, if they want to put any arguments on the record, to be able to do that now as it relates to the photos.
Judge, I'll be brief. I think we discussed this in chambers. I don't want to get too specific out here. I understand that some of these photographs are graphic. Unfortunately, that's the hand that we're dealt with respect to the horrific nature of these deaths. In particular, most likely or most probably poignantly with Sophia and Jennifer Caneiro, given the state of the bodies. We try to be guided accordingly. I understand that there was objections to certain photos. I understand they're going to argue that we have to think about the jurors and the reaction they may have. I get that. I've spent a lot of time looking at autopsy photos that I don't want to look at, quite frankly, but I looked at. And unfortunately, it's part of doing our job to prove the cause and manner of the death, whether they are, challenging it or not. I'm not going to get into it further. I look to the court. We look to the court this morning in chambers for some insight, because I am realistic in the fact that I don't want to go too far if it's not wholly necessary. Therefore, we will look to pare this down in conjunction with a potential stipulation. I have given some thought to being able to say, for instance, in summation, that we didn't show you this because, quite frankly, it wouldn't be fair. It's so bad that, these deaths, etc. So I'll give it some thought. We'll discuss further today and be guided accordingly. And if we can come to a resolution, I hope we certainly can.
We'll have the same time frame that we had for the other issues that we discussed, that by if you come up with something, it would be due by August 15th. Together collectively. If you don't come up with something, I want the objections by then, and then I'll figure out a day to hear it after that. So it'll be August 15th if there is objection. But Ms. Massalone, I had indicated to you in chambers that I would give you the opportunity to object to these on the record, even if there is some ability to be able to come to some stipulation that both sides agree to. Go ahead.
Thank you, Judge. Just to clarify, did Your Honor mean August 22nd as in next Friday, or Your Honor?
No, because I'm going to need more time.
Okay.
So I'm going to give you to the 15th as it relates to this one.
Thank you, Judge. So yes, just with the qualifier that we did have the opportunity to conference it, and the parties have indicated that we're amenable to meeting and conferring and see if we can resolve this with a stipulation. I just in the event that we are unable to agree, or if the state beyond the stipulation is still seeking to admit certain photos, which I understand also may be the case, I just want to place the objection on the record. So I appreciate the court's indulgence with that. So yesterday afternoon, Judge, the defense did receive 25 pages worth of either autopsy or on-scene photographs that are graphic in nature. They amount to 50 total photographs. I think it's actually pretty evident. I would say that the defense objects to a large majority of these as being either not relevant or unduly prejudicial. And I'll rely on the case law that I provided in my brief. I know the court's well aware of it. But I do just want to highlight, I think the court really, part of its gatekeeping obligation here is to assess what is the actual purpose of each of these photos. And that's where the defense just wanted to take the time to highlight a couple of things. One, the defense doesn't challenge the cause and manner of death in this case. And nor, I know in the state's...
Of any of the victims.
Of any of the victims, exactly. Tragically, the victims in this case are deceased as a result of gunshot wounds, stab wounds, and or smoke inhalation. So that's not contested. The angles of the stab wounds are not contested, as they are identified in the ME reports. Again, I think the photos speak for themselves. How many, as well as the autopsy report. So how many bullet wounds there are, or how many stab wounds there are per particular victim, not contested. We did have the pretrial hearing with regard to the arson, so I understand why the state, in its response brief, was expressed a concern, like, well, what if the defense is challenging the time of death of the victims? And I clarified, we're not challenging the time of the death. There's a lot of circumstantial evidence in this case that can lead any reasonable person to arrive at the conclusion that the murders or deaths occurred during a specific time frame. Again, we're not challenging that. So I think, and I also indicated that, there's a witness that the defense is not going to call. That's, related to that, sort of tangentially related to that issue. So if that assists the state or the court at all as well. That was Mr. Wood. So the point is, Judge, is like when we're looking at 50 photographs, right? And I had suggested, I know it's not the preferred method, but by the court perhaps, but the defense would suggest potentially a 104 hearing where even if it occurs right before testimony, where the ME gets on the stand and says, I need photo number 1 because of this reason, right? And then reason by reason, like, well, is this something the defense is contesting? Because if the defense is not contesting this, or if the defense concedes this, or if the defense can stipulate to this, why do we need the graphic photo? I think it was related to a different issue, but oftentimes the analysis is like, what is the least prejudicial means through which the jury can learn this information? And if it's just...
Isn't there going to be an issue as it relates to one of the defense experts in a report that was supplied as it relates to the knife wound injuries, that there may be some relevance as it relates to that, or no?
Judge, I don't think so, and I can discuss that with the state as well.
There's photos in that report, right?
Oh, right. But I also indicated in my reply letter that if that expert testifies, he is not by any means relying on the photos in his report. He provided a trial presentation slideshow that only has 6 photos, and they're just sort of zoomed in on a little tiny wound. It's not...
I understand, but if that happens, then the state would have the ability to respond to that with photos that they feel may be responsive to that. So I'm just saying to you that it's not just in that vacuum that you're talking about, that it may become more relevant also during the course of the case. So I may have to make a determination first by saying certain things are in, certain things are out, but may have to readdress them depending on what
And
happens.
I think that's fair, Judge. I think the court's ruling with respect to the state's case in chief is separate and apart from the defense potentially opened the door to allowing photographs in. I think that's a separate analysis. But with respect to only the state's case in chief, and let's assume for a moment the defense isn't even going to call that witness. If we're looking at it through that lens, I think that there should be. It should be placed on the record. There should be a mechanism where each and every objection is noted as far as, again, the ME explaining, like, I need this photo to show XYZ, and the defense saying, we don't dispute XYZ. So we would ask that the court permit the ME to simply testify to these facts or explain the facts to the jury or explain, the condition of the decedent upon receipt. Like, those are things that can be explained via testimony, particularly in instances where the defense isn't disputing the information. So with that said, Judge, I think another part of the court's analysis here that's significant is, and I provided 2 articles. Did the court have an opportunity? Does the court like a hard copy?
I have them.
Okay. Does the state have them?
Yes.
Okay. So, Judge, I just want to highlight a couple of things because when we make these arguments, right, it's unduly prejudicial. It's very vague and it's almost abstract. And I think what these articles help identify.
I read the New York Times article before you even supplied it to me, so I know exactly what it says. You don't have to reiterate it unless you feel a need.
Just as a broader principle, I think what both articles highlight is what the prejudice specifically is, right? It's not just like prejudice. It's that these jurors who observe graphic photographs can very much ultimately, it could result in not only trauma, but also it being a basis that serves to create a bias against the defense. And I think that that's what these are, particularly the law review article highlights, is that arousing negative emotions in jurors is not just an unfortunate but harmless byproduct of presenting evidence of certain injuries. Experiencing intense negative emotion can bias how people process information and to make decisions. Gruesome photographic evidence of, and they're referring to plaintiff's injuries, but let's say a victim's injury is particularly likely to rouse anger, which people tend to feel when they see an act of harm against someone that they perceive to be intentional, and disgust, which people tend to feel when they see a violation of a body. Psychological experiments have demonstrated that feeling anger and disgust can create a need to blame and punish someone to right the scales of justice for the harm that they have witnessed. And the combination of anger and disgust is particularly powerful. And they go on to cite some studies where they had, a mock trial with mock jurors, and group A only heard a description of the injuries versus group B who saw the photographs. And essentially this article recaps how the result of those studies demonstrated that the people who were shown the photographs not only experienced like more of a disgusted response and therefore that they also experienced more bias when they were more inclined to convict or more inclined to view evidence through a different perspective, which was that it was not as objective to hearing out the defense. And so a lot of times their perception can be skewed in favor of conviction or in favor of guilt just by virtue of seeing the photo. And it's not conscious, it's not intentional, it's just human nature that, as Mr. Decker indicated, like none of us want to see these photos. And certainly, at the very least, this is our job. The jurors, although technically it's their civic duty and their job, they can't pick and choose their trials. So if they're not emotionally prepared or psychologically prepared to see graphic photographs, it could not only harm the jurors, but also obviously then impact the bias toward the defense, whether it's conscious or not. So I think that the articles, I'll just place the titles on the record. It's the impact of gruesome photographs on mock jurors' emotional responses and decision-making. And it says in a civil case by DePaul University, DePaul Law Review, volume 69, issue 2, winter 2020. But again, although it's this particular article discusses a civil case, which the mock experiment is like the second half of the article. The first half of the article talks about how most of the case studies surround criminal cases, and it recaps those, and that's what I'm specifically referring to. And the New York Times article is titled, "After a Grisly Trial, Jurors Are Left with Mental Scars and Few Resources." So I think, Judge, in light of the combined issues here, which is A, that we're dealing with an exceptional case here. We have not just one, not just two, not just three, but we have 4 victims, 2 of which are young children. And the injuries are particularly egregious, right? So there's multiple forms of injuries here. And when you combine all of those things, I think the heightened level of prejudice is exceptional in this case. That combined with B, the fact that the defense is not disputing cause, manner, method of death, or time, creates a scenario where this court, I think, has to really carefully assess whether each individual photograph is actually necessary.
I'll do a 401 and a 403 analysis for each one.
Thank you, Judge.
If necessary. For the record, we're going to mark what the state has proposed. It's 25 pages. There's 2 pictures on each page, so it's a total of 50 pictures. We'll mark that as S1 for this particular in limine motion, so the record is clear as to what photos we're talking about. If you come to limit those photos, Mr. Decker, you can give me a new version, and I would mark that as S1A or 1-2 or 2, whatever, and we'll go from there. All right. All right. So that motion will be held for now until such time as I hear from everyone on the 15th. The next request is for a witness to testify outside of the media presence. That's a defense in limine motion, so I believe that's going to be heard on the papers, but Ms. Mastalone, if there's anything that you want to put on the record, I'll give you the opportunity to do that now.
I have nothing to add, Judge. Thank you.
All right. And the state took no position. The court will do some more research on that particular issue before making its final determination, looking to get that opinion out either by Friday of this week. If not by Friday, then definitely by the beginning of next week, so everyone will know. I also want to point out that before I go to the other motion, is that I received notice from the defense that they are withdrawing their motion to preclude certain financial motive evidence that they filed in this particular case, and they're also withdrawing their motion to preclude Kimberly Patton's testimony due to the fact that the state has supplied expert reports, 2 different expert reports to deal with the 2 issues that were of concern to the defense. Am I correct that these are being withdrawn?
That's accurate, Judge.
Okay. And for the state, you've turned over CVs, the reports, everything has been turned over, correct?
That's correct for both, yes.
And Ms. Mastalone, you have received those and had an opportunity to look at them, correct?
That's accurate, Judge.
All right. All right, next. And I should point out, with all of it, every time that I ask about this discovery issues that they've been turned over, Ms. Mastalone, you've also turned those over to Mr. Caneiro, so he's had the opportunity to look at them also.
Of course, Judge.
Okay. All right, the next issue is the defense has requested the court to reconsider the motion for change of venue as it relates to an opinion that this court has already ruled back on April 4th, 2025, In a written opinion, the court denied the defendant's motion to change venue, which was originally filed on March the 7th, 2025. At that point in time, the court had indicated that the defendant had not met its burden under Rule 3:14-2 and controlling precedent to show a clear and convincing proof that a fair and impartial trial could not be held in Monmouth County. The defendant now moves for reconsideration. I should point out, as I indicated before, that the defendant had filed this motion on March 7th. And at that time, the defendant moved for change of venue, citing cumulative local publicity. The Asbury Park Press concentrated readership in Monmouth and Ocean County, and the prevalence of hostile online commentary. The state opposed that motion, arguing that the coverage was factual and that the voir dire would suffice to ensure impartiality. On April 4th, this court denied the defendant's motion in a 53-page written opinion, concluding that 1, most coverage was fact-based and neutral, 2, no torrent publicity or carnival-like atmosphere existed, 3, social media commentary was not competent evidence of community-wide prejudice, and 4, that the comprehensive voir dire would adequately safeguard defendant's right to an impartial jury. On August the 7th, 2025, the defendant filed the present motion for reconsideration, attaching exhibits claiming to show 65 new items of news coverage since April the 4th, 2025. State opposed the defendant's motion in a brief on August the 10th, 2025. Defendant's argument now incorporated everything that was in the original March 7th, 2025 brief, and indicated that these 65 additional items of coverage since April, consisting mostly of Asbury Park Press articles, other news outlet reporting, and online commentary, the court should reconsider its decision of April 2025. Defendant emphasized that the volume of news coverage occurred in just 4 months, which he claims marks a significant shift from the court's finding of the peak coverage that occurred in 2019. Defendant argued that the most recent coverage has reinforced community awareness and hostility, particularly given APP's concentrated local readership. When I say APP, I'm talking about the Asbury Park Press. The defendant further asserts that much of the recent coverage was triggered by defense-filed motion, but contends that the defendant should not be penalized for exercising its rights. He maintains that online and social media commentary remains inflammatory and reflective of local sentiment. On the merits, the defendant renews his claim for presumed prejudice under Harris and Marshall, arguing that the nature, frequency, and distribution of publicity now meets the threshold for a venue change. In the alternative, he requests that the court reserve decision until voir dire, at which point a finding of actual prejudice could be made if juror questioning reveals bias. The state, in its response to this August 7th submission, relies on its March 21st, 2025 written submission and oral argument in response to the defendant's original motion. It argues that the increased volume of coverage since April 4th, 2025 is unsurprising given the number of recent motions litigated, but that the coverage remains factual and does not contain name-calling or opinion pieces such as those found prejudicial in State versus Harris. According to the state, the recent articles merely recount what each side argued and what the court decided. None constitute a torrent of publicity that creates a carnival-like setting or a barrage of inflammatory reporting, as noted in State versus Nelson. The state further notes that some headlines could be viewed as favorable to the defendant, covering the defendant's successful motions. Regarding social media commentary, the state argues that presuming hostility in the entire jury pool based on such comments would be premature and speculative. The state concludes that voir dire is the proper method to address any potential prejudice, and that the court may revisit the issue if jury selection reveals a realistic likelihood of bias. I tried to outline the arguments. If counsel needs to be heard further, I'll give you a chance to do that now. Ms. Mastalone, this is your motion on behalf of your client, so the floor is yours. I'm just asking you not to reiterate your brief.
Yes, Judge, just very briefly. I just want to highlight, when we talk about the pretrial publicity and the prejudice, it doesn't have to always be super negative prejudice name calling type reporting. I think what the court can also consider, which is more what we have here as well. I know I previously made the arguments about how the social media commentary can come into play with the negative publicity and how people see the social media posting and comments online. And I don't need to reiterate that argument. The court's aware of it. But with respect to the media outlets themselves, fact-based and neutral reporting can still be problematic, and here's why. Because many of these headlines, if you read through them, reveal evidence that is either going to be admitted at trial or that is not going to be admitted at trial. And they are both equally, if not unequally, they're both problematic. And the issue is that when jurors already have a sense of the evidence that is to come, or if they have knowledge of evidence that exists that they don't end up seeing at the trial, it creates a clear prejudice for the defense. I mean, the jurors, we know, should be as close to clean slates as possible. I know the case law says it doesn't have to be like completely clean. They can have a little bit of knowledge, but there's a difference between having some familiarity with the fact that this case exists and to know, testimony likely to be elicited when Paul Caneiro goes on trial and they go in, the article goes into detail about certain testimony. Pretrial hearings provide sneak peek of Paul Caneiro's trial in this case. Surveillance video shows, and they're playing surveillance. There's surveillance.
Do you agree that some of your exhibits are actually duplicative? If you actually look at them, do you agree that some of them are duplicative?
As far as like the headline itself, yes, the medium is different. So some of it is like an Asbury Park article, some of it is Asbury Park Press posting on Facebook, some of it is Asbury Park posting on Twitter or
saying the
X.
same exact thing though. You would agree, right?
Yes, exactly. It's just that it reaches a wider audience the more mediums that it's posted on. So maybe someone doesn't subscribe, but they see it on Facebook, or they're not on Facebook, but they're on Instagram or Twitter. So that was the purpose of showing, yes, so that the headlines themselves are duplicative, but it's separate content as far as the audience base.
Well, it's not separate content. You're saying that it's separate base that will read it, but it's not separate content. It's the same content. Or taking blurbs of certain content, correct?
When I say content, I was referring to the medium itself. It's separate mediums. Okay. The content of the information is the same, yes. But nevertheless, Judge, we're talking about surveillance videos and sneak peeks and evidence examined and motive evidence, alleged motive evidence, life insurance policy evidence. I mean, all of these things are evidence that jurors should not have any knowledge of prior to sitting on this case. And there's just, I mean, that's the whole point of the motion, right? Is like, we're not saying that there's not some needles in a haystack here that maybe have no knowledge of this case or that have very limited knowledge of this case. But the purpose of highlighting, like, yes, these are repeated headlines, but here are all of the vast mediums that they're published on. And so they're reaching a wide audience base concentrated here in Monmouth County. And there's a concern that many of our jurors are going to come not only with this knowledge that is heightened in this case that they shouldn't have if they're sitting on the jury, but how that knowledge is going to cause them to prejudge this case or prejudge Mr. Caneiro, again, whether intentional or unintentional or conscious or subconscious. Beyond that, Judge, what is extra concerning are all of the headlines that highlight the suppression of evidence in this case. So no juror wants to feel that evidence is being hidden from them or that they're not having access to all of the information. And if there's a wide reader base of the Asbury Park Press combined with the people that see it on social media, on the various platforms, there's a concern that, jurors are going to have that in the back of their mind or have information
All
that's
of your
not
arguments
admissible.
are making a lot of assumptions, aren't they? Under the circumstances, and also where we are today is really not different than where we were in April. We have to at least have voir dire, that searching voir dire, then we're going to know. So my concern is that, and I know you had indicated that the court could hold off on this and wait, but the court's position as it relates to where we are today is that the court, understanding its obligations to make sure that Mr. Caneiro has a fair trial, and understanding what I've ruled on already, that if I find prejudice, actual prejudice, at any point in time, I won't need either party to tell me that there's actual prejudice. I will do it sua sponte. I can tell you that directly right now. So I understand what your arguments that you're making. My concern is that we are again assuming certain things because we don't know until they show up, until they start answering us. Then we will know how wide-ranging this is and how much people may care. They may have read something in 2018. They may not have they may have stopped getting the paper after COVID. Who knows? Or they may have stopped reading online after COVID. Who knows? So I hear your arguments. I don't know if we're in a different position today than we were.
The reason why I would submit we are in a different position, Judge, is simply because motions have been filed. As has been placed repeatedly on the record that up until more recently, no motions have been filed. Obviously, there's a change of counsel. Motions have been filed, and I think that that's where this influx of headlines is coming from, clearly, and it's unfortunately right before the trial is about to begin. I agree, Judge, we are assuming things, but I think that's the whole point of the presumed prejudice, right? It's not like we have to come prepared to show presumed prejudice. That's why it's distinct from actual prejudice, because we don't have data. We just have all of this information that could possibly, if the defense were to meet the standard, demonstrate to the court that, you know what, there's just so much going on here. We can presume or assume that the prejudice has met that threshold. So that's the argument, Judge, and I understand the court is aware of it.
Okay, great. State, going to respond?
Just very briefly, Judge, the state would rely on his previous submissions. The court outlined them very accurately. Just in response to the defense's arguments, I would note that, in terms of any prejudice more recently and overall, I'm just looking at the voir dire here. There are specific questions in here about that. And they will be asked those questions as the court indicated. So at this point, it's the state's position that any presumed prejudice is premature.
The defense motion as it relates to for reconsideration, it's going to be denied for two different reasons. One will be for procedural grounds. It's outside the time frame, but it also will be denied based upon the merits of the argument. You'll have an actual written opinion today that will provide the reasons for the court's decision. And here's what I will say, is that, I just said it to Ms. Mastalone, if this court will be analyzing each and every witness that comes in here as to, each and every juror, prospective juror that comes in here. If the court finds that there's actual prejudice, that there is some pattern of that in this particular case, this court will, at that point in time, address it with the attorneys. Otherwise, this court has decided this motion. It decided it again today. And this court feels that if there's anything further that it needs, it will address it when the appropriate time comes. So with that being said, you'll get an order and an opinion today denying the reconsideration. All right. The next issue that is outstanding is this wasn't a written submission, but it was orally brought up by the defense. So I said that I would address it today. Was the objection by the defense to the seating arrangement in the courtroom. And Ms. Mastalone, I don't know if you want to put anything on the record. I'm going to tell you straight up so you can create your record, but I'm telling you right now, the way it's set up right now is the way it's going to be based upon the limited room in this particular courtroom. We don't have a large area within the well to be able to move counsel table around. We have 4 people at defense counsel table right now as we speak. I don't know if there will ever be more than that or if this is what the 4 will be. So with that being said, we need the 2 tables that are set up. From my understanding, the state has 2 attorneys on this case, and they may have individuals that are seated with them to assist them with the trial. So there is no way to put this on tables on an angle. I'm not going to put attorneys and or their people that are assisting them behind them in this particular case. I also want to leave enough room so during openings, summations, and for you to do your direct and cross with the way that this courtroom is set up, that I want to have a sufficient room for all the parties to be able to stand up and do what they need to do. Based on the fact where the witness stand is located and that the jurors are located across the room looking directly at the witness, this court does not find that there's any other place, another setup that can be done under these circumstances of this courtroom. I will also tell you, so if you want to address this also in your argument, is that this court does not intend on having that podium here for purposes of this trial. If you wanted it for your openings or summations, feel free, that's up to you. Otherwise, I will have a portable podium that you could put right on counsel table. So if you want to stand up and have it right in front of you, but then have all your other stuff that you may need for a particular witness, you'll have it right there. If you don't want that, then you won't need it. You won't have to have it. But based upon logistics, I can't even have a podium out here where you may be blocking the view of a particular juror as they're trying to analyze the evidence, especially in light of the arguments first thing this morning, wherein we're not going to allow note-taking so that people can pay attention to the actual witness. So Ms. Massillon, with that being said, I want to give you the opportunity to place whatever positions that you want to place on the record, but at least out of fairness to you, want to let you know where I'm thinking, what I'm thinking.
Thank you, Judge. I mean, I think the court's explained, why we are where we are. It sounds like we have limited options. All I can say is I don't like it. I object that, but if the court's going to rule how it rules, and if we have limited options, I understand the court's constrained as well. My only perhaps misunderstanding was I thought that the witness was going to be in that witness box. For the record, I'm pointing to the one that's like next to the
right
court.
Where my law clerk's located
Right
now.
where the law clerk is located, as opposed to, only because this one just feels like our backs are to the jury more,
I understand.
as opposed to this one. So I don't know if that's something the court can reconsider or if that's already been considered.
So yes, it has been considered. I'll tell you why. That we were of the opinion that we have to leave the witnesses where it is. It was because from where Mr. Hinton is seated, my law clerk, is that I'm not sure Mr. Murray can actually even see Mr. Hinton in his full body from where he is, or he has to lean over. So I was worried about a sightline issue for each one of you, and I don't want that. And Mr. Caneiro has the right to be able to see that witness. So that's the reason why that we can't have the witness over here, and we had to have the witness right in front of you. But if you have any thoughts, feel free. Believe me, we tried. But if I ask the county to do one more thing for me, then I may get fired.
Yeah, I mean, I guess we can't move that one forward, right? It's
affixed.
Okay.
Yeah.
Then, I guess it is what it is, but, so my objection, I would note it for the record, that this is less than ideal.
Mr. Murray, if you don't mind me, I don't mean to put you on the spot, but from your vantage point, can you actually see my law clerk to be able to?
The top of his head, Judge, but if I moved over for purposes of cross, I could see the witness from the end of the counsel table.
Listen, if you all prefer that, my concern was for you, not for me. I can see. So if you want to do that, think about it and you let me know, because here's the thing. If we're going to do that, then we have a wiring issue, because that is wired. So we would have to, my division manager is in the back from IT, is probably losing his mind, but we would have to rewire it over to here so that we could do it. So that's up to you guys. I don't mind either way, but that's the way it's set up right now.
Judge, the problem though too is, as Your Honor indicated, that like Mr. Caneiro can't see.
That's the concern.
And yeah, so now that we're sitting here, from our vantage point, it's an issue. So I think we are probably constrained to use the witness box that is diagonal from the bench and across the courtroom from the jury. But as far as the seating arrangement, I would just note my objection for the record.
I understand. Look, and I can't tell you all what to do and how you do your directs and your cross and where you do them from. You can do them from counsel table. My suggestion also is you could do it from on the side next to where the jurors are and look straight across. If you want to get more of everyone focused on the witness and not on you and everything else, that's up to you. However you want to do it. The courtroom is yours for you to do your presentations. If you're going to do something that's extremely out of the ordinary, all I ask for you to do is let me know, so that if I have to deal with it, I'll deal with it. But other than that, again, I respect and understand what each side needs to do, and I want to give you the opportunity to do it. Believe me, based upon my experience, I've tried every other way to make this work. And if I thought that there was another way, I would do it. So, all right. All right. With that being said, let me see. Okay. I think we're coming to the end here. This is good for all of us. I did receive a proposed jury charge from the state dealing with the issue of life without parole because the defendant is eligible if convicted of any one of the first four counts of the indictment, that has the potential of life without parole. There was a proposed charge that was provided by the state, and I believe that the state has supplied it to the defense. The defense has had the opportunity to take a look at it. And are we in agreement or close to an agreement as it relates to the life without parole jury charge?
And I think we are either in agreement or very, very close to agreement.
Okay.
I don't have any issues.
I think we're in agreement, Judge. The state had supplied a proposed ad lib to the model charge, and I reviewed it, and then I changed it and submitted it to the state, and I conferred about it, and then we completed it, and I submitted it to the court. I think we're all in agreement.
Okay, good. And I do have that, so for the record purposes, that is, we're all in agreement to that. Next. As it relates to pre-marked exhibits, we talked about pre-marking everything in this particular case. What I'm going to ask for is, once you pre-mark all of your exhibits, I'd like to have them uploaded into the share drive like you have shared other things for hearings. If you have any issues with that, I know you're going to be meeting with our division manager for IT, so you guys can discuss that. But I'd like the pre-marked exhibits in advance, and I'm going to explain why. But I need them with the sticker on them already, with the number that you're going to assign for each one of them. So here's the thing, that during the course of the trial, you're going to be using these items. Some of these items may go up on the screen. Because the state will not be moving its evidence in until the end of the state's case, same with the defense, at that point in time, we would be in the position of then trying to remark all of those, and then we may be getting requests for those items. Nobody can get any of them unless I have had the opportunity to review it. So if I have them all in advance, and we can see certain items have already been marked, that they're probably going to be moved into evidence, we can at least have that process started, and we're not doing it all at once, because I don't want to create that kind of an issue.
Judge, just to be clear, you're talking about a list. Well, not the actual.
No, the list.
The list, S1 through S200. I don't understand that.
I'm asking for, tell me if it's too much of an issue, that when you're going to mark S46, which is, say, a financial document that's 100 pages long.
Sure.
I want to upload it into SharePoint, because that we're going to need the final version of everything that's going to be used. and to make copies of it. If it's too onerous, you can tell me that now. But we're trying to figure out something. We thought that would be easy for an upload, that somebody's marking them, somebody scans them in and uploads them into that particular drive, so then that we have them. If it's too difficult, you guys can tell me, but that's kind of what the thought process. If not, we're still going to need all of those exhibits at some point in time.
Can I ask for clarification? Your Honor had said something about moving the evidence at the end of the case, but I was under the impression that we were going to be moving in evidence through each witness. And so my concern...
What I'm saying is that a witness, you may ask them using certain documents or whatever it is. That's fine. The actual moving of those exhibits, I'm going to expect that the state's going to do it at the end of the state's case for all of its evidence, so that you can, if there's objections or issues or modifications, or because I won't know. If there's certain things that Mr. Decker wants to move in and with a particular witness and you have an objection to it, but he's going to use it on another witness later, I want it to be done at the end so it's clean.
But it can only be published to the jury if it's in evidence. So wouldn't he need to say to the witness, like, this is a photograph, and the witness says yes, and blah, blah, blah?
You guys are already going to have agreed on that, I am sure, of particular items. Yes, I understand the evidence rules, and I understand that if they go on the screen that they've already been moved into evidence. I assume that a lot of these are not going to be issues because both sides are going to be using them.
Right, so that's why I think personally, I would prefer if we could just keep track by moving it into evidence through each witness as it's occurring, so that...
Can I see the attorneys in the back for a second?
Well, that ended abruptly. I have no idea what the outcome of that was, but so we heard some good stuff here. September 8th to the third week in November, so that's pretty much like your 10-week trial. So it looks like they're not going to allow note-taking, I should say. It's going to start at 8:45 a.m. every day. We're going to hear cell phone data. That's good. He denied the change of venue. He denied the whole motion about news coverage. They talked about seating arrangements and then the jury charge. So, hey, I just want to give a quick shout out to Clairview. If you guys are familiar with Clairview, then you don't need to listen. But if you're not, check out this is Clairview's channel, and we are hoping for a little collaboration there. So this is Clairview's channel. If you guys are unfamiliar with what goes on over there, check it out. So Miss View is in our chat right now, so appreciate you being with us and dropping all kinds of knowledge, and hopefully we can have you on at some point and talk about this trial. Like maybe once it gets rolling and all that stuff, but we'll talk about that. But anyway, yeah, you're always welcome in our chat to drop whatever knowledge you have. So thank you for that, and guys, go please support Clairview's channel. All right, I got one more video to watch. This is from September 12th. All right, so this is from September 12th, and I think this is the last. Pretty sure this is the last pretrial hearing.
Let me hear from Ms. Matt.
Although, let me just, this is from September 12th. Let me just post that up here. So we had August 17th, and now we're going to fast forwarding to September 12th, and then we will be done for today, and our deep dive will be done. September 12th, 2025. So this is a hearing from September 12th. He's taking, yes, Deviant, he's taking him into the back. They're in trouble. All right, so this is from September 12th, 2025.
Salone for a minute, I'll come back to you. Ms. Salone, so tell me if I'm wrong, and we don't need to get into this issue of some of the arguments that were made of the really conflate the 180 clock to the 2-year clock. Let's stay away from that. I already know that that's not where this court is. I'm trying to frame it for everybody. I read your brief. One, on the issue, McElroy Davis, you can address that. But number two, I read it as that under these circumstances, that when I asked the question whether the prosecutor is trial ready, that the prosecutor has to be ready to, let's go, let's bring the jury up at that point in time. Am I wrong in how I read your brief?
Under these circumstances, that's correct, Judge.
Okay, so I'll allow you to proceed. I need for you to explain to me why that I should read McElroy Davis in that narrow way that you're asking me to do that.
Absolutely, Judge. Actually, it's on page 236 of McElroy Davis, and I quoted this in my brief as well, but the Supreme Court says, to be clear, this appeal addresses the need for additional time to commence trial because of the COVID-19 pandemic, not more generalized arguments, et cetera, et cetera. So I think, Judge, the words of the Supreme Court indicate that this was a unique scenario. This was an unanticipated scenario. And to answer the court's question from the defense perspective about do you need to say you're ready or do you have to be physically ready? So let's start with the statute. NJSA 2A 162-22A 2B(i) says, for the purposes of this paragraph, a trial is considered to have commenced when the court determines that the parties are present and directs them to proceed to voir dire or to opening argument or to the hearing of any motions that had been reserved for the time of trial, right? So prior to McElroy Davis, prior to COVID-19, it wasn't just the prosecutor standing up and saying, I'm ready. It was they had to actually be prepared to physically start opening statement or start jury selection or start an in limine motion that had been predetermined to be specifically reserved for right before trial starts. That was the standard. However, when we had COVID-19 and the pandemic, as we all know, trials came to a halt. We had social distancing. And what happened in McElroy Davis, which is a case out of Burlington County, was that we were ready to go to trial. And we couldn't because the court had no courtrooms available. There was a huge backlog of trials, as was in every county. And the presiding judge at the time said, you know, we can only accommodate one trial at a time. We can't have multiple juries. We can't have multiple people in trial in the courtroom, in the courthouse filled with people. So because of the unique circumstances of COVID-19, we can't proceed. Like, we physically can't proceed, and it's not the state's fault, and it's not the defense's fault, and it's not even the court's fault. It's the pandemic's fault. It's an act of God, so to speak. And when it ultimately got in front of the Supreme Court, they agreed, because at the time the defense was arguing that that wasn't the intention of the statute. That, I mean, it didn't contemplate COVID-19, but 2 years is 2 years. So the Supreme Court clarified and said, okay, here's the deal. Under these circumstances that were unforeseeable at the time that the statute was actually drafted and enacted, we are now going to read into the statute to say that the state can simply advise the court that it is trial ready, and here's how we're going to define that. We're going to define a statement of trial readiness, meaning your witnesses are generally available, discovery is complete, the indictment's in its finalized form, and as long as the state, and they used the word, I think it was in DFW, but one of the cases uses the word genuinely ready. As long as the state is genuinely ready to proceed, but can't, not because it's their fault, not because it's anyone's fault, but because of the pandemic, then that suffices and the 2-year clock can extend. And then they gave additional guidance and said, but we don't want people in jail in perpetuity, so we're going to have these like monthly McElroy Davis hearings, and we're going to make sure that, you know, we're scheduling appropriately, etc. Prioritizing the oldest cases along those lines. Here, That is not the circumstances. Beyond the fact that we're not dealing with anything pandemic related, even if we were to read McElroy Davis a bit more broadly to suggest, if something happened to the courthouse, we show up on Wednesday for a pretrial conference, we're ready to start work there on Monday, and regrettably a tornado blows through the courthouse, and now we can't proceed because we don't have a courthouse, right? That would be an extension of the intent behind McElroy Davis. We do not have that here. Here, what we have is, and I'm going to quote the state said to this court momentarily ago, it would have been withdrawn. Had the Supreme Court not gotten back to us, their appeal would have been withdrawn. Once we heard from the Supreme Court, they were faced with a choice. And that choice was proceed to trial with evidence that conceitedly they could have tried the case without, because they were going to withdraw it. They could have tried this case on Monday without that evidence, and if we hadn't heard from the Supreme Court...
Why do they have to? Why do they have to? If the Supreme Court wants to make the determination that if I'm wrong, then they have a right to know that one way or another, and they've decided that beforehand. Here's the problem that I have, and I'm going to point you right to it so that you can address it, so that we stay focused on where I think the issue really is. That it's not just McElroy Davis that talks about how are we defining ready to proceed. It's right in the court rule. The words are specific. It's not that the prosecutor is ready to move to opening statements. The words in the court rule says, an eligible defendant shall not be released from jail or a juvenile detention facility pursuant to subparagraph 1 of this paragraph if on or before the expiration of the applicable period of detention, the prosecutor has represented that the state is ready to proceed to voir dire or to opening arguments or to proceed to a hearing of any motions that have been reserved for trial. Here's what I'm looking at. Both the defense and the state have indicated that this court does not have jurisdiction right this minute. If I don't have jurisdiction, the state can't proceed. I understand your point that it's the state is the reason why that we can't proceed, but why should the state be penalized for wanting to know whether the Supreme Court believes that the trial, under these circumstances, the trial court's decision was incorrect? It could be correct for all we know, and it'll make law that maybe the state won't like. I don't know. But assuming that for the state that the trial court is reversed, the appellate division is wrong, then under these circumstances, shouldn't I factor, when I look at the court rule here and what it means to say that they're ready otherwise, and what the history of this case shows that they're ready, that I shouldn't take any of that into consideration?
So, Judge, that's a loaded question. If I'm going to answer it.
I'm sure it is.
A few different parts. So, number one, I want to point out that an appeal is always a choice, right? The Supreme Court doesn't take things sua sponte. They're not keeping an eye on our cases and saying, oh, that's an issue we want to look at, right? We have a scenario where a motion was filed and a decision by this court was made. The state has the choice to accept that or pursue an appeal. They pursued the appeal. That's a choice, okay? Then they got an answer from the appellate division. Again, this is all stemming from their request, their choice, their decision. It's their delay. And to say that, well, we don't want to punish the state is to, I think, miss the mark on the intention of the Criminal Justice Reform Act. And it's not about, as the state argued, totality of the circumstances. And it's not about, they used additional language in what would be unreasonable.
I'm not really talking about punishing the state. What I'm actually talking about is just under these circumstances, when, of course, in McElroy Davis and also in DFW, they were confronted with this issue with the pandemic. The directive that comes out in 2022, 2 years after the pandemic, also speaks directly to this point and talks about
how that under the circumstances that the 2-year cap can be extended if the state is ready to proceed. And to me, I hear everything that you're saying. I don't see, and I could be wrong, I don't see that I can say that the state's motion to the Supreme Court is attributable to the defendant. So let's frame that and move it to the side. The question that I have, though, and the one that I am struggling with as I sit here today with you, is the issue of what does ready to proceed mean? Does it mean that they've said it and they genuinely mean it, which in this procedural history of this case, they were ready and they still are ready pending the Supreme Court's decision. And the trial court no longer has jurisdiction at this point. Or does it mean that physically they are ready and they have to proceed at that point? And my concern is that if it's prosecutor indicating that they're ready, and it's their words that I have to listen to, and not their actions of physically being ready, that appeared to me to be the legislative intent behind what I have read between the court rule and the statute. However, I do see from your perspective that under these circumstances, this has nothing to do with the defendant. And the rule makes clear that put up or shut up at the time that we get to the 2-year cap. So therein lies the struggle. So I don't want you to worry about anything else. I want you to focus me in, as you see it, on what that really means as to ready to proceed, because that's where I'm going to decide this particular, make this decision on this case.
Thank you, Judge. The state can, let's assume for a moment that all they have to say is that they're ready and genuinely mean it, right? And AP Decker just stood up and said, we are genuinely ready, right? They can say that. It doesn't make it true pursuant to the statute, because the issue, let's assume all they have to do is say it. They are not ready to proceed because they can't proceed. They're not willing to proceed until this appeal is heard, and that is their choice. They're choosing not to go to opening statement. They're choosing not to select a jury on Monday, and they're choosing not to proceed with this trial because they want to hear the appeal. They want to try their chances with the Supreme Court, which, as the court stated, it could go their way, it could not go their way. The Supreme Court taking it doesn't allude to that. It only demonstrates a willingness to give the state their shot. They want to shoot their shot, and that's what they're doing, but that's their choice. So they can stand here and say till they're blue in the face that they're ready. It doesn't mean that they're actually ready, because the intention of the statute isn't, well, you would be ready except. Well, you would be ready, but you're waiting for this appeal that you chose to file. And that's not the intention. And the distinction, the very critical distinction with McRoy Davis, is that it wasn't anyone's fault and it wasn't anyone's choice. No one chose to bring on a pandemic. No one chose to have, basically a plague in our country that prevented trials from occurring. This all stems from a choice that the state is making. This isn't like a sure thing. It's not like, well, we have no choice because we need this evidence and we know the Supreme Court's going to go our way. I mean, even if that were the case, that's still their choice. But that's not what we have here. They're simply choosing to pursue a route that's a question mark. And if they want to hold up this trial, if they want to keep this man, who's not only presumed innocent, but has maintained his innocence for 7 years, they want to keep him in jail, you're right, Judge. That is not on him. That's not on Mr. Caneiro. He should not be held 7 years in jail because on the eve of trial, when they could have withdrawn the appeal, they chose not to. That's where we're at, Judge. And again, it's not punitive. It's simply the law. And I want to be clear about one thing, because the court brought up the consent order. So the defense agrees that because of Rule 2:9-11, because of the case law that discusses the rule, that the law is, if the Supreme Court takes the appeal, the trial court loses jurisdiction over the matter, meaning we can't proceed to trial, right? And again, that all stems from the state's choice. But it's not the defense consenting to the adjournment. It's not the defense asking for an adjournment. We're not consenting to or asking for anything. We're simply recognizing what the law is. And it's not like I'm just, oh, they say, the state says we lose jurisdiction, we don't have jurisdiction. This is independently what my experience has been, what our appellate attorneys say. I spoke to like 4 or 5 different appellate attorneys in my office. Apparently our prior deputy of appellate has like an outline that also says once it's taken, we lose jurisdiction. So, I mean, I did my research, Judge, and the point is we're not capable of taking a position. We're not consenting. We're not objecting because we can't, because I have no authority to say to this court, please override the Supreme Court order, as it's up to the state. It's up to them. So with that said, Judge, what I don't want to happen is it to be conflated in the record that this is somehow the defense's acquiescence.
It's not. I just wanted an order from Friday of what went on. That's it.
Okay. Should I continue, Judge, or does the court have any specific questions?
No, if you have something else that you want to add, I mean, obviously this is your day in court on behalf of your client. I'll give you the opportunity to do it, and then I'm going to listen to Mr. Decker.
So, Judge, ultimately, I think when we're looking at prosecutor readiness, and that's pursuant to NJSA 2A 162-22A2A, pursuant to the rule 3:25-4D1, pursuant to DFW, pursuant to McCord-Davis, what they all do is they discuss trial readiness per the statute. So outside of the exception of McCord-Davis, what we have here is a scenario where, as the court's aware, our position is the state's not ready. And another thing, Judge, is that readiness can change, right? So again, conceitedly, on the morning of September 3rd, the state was ready because we hadn't heard from the Supreme Court and we were going to go. But the readiness can always change, right? Readiness is not, it's a fluid thing. And that's why in McCord-Davis or DFW, one of them, it says it can always be revisited. It should be revisited because circumstances change. And in that vein, I just want to make sure, I just want to put on the record a little bit of clarification because I understand that the state submitted a letter in August of 22 saying that they're ready, and in August of 24 saying that they're ready. Since those dates, we have received 8,517 pages of Bates discovery and 6,275 pages of Bates discovery, respectively. And some of that is stuff where the defense is asking for, hey, can you get me this body-worn camera policy? Okay, that's 10 pages. But some of this stuff, in very recent time, as recent as July, we received over 3,000 pages of financial information that should have been provided years ago. And I think AP Wallace conceded that on the record and said, after meeting with Detective Bassender, they realized, oh, this should have been provided. Oops. We got 41 discs of raw financial data, which after review is tons of new material, all relevant to this purported financial motive. So they can say they're trial ready, and in hindsight, we know they weren't actually trial ready because on the eve of trial, if suddenly they realized they had to provide this discovery, it would have been problematic. And I think this is analogous.
Isn't that the reason why they say that when you look at DFW, they talk about that the readiness must be genuine? Like, you know, no one's perfect. And without creating too much on this record, neither side have been perfect.
Agreed.
So in saying that, what you're mentioning right now was the result of a trial prep realization of something that came up. I don't know if I can hold that against the state under these circumstances. I don't think that that's what DFW was talking about. I don't think that's what the directive was talking about, or any of the rule, or McCord-Davis for that matter. I don't think that that's what they meant.
So I can tell this court that it is in this sense. If the state says we are trial ready, right? And let's say they genuinely thought they were ready, right? We thought that we turned over all the discovery, but on the eve of trial, they realized, ooh, we didn't. We owe them these 3,000 pages of discovery. At that point in time, they are no longer trial ready because now the defense is faced with, we just received 3,000 pages of discovery. We can't go to trial. We need time and a review. And this has been reviewed by the appellate court. An example is State versus Florence Ross. I don't believe it was a published decision, but in that case, the defendant was about to start trial.
But isn't that irrelevant too, considering you received this in July and obviously you were ready to proceed on September 3rd and we're not there now. We're actually beyond that and you have it and the state has turned it over so that they...
Can I say one last thing? And I'm sorry, it'll be very brief. I just want to note the case law that I cited in my brief, it was Pulse and Washington. What I think is important to note is what's alluded in those cases is that there is a remedy, right? It's not that the state has to choose, do we pursue our appeal or have the defendant released? At face value, yes. But what they could have done, and what's sort of discussed and mentioned, referenced in those two cases, is they could have asked the Supreme Court to stay this defendant's release as part of their appeal. They could have brought it to their attention and said, by the way, if you take this appeal, we're going to be up on the 2-year release date. Can you also stay the release? That was procedurally an option that they had, and that's the guidance essentially that Pulse and Washington provide. They say, don't tell us for the first time on appeal that suddenly this is your problem. That's their problem. It's not the court's problem. So I think it's also important to recognize that they had that ability. It's not like their hands were totally tied. They just didn't do it, and that's on them.
All right. So that concludes our coverage for today. But just let me just go over a few things. So that was basically she's arguing that Paul's been in custody without bail for more than 180 days. But as Claire has been saying, and he's had private attorneys, and they left because of discovery. When they got into discovery, they noticed conflicts of interest, and then he had another team which we saw, which was the Michael Wick and Christopher Godin. I guess Godin may still come on board, but now this is Monica Mastelloni and Andy Murray, of course, tennis fans, and Andy Murray. So anytime a new team comes on, they take time. They take 6 months, 7 months, a year, whatever it is. So. But let me just go to, let's see. So just finally, before I let you guys go here, we'll come over here. Oops, hold on. Okay. So a New Jersey Supreme Court ruled Thursday, and this is from January 5th. This is, this is like right now. This is the 5th. Okay, wait. They ruled Thursday, so this must be maybe last week? That would have been New Year's Day. All right, anyway, I'm going to read this report. It's from newjersey.com. It's from January 5th. Oh, it was published December 4th, and it was updated. Okay, so this is published from December 4th. And Claire, you were talking about this, so I just wanted to read this. So New Jersey Supreme Court ruled Thursday, so back in December, prosecutors can use digital video recordings seized without a warrant as evidence. Remember, the house was on fire, and firefighters were in there, and law enforcement went in there, and they grabbed a DVR. And the defense, we saw that in one of the hearings, the defense was arguing, "Hey, wait a minute, you guys got that without a warrant." So the judge, I forget if I think the judge ruled. I think Judge Lemieux ruled for the defense, but then I guess it got appealed. Anyway, the Supreme Court ruled that they can use that digital video recording, the DVR. Oh yeah, here. So the decision reverses lower court rulings that found the warrantless seizure of the DVR from Caneiro's garage was not justified because the fire had already been extinguished in that part of the structure. So Judge Lemieux said no, that was unfair because that warrant didn't cover that, and then I guess the state appealed that, and the Supreme Court ruled that yes, that DVR is coming in. So prosecutors believe the DVR will show Caneiro's disconnecting the security camera system prior to setting his own home ablaze, an act they said was a ruse meant to destroy evidence and mislead homicide investigators. So interesting. All right. So there you go. So that's pretty critical. So that was back in December. All right, you guys. I think that's about it. Let's continue live stream till 2. Oh, Southern Belle. No. Yes. So nice to hear my voice, such as it is. Yeah, where does that, Claire, do you know, where does Colts Neck? I know there's a lot of farms out there. Bruce Springsteen is there. Queen Latifah is there. Jon Stewart lives out there. There's a lot of horses, farms. I'm obviously it comes from the horse community, but Colts Neck, that's just such a very interesting. Yeah, here's the map. All right, that's so Colts Neck. Yeah, the Colts Neck is right there, right above my picture. Colts Neck. Yeah, why Colts Neck? I mean, that's just such a bizarre. I don't know. It's just weird name. But anyway. All right, you guys. That's it for me. Thank you for joining. Really appreciate it. This was a full day for us. We started at 9. Here it is 7:30. So a good full day for us. Guess what? The next 3 days is going to be Corey. So Corey Richins has 2 hearings. 2 days of hearings, the 7th and the 8th, which is Wednesday and Thursday. So tomorrow we're going to put together all kinds of stuff. So tomorrow's going to be nothing but Corey. And then Wednesday and Thursday will be live with her hearings. But then don't forget, Davine Michaels has her sentencing is coming up on Thursday. So and Raul Valde, he's got a hearing tomorrow. So we're not quite sure what that's going to be about, but I'm not sure we'll cover that live. If it is, we'll do that after Corey. So we'll be prepared for that as well. So that's a great place there's a great place in Colts Neck called Delicious Orchards. K-Girl says, interesting. McCormick family, hello. Just want to say thanks for the stream. It gives me something to listen to while I get things done. Awesome. FYI, I love horses. I love horses too. My brother had horses when I was growing up. So I love horses. Led Zepp. Nope. That's a big nope. So anyway, so Corey Richins tomorrow. We're going to do like deep diving, get all kinds of stuff together for you guys. And then Wednesday and Thursday will be Corey. Davine Michaels is Thursday. Raul Valley's got a hearing tomorrow. So we'll also cover that as best as we can. So with that, thank you guys. Clairview, thank you for being in our chat. And I'm definitely looking forward to connecting with you and doing something, if not multiple things with you over the course of this trial. We'll definitely have to plan that. And with that, I always leave you with kitties. I only have one. I only have little Roger. He's hanging out with me here. Everybody else is probably waiting for another meal. I swear they eat like all the time. Yeah, I don't know where everybody else is. So anyway. All right. Thank you guys. Again, appreciate you guys joining us today. It was a full day, and appreciate you being with us. And Mods, great job, and Aaron, fantastic job with all the admin background info and graphics. Aaron's working on Corey Richins right now, even as we speak. So we will be going into the evening. We just won't be streaming. We're going to get our stuff together for you guys for Corey tomorrow. So. I know JMS, unfortunately, it looks like we're going to miss Corey's trial because we'll be covering Paul Caneiro's trial. But we're going to at least do a deep dive, and we're going to get as much as we can information on that for you guys. So, $1 million homes. Yeah, absolutely. Well, when you have Queen Latifah, Jon Stewart, and Bruce Springsteen all calling that area of the state home, it's rich. So, all right, you guys, thank you for joining us. Thank you, Mods. Thank you, Aaron. We will see you tomorrow for Corey Richins for the next 3 days. And we're not going to forget about Raul Valley too. We'll squeeze him in there somewhere. So with that, have a good night, and we will see you tomorrow.